Hi, good morning. I want to welcome everybody back to day 2, and it's now my pleasure to introduce you to the co-chair of today's program, Gurbir Grewal, who has been the director of the SEC's Division of Enforcement since July 2021. Immediately before joining the commission, Gurbir was the Attorney General for the state of New Jersey. Prior to that, he served as the Bergen County Prosecutor, the Chief Law Enforcement Officer for New Jersey's most populous county. Earlier in his career, he served as an assistant U.S. attorney for the District of New Jersey, where he was chief of the Economic Crimes Unit, and an assistant U.S. attorney for the Eastern District of New York, where he was assigned to the Business and Securities Fraud Unit. Since assuming the role of director, he has focused on enhancing investor protection and confidence in our markets by emphasizing proactive enforcement efforts and stressing the need to create a culture of compliance among market participants. It's my pleasure to turn the program over to Gurbir.
Thank you, Grace, and good morning, everyone, and welcome, whether you're here in person or participating virtually from around the country or even overseas. I thank you all for joining us. I'd like to start the day with a quick reminder to first the members of the media who might be here that if you have any follow-up questions on what's said by SEC staff during the conference, please direct your questions to the Office of Public Affairs, and they'll work with you to get you the information that you need. I also want to reiterate yesterday's reminder that the views expressed during the conference by me and the other speakers from the Commission will be in our official capacities and don't necessarily reflect the views of the Commission, the Commissioners, or any members of the staff. Hopefully you don't hear that again all day anyway, now that I've gotten it out of the way. But welcome to day 2. I have a little competition with Eric Girding. I think day 2 of any festival is better than day 1 of that festival, so if you could reflect that in your reviews, I just would like something more to lord over him. I want to also start by thanking PLI for organizing this event, and importantly for making it available for free to all this year. It's important for us to be able to speak directly to not just the securities bar, but also to everyone that's interested in our work. And that's precisely what we'd like to do today, that is, speak to each of you directly. In a few moments, my Enforcement Division colleagues will talk to you about the what of our work. In other words, those issues that are top of mind to us, whether that's explaining how we're thinking about penalties, disgorgement, and other remedies, highlighting enforcement initiatives, discussing legal developments, or outlining the many ways in which we're trying to encourage and reward cooperation. That type of dialogue benefits all of us. I think by hearing about issues significant to the enforcement program, you all are better able to counsel your clients. And together, we're better able to protect investors, which, after all, should be our shared mission. But before we get to the what, I want to talk to you about the why of our work. It goes without saying that we're facing significant headwinds in our enforcement efforts. There are some out there that question our authority, hoping for a different regulatory regime altogether for their industry. And there are others that question our motivations. And in rare cases, there are also those who question the integrity with which we approach our work. And I'd like to address each of these headwinds in turn, underscoring the importance of our work in the process. In the decade since we brought our first crypto enforcement actions, our approach has been consistent, it's been principled, and it's been tethered to the federal securities laws and legal precedent. After all, every lawyer here knows what the test is to determine whether a crypto asset was offered and sold as an investment contract, and therefore a security. It's the Howey test. It's not the essential ingredients test or the Beanie Babies test or some other test that industry folks might like to create for themselves. And for years, the SEC has clearly and it has consistently applied Howey and its progeny to protect investors in the crypto space. We've applied it to the alleged facts in dozens of orders, complaints, and briefs. These are not secret analyses. They are public documents for the whole world to see. And even those parties that argue in court that their conduct does not somehow implicate the federal securities laws have themselves used Howey internally for years to evaluate their crypto offerings. Of course, that does not mean that all crypto products are offered as investment contracts and therefore securities. But it does mean that the analytical framework, the test for whether something is an investment contract, is the same whether we're dealing with transactions involving crypto products or with transactions involving the many other kinds of offerings that courts have analyzed under Howey. Nevertheless, over this past decade, we have confronted significant noncompliance and many creative attempts by market participants to avoid our jurisdiction, with some claiming that we're making it up as we go, that we are regulating by enforcement, and others arguing that we are somehow recklessly exceeding our authorities. They've variously argued that their crypto products were currencies and therefore beyond our remit, that the term investment contract was unconstitutionally vague and could not be applied to crypto, that their offerings were, quote, utility tokens, not securities, that there was a lack of fair notice, that their conduct implicated the securities laws, that everything was decentralized, and because there were no entities or entrepreneurs involved, we lacked jurisdiction, that there needed to be an actual contract for there to be an investment contract under Howey, and more recently, that there was something called the major questions doctrine that prevented us from using our tools to protect investors in the crypto markets. And at the same time, we've been accused of picking winners and losers, stifling innovation, and driving crypto businesses to some more favorable foreign jurisdictions, wherever they may exist. Listen, a decade's worth of verbal gymnastics that are just a backhanded way of saying that we want a different set of rules than apply to everyone else. A decade's worth of arguments that have served nothing more than as a distraction from the very real issues and risks that the crypto markets present for the investing public. And most importantly, a decade's worth of arguments that have been serially rejected in one way or another by court after court. As we have consistently maintained and as court after court has confirmed, the federal securities laws apply equally to everyone. You don't get your own set of rules. Indeed, as one federal court recently stated, quote, the crypto nomenclature may be of a recent vintage, but the challenged transactions fall comfortably within the framework that courts have used to identify securities for nearly 80 years. The court went on to observe that, quote, using enforcement actions as we have to address crypto assets is simply the latest chapter in a long history of giving meaning to the securities laws through iterative application to new situations, close quote. These crypto enforcement actions, however, have not and are not without challenge to us. Given the stakes and the resources available to our adversaries, they've been among the most hard-fought that I've seen in my legal career. But I am so incredibly proud of the perseverance of our staff, who push forward for one reason alone, because investor protection demands it. Last year, the Pew Research Center released a survey finding that nearly a third of Americans who have ever invested in or traded or used crypto no longer held any. The same survey found that a whopping 3/4 of Americans who have heard about crypto don't believe it to be reliable or safe. Given the continued noncompliance in this space, they have good reason to be concerned. one need look no further than last week's sentencing of Samuel Bankman-Fried. Looking at that sentencing, we see very clearly the impacts of noncompliance. In advance of that sentencing, the victim statements that the Department of Justice filed, hundreds of them, reflected the incredibly broad cross-section of people who were harmed by the fraud that Bankman-Fried was convicted of. Single parents, retirees, young people, grandparents, people who were forced to sell their homes, their cars, or to take on second jobs to make up for their losses, people who had to figure out a way to pay for their mortgages, their education, their retirements, and so on. As another example, just last month, the SEC charged 17 individuals for their role in an alleged crypto Ponzi scheme that raised $300 million from, get this, more than 40,000 investors. And here's what's more. They were all primarily from the Latino community. Several defendants in that matter allegedly solicited investors with promises of financial freedom and risk-free crypto and foreign exchange investments. As alleged in our complaint, in true Ponzi fashion, most of the funds raised in that case were not used for any investments. They were instead used to fund the defendants' lifestyles and to pay supposed returns to other investors. Listen, the predatory inclusion tactics that certain crypto entities are directing at Black, brown, and other marginalized communities are extremely troubling. And here I'm talking about the familiar but so far unsupported narratives that crypto will somehow increase financial inclusion, that it will uplift the unbanked or the underbanked, and that it will help them build wealth and increase upward mobility. We've seen these unlawful tactics on full display in cases where the SEC has charged influencers for touting unregistered crypto offerings to investors. They've done so without disclosing that they were being compensated to do so. We've even charged one celebrity with making materially false and misleading tweets about supposed returns that his crypto investments earned, while not disclosing he was being paid hundreds of thousands of dollars for those very tweets. Whether it's the direct result of these types of efforts or for other reasons beyond the scope of these remarks, crypto assets are the only major financial products that Black Americans are more likely to own than white Americans. And there's some evidence that Black and brown investors were disproportionately harmed during the downturn of crypto markets over the last few years. In the end, the stories of the victims in all of these cases are absolutely devastating, and they are our why. But somehow, those stories are constantly drowned out by tired industry talking points about us exceeding our authorities or destroying innovation. But regardless of the headwinds, we remain committed to using all the tools at our disposal to protect the investing public, including against risks in the crypto markets. And listen, it's my hope that after the latest in that long and growing string of courts affirming our authority to police the crypto markets, that we can somehow finally move past those arguments and address the very real issues present in this industry that lead to elevated investor risk, the fraud, the lack of transparency, the commingling of assets, the conflicts of interest, and the lack of oversight. I want to end by addressing a particular headwind that we face from certain market participants. And that's those attacks on our integrity that I mentioned at the outset. I'm now coming up on 3 years in this role. And like so many of my colleagues, I've spent the majority of my career in public service. During that time, I've had the privilege of working alongside thousands upon thousands of dedicated public servants at the local, state, and federal levels. And here's what I've learned. We don't do this work to round corners and notch wins, nor do we do it for financial incentives or for personal gain. The overwhelming majority of us do it for one reason alone. We believe in standing up for others. And in the case of the men and women of the Enforcement Division, that means standing up each and every day for the investing public. That's why, as we speak, there are investigative teams across our division pouring through voluminous records to, for example, seek emergency relief to stop ongoing frauds. And it's why there's a trial team in New York walking into district court as we speak to present evidence to a jury concerning a massive alleged crypto fraud, all in an effort to hold accountable the individual and the entity responsible for alleged widespread investor harm. And it's why in just a few hours, a trial team in California will walk into district court to hold accountable an insider that allegedly benefited from his position in a way that the rest of us cannot, by engaging in, as we allege, insider trading. Our ability to do all this work, however, hinges and depends on trust and credibility. And I've spoken about this previously. The public must have confidence that we will hold bad actors accountable. We will hold them accountable when they violate the securities laws, regardless of who they are and how powerful they are. And the public, the courts, and each of you in this room and members of the bar must all have confidence in the representations we make when we are advocating to protect investors. We cannot and will not let our zeal to address misconduct compromise that reservoir of trust and credibility that we have and other public servants have contributed to, that they've spent their careers building and protecting. After all, it's that reservoir that allows us to do so much of the good that we're trying to accomplish. And that also means if we fall short, we must first acknowledge our mistakes, as we recently have. And then we must recommit ourselves to doing everything we can to never compromise that reservoir, as we also recently have. But here's what we won't do. We won't let any of that criticism that we may face overshadow all of the incredible work being done by the Enforcement Division on a daily basis on behalf of the investing public. And instead, what we will do moving forward is embrace any scrutiny and any criticism that we may face and use it instead to highlight all the good that we are doing on a daily basis. And that's my commitment to the public, that's my commitment to the members of the bar, and that's my commitment to the courts we appear in front of. With that, it's my privilege to turn it over to Sanjay Wadhwa, the Deputy Director of our Enforcement Division, for some brief remarks and to introduce the panel, which will discuss all that good that we're doing that I just spoke of a moment ago. I thank you for attending again, and I look forward to speaking with you throughout the day. Thank you.
Thank you, Gurbir. I'd like to begin with the disclaimer that my remarks today are, actually, I don't need to do that, do I? Because you did it for everyone. All right, what I would like to do is echo Gurbir by thanking PLI for providing free access to the online stream of this program. It's important that those who are interested in the work of this agency have an opportunity to hear directly from us, the staff of the agency. In the spirit of addressing a wider audience, we have deliberately tried to include practical tips and best practices in this panel discussion and in the enforcement workshop that is scheduled for later this afternoon. Before I introduce this panel, I want to highlight some of the division's work during the last fiscal year. In fiscal 23, the Commission filed 784 total enforcement actions. These included 501 original or standalone enforcement actions, representing an 8% increase over the prior fiscal year. In addition, we filed 162 follow-on APs seeking to bar or suspend individuals from certain functions in the securities markets based on criminal convictions, civil injunctions, or other orders. And we filed 121 actions against issuers who were allegedly delinquent in making required SEC filings. In fiscal 23, the Commission obtained orders for just under $5 billion in financial remedies, the second highest amount in SEC history after the record-setting financial remedies ordered in fiscal 22. The financial remedies ordered in fiscal year 23 comprised nearly $3.4 billion in disgorgement and prejudgment interest and nearly $1.6 billion in civil penalties. In addition, the Commission obtained orders barring 133 individuals from serving as officers and directors of public companies, the highest number of officer and director bars obtained in a decade. Fiscal 23 was also a record-breaking year for our whistleblower program. The SEC issued whistleblower awards totaling nearly $600 million, the most ever awarded in one year, including a record-breaking $279 million awarded to one whistleblower. And reflecting the continued success of the whistleblower program, we received more than 18,000 whistleblower tips in fiscal 23, the most ever in any fiscal year, and roughly 50% more than the record that had been set in the prior fiscal year. Finally, we distributed $930 million to harmed investors last fiscal year, marking the second consecutive year where we've distributed in excess of $900 million in distributions. Of course, these numbers don't tell the full story of the work that we've been doing, the work we did last year, the work that we continue to do today. I don't think I could cover that in the time that's been allotted to this panel. Suffice it to say, the enforcement staff is as dedicated and as productive as it has ever been. I do want to briefly address two ongoing enforcement initiatives that have received a fair amount of attention: the record-keeping initiative and the amended marketing rule initiative. Specifically, I want to discuss our approach to penalties in these matters. Since December 2021, the Commission has charged nearly 60 firms, including investment advisors, broker-dealers, credit ratings agencies, with record-keeping violations, resulting in combined penalties of just over $1.7 billion. This initiative has received a great deal of attention, much of it focused on penalties, which were as high as $125 million for some of the firms, while on the lower end of the spectrum, one firm paid a $2.5 million penalty. Now, perhaps as a result of that wide range in penalties, there's been a critique from the defense bar that we're picking numbers at random, that our penalties are not informed by individualized determinations. Well, I'm here to disabuse you of that perception. Stated simply, we do make an individualized assessment of each firm. I'll share some of the factors we focus on. We consider the size of the firm to ensure that the penalties are adequate to serve as a deterrent against future violations. After all, a penalty that may be adequate for one firm may not be adequate for another. And by size, what I mean is we look at the firm's revenues from the regulated parts of its business. We look at the number of registered professionals at the firm. We consider the scope of the violations. How many individuals communicated using off-channel means? How many off-channel communications were there? But since we're generally dealing with samples and not the total numbers, there is not a strict correlation between these numbers and the penalty. Consideration of other factors can also result in a relatively larger or smaller recommended penalty. For example, we take into consideration a firm's efforts to comply with its record-keeping obligations and to prevent off-channel communications, focusing, for example, on timely adoption of meaningful technological or other solutions. We consider precedent. The SEC has now issued 40 settled orders in these matters since December of 2021. These precedents are a guide, but they're not determinative. They are part of an individualized determination, not a substitute for it. We also consider whether a firm self-reported. Now, this is, in my mind, and in fact, the most significant factor in terms of moving the needle on penalties. From our prior actions, you can see how much we have credited those firms which have chosen to self-report, including the firm that was assessed the $2.5 million penalty I mentioned. Finally, we consider cooperation. Firms that do not self-report can still receive credit based on their cooperation with enforcement staff during our investigation. We'll address later on this panel what cooperation looks like. Those are some of the factors we consider when assessing what penalty to recommend in each action in this initiative. While none of these factors is dispositive, I want to reiterate that self-reporting is the factor most likely to significantly lower the penalty we recommend to the Commission. Next, I want to briefly talk about our amended marketing rule initiative, which has resulted in penalties ranging from a high of $175,000 to a low of $50,000. This initiative, too, has made a big impact on the industry. We hear about that. This is exactly what we had intended, as the amended rule contains important investor protection measures that we want to ensure firms comply with. Here, too, we conduct an individualized assessment of each firm when determining what penalty to recommend. The factors we look at include a firm's reported regulatory assets under management, the nature of the regulatory history of the firm, including the nature of any prior enforcement actions, whether the firm promptly remediated the non-compliant marketing materials, the need to send strong messages of accountability and deterrence, and as with the record-keeping cases, and frankly for all our cases, we consider whether a firm self-reported and cooperated with our investigation. So I hope the factors I've laid out are helpful in shaping your response in the event your client is confronted with some of these issues. In fact, those factors are almost certainly going to be relevant in any SEC investigation you may be helping your client navigate. I'll turn now to my colleagues here for their presentations, which will include recent judicial developments in our space and helpful practice tips. And for the panel, I'm joined by Stacy Bogert, going from my left on down. Stacy Bogert, Associate Director in the Home Office, who will discuss individual accountability and remedies, as well as tips on effective advocacy during the Wells process. Ryan Wolf, our Enforcement Chief Accountant, who will focus his remarks on gatekeepers. Charlotte Buford, our Deputy Chief Counsel, who will present on corporate remedies. Sam Walden, our Chief Counsel, who will address cooperation. Nicole Cree-Kelly, Chief of our Office of the Whistleblower, who will address various aspects of our whistleblower program. And Olivia Shett, our Chief Litigation Counsel, who will discuss recent judicial developments that impact our investigative authorities as well as our authority to pursue disgorgement. Finally, time permitting, Sam and Charlotte will also touch on developments in the crypto asset space. Please consider the comments of these panelists. Stacy?
Thank you, Sanjay. So holding individuals accountable for their misconduct is a pillar of our enforcement program and continues to be an area of focus for us. In fiscal year 2023, approximately 2/3 of the SEC's cases involved charges against one or more individuals. So whether settled or in litigation, we are committed to pursuing charges against individuals. And as Gurbir just mentioned, we currently have 2 trials taking place involving charges against individuals, one in New York and one in the Northern District of California. We're also very conscious of the remedies that we seek and the impact on deterring violations from happening. And this is particularly important when we're dealing with recidivists. And this can include, of course, financial remedies. So as Olivia will address in more detail, we continue to seek disgorgement of illicit profits and also robust civil penalties. But I want to highlight SOX 304 clawbacks are also an area of focus for us. For those of you unfamiliar with SOX 304, the Commission can seek a clawback of executive compensation in certain circumstances where an issuer was required to prepare an accounting restatement. And the clawback applies to a CEO or CFO, and it can cover bonus, incentive-based, or equity-based compensation, or profits from the sale of securities for the 12-month period following the restated filing. And our approach to SOX 304 is guided by the policy underlying the statute. It's to incentivize CEOs and CFOs to implement robust internal controls designed to detect and prevent misconduct in financial reporting and to encourage an appropriate tone at the top of a culture of compliance. So importantly, with that in mind, SOX 304 reimbursement is not limited to what is sometimes referred to as the fraud delta, and you'll see that in our cases. The fraud delta being the amount in which a CEO or CFO's compensation or profits were inflated by the misconduct at issue. The SEC is frequently seeking reimbursement of the full amount of compensation or profits and does not limit reimbursement requirement to the fraud delta. And additionally, SOX 304 applies regardless of whether the CEO or CFO engage in the misconduct that caused the need for restatement. And consistent with that view, we have brought SOX 304 charges against CEOs and CFOs who were not themselves involved in the misconduct. In addition to financial remedies, we are also seeking strong prophylactic relief in the form of injunctions and bars. And in many cases, the non-monetary relief we seek can be the most important part of the remedies against individuals because of the protection it affords from future violations. And so this can include conduct-based injunctions, in addition to obey the law injunctions. We've been seeking injunctions tailored to the misconduct at issue, such as injunctions from participating in the offer or sale of securities, the offer or sale of crypto asset securities, or from participating in certain multi-level marketing programs or the like. We also, as many of you are familiar, for individuals associated with a regulated entity, barring or suspending an individual from association can be a critical component of a case, given both the prophylactic purpose and the need to protect the integrity of our markets. I'd also want to point out in fiscal year 2023, the SEC obtained 133 orders barring individuals from serving as officer or director of a public company, which was the highest number in a decade. And we have frequently sought O&D bars against individuals who've engaged in scienter-based violations in violation of the Securities Act or the Exchange Act. Some examples from 2023 include a case we brought against the former CEO of McDonald's, who was barred from serving as an officer or director for 5 years to settle fraud charges for making false and misleading statements about the circumstances leading to his termination from McDonald's, as well as a case from May of 2023 where a former Wells Fargo executive settled fraud charges that she misled investors about the success of Wells Fargo's core business, and as part of that settlement agreed to a permanent bar from serving as an officer or director of a public company. Now, in some circumstances, we've also sought O&D bars pursuant to a court's inherent equitable authority for individuals who engaged in negligence-based fraud or violations of 17A2 or 3. And that includes both settled charges, such as the recent case against the former chairman and CEO of Lordstown Motors Corp., which was filed a few weeks ago, or we filed litigated cases where we're seeking such bars. And in fact, recently in February, a court in the Northern District of California denied a defendant's motion to dismiss the O&D bar we had sought for negligence-based charges. The court there, citing to Ninth Circuit precedent, held that it has broad equitable powers to impose an officer-director bar, and that the defendant had failed to point to any authority supporting the claim that an O&D bar requires scienter. So O&D bars continue to be a key part of the relief we seek. Finally, 102E orders are something that are often part of our remedies involving individuals. The rule most commonly applies to attorneys and accountants who practice before the commission. It was actually first adopted almost 90 years ago, and I'm sure it was a hot topic for the Wednesday morning panel of 1936 SEC Speaks. But the reason why it's been such a longstanding concern is, as gatekeepers, it is important that the attorneys and accountants who practice before the commission are fulfilling their own professional responsibilities, and they're not giving cover to corporations or others engaged in misconduct. And so, notwithstanding recent challenges to our AP process, we've continued to seek 102 orders in both a litigated and settled context. And as Ryan will discuss, our commitment in this area, even in the face of these challenges, reflects how important we view the gatekeeper role.
Thanks, Stacy. So, just as an initial matter, we're certainly aware of what's going on in the courts, what's going on in the Jarkissi case, and the potential effect that could have on our ability to hold gatekeepers accountable. I'm pretty sure I am the only person on this panel who didn't actually go to law school. But I do have the joy of getting to read the federal securities laws quite a bit. And every time I do, I always come away with two thoughts. And the first one is that accountants and other gatekeepers are absolutely fundamental to the integrity of our capital markets. And the second thought is our ability to enforce rules and professional standards against those gatekeepers is a critical feature of that system. Uncertainty in the courts does not mean that we're going to retreat from holding gatekeepers accountable. Professionals who appear and practice before the Commission aren't just anyone. They're critical participants in our capital markets, and they've chosen to take on professional responsibilities, so investors have reasonable expectations that they'll live up to those professional responsibilities. That means our commitment to holding market participants accountable for financial reporting and disclosures will endure. This commitment's borne out by our body of work. Hopefully many of you will attend the workshop later this afternoon and hear from our colleagues to talk about specific cases. I want to spend a little bit of time talking about the gatekeepers more generally, and I want to talk about three specific types of critical participants in the financial reporting and disclosure process. And the first is the preparers. This is the CFOs, the controllers, the accounting policy folks, and others who are responsible for preparing the financial statements and the other disclosures that are communicated out to investors. Accurate, relevant, and timely information is the entry price to our capital markets. Where there are failures in this area, we will continue to act. The second set of critical gatekeepers I want to talk about are the auditors and the assurance providers. These aren't just gatekeepers for public companies, but these are gatekeepers for broker-dealers, investment companies, municipalities, and credible financial reporting depends on audit professionals meeting the professional standards that they take on. And I think our activity, despite the challenges over the past year, really speaks to our continued focus in this area. We are litigating administrative proceedings against engagement partners at firms of all sizes. We continue to obtain meaningful settlements with both individual auditors and firms. We continue to use proactive measures to uncover fundamental problems, things like failing to obtain an engagement quality review. We're also obtaining meaningful settlements against national firms, such as the settlement against Markham related to deficient audits and pervasive quality control failures. I'm going to be speaking more in depth at the accounting panel this afternoon on the importance of auditor independence, but I also want to mention the Prager Metis matter, which is currently litigating in district court, where the Commission alleged independence failures not only at public companies, but at broker-dealers and investment funds. The last category of critical market participants I want to talk about are those who are charged with corporate governance, so your boards of directors and your audit committees. It's really hard to overstate how important those roles are on behalf of protecting investors. They're absolutely integral to creating an environment that protects investors and preserves confidence in our capital markets. And this is the enforcement panel, so we do see a lot of poor compliance in this area, and it often leaves us asking, where was the audit committee here? But I don't want to focus solely on the negative, because we also see the positive impact that skilled and diligent audit committees can have on the overall organization. And what does that look like? That looks like boards and audit committees that hold management accountable for the quality of the financial reporting and their control system. It also looks like boards who address and respond to problems as they arise, and very importantly, those who protect those who report those problems from retaliation. And the last thing I would say about effective boards is that they support the independent auditor and they hold the independent auditor accountable for quality. And I know that there are probably many in this room who aren't serving in these gatekeeping roles directly, but we see you too. You play a really important role and you can impact investors and protect them as well. So in that sense, we're all counting on you because we are all in this together. And the last thing I will say is it's not just about the gatekeepers, it's about the gates. It's about the systems, it's about the internal accounting controls, the internal control of our financial reporting process, about the disclosure controls and procedures. These systems serve investors. They serve investors by preventing and detecting misstatements before they make their way to the market. And at the risk of encouraging you all to take an extra long lunch, I'm going to talk more about those gates at the accounting panel this afternoon. But it's going to continue to be a focus. And so now I'm going to turn it over to Charlotte to talk about the ways that we enforce compliance in this and other areas and how we craft tailored remedies to fix problems. Charlotte.
Thanks, Ryan. So individual accountability and ensuring responsible gatekeeper behavior are absolutely critical to investor protection and maintaining fair and orderly markets. But what you'll see from our cases is that it's equally important for entities to behave in a manner that fosters a culture of compliance and protects the interest of shareholders. In our actions against entities, we're seeking to maximize protection to investors and the market by looking back at the bad behavior and recommending sanctions that appropriately hold entities to account for their wrongdoing, but also looking forward to a better future. And we are, by gearing our remedies to deterring future misconduct and providing roadmaps that entities can follow to ensure compliant behavior going forward. So what are we doing? As Sanjay mentioned, there are still traditional remedies, financial remedies that play an important part in this. We're continuing to recommend penalties that are calibrated to be meaningful and adequate to effectively provide deterrence. As you've heard Gurbir and Sanjay and others mention in the past, we want to get away from the idea that penalties are just the cost of doing business. We are continuing to distribute disgorgement and penalties to investors whenever it's feasible to do so. But as Stacy mentioned in her remarks, non-financial relief can be the most effective in providing relief to investors. So additionally, because our focus is on protecting investors going forward, our enforcement actions often include remedies that are specifically crafted to correct institutional or corporate failures. These remedies may include requirements to take affirmative steps to establish policies and procedures designed to prevent the failure from recurring. One example is our Citadel Reg Show case, where there were undertakings that included a written certification that the coding error that led to the Reg Show violation had been remediated, and a review of the firm's computer programming and coding logic that was involved in processing the relevant transactions. When needed, we may require independent consultants to evaluate the company's policies and procedures and help the company develop systems to correct the behavior going forward. Example, in our settlements with DBRS and Kroll Bond Rating Agency, each firm was required to retain an independent compliance consultant to, among other things, do a comprehensive review of its policies and procedures relating to the retention of electronic communications. If an entity proactively took remedial measures to help prevent future misconduct, we will include that in our order as a helpful roadmap for other entities in the space. One example is GTT Communications, where our order noted the steps that the company took, including attempting to rebuild its cost of revenue accounts, replacing members of management, its board of directors, its auditor, and overhauling its accounting functions, including its policies and procedures relating to cost of revenue. And where there is a particular need for this type of accountability, we may require specific admissions, as in the case of Goldman Sachs' Blue Sheet data matter. We have seen that these types of remedies encourage better corporate behavior, and for those who have already committed wrongdoing, the remedies encourage self-reports, remedial acts, or other cooperative behavior. Of course, the question is always, if I do these things, what do I get for my efforts? What credit do I get? For the answer to that, I'm going to turn it over to Sam.
Thanks, Charlotte. There's been a real effort over the last couple of years to encourage and reward cooperation, meaningful cooperation. There have been a number of cases last year or so that demonstrate the benefits of cooperation, and I'll highlight some of those. But first, a few words about cooperation generally, and a little bit about how the Commission thinks about cooperation. So first, there are two types of cooperation in our world. There's informal cooperation, which is available to anyone who's involved in an investigation. All you have to do is cooperate. And at the end of the investigation, staff and the commission will evaluate the quality of the cooperation when determining the remedies. But then there's also formal cooperations, which is through our cooperation program. To participate in that program, you have to go through a formal approval process with our cooperation committee. And at the end of that process, typically there will be an agreement, a cooperation agreement, a deferred prosecution agreement, and a non-prosecution agreement entered into between the cooperator and staff, and that agreement will set out the parameters of the cooperation. Second, with cooperation, I think timing is critical. If you're thinking about cooperating, you want to be thinking about it right out of the gate. If you want to maximize your cooperation credit, you really want to cooperate throughout the investigation from start to finish. That's not to say that you can't get cooperation credit if you don't cooperate at the outset and then cooperate later. Some cooperation is always better than none, but it's going to look a lot different, and the credit you'll get will be significantly reduced. The same is true with the formal cooperation program. It's better to be thinking about that early on if you want to become part of the program. The longer you wait, the greater the chances are that other cooperators will come forward, a whistleblower might come forward, and the need for additional cooperation might be diminished. Third, what is cooperation? This might be the most important question. So some examples of cooperation: providing us with documents that we arguably can't compel, conducting an internal investigation and providing us with the results of it, waiving privileges and producing otherwise potentially privileged documents that help us develop the record more fully, translating documents when necessary, providing helpful financial analyses or compilations of key documents. What is not cooperation? Complying with subpoenas, document requests, providing truthful testimony. All of those things are appreciated and expected, but the Commission does not consider them for purposes of granting cooperation credit. Finally, how does the Commission evaluate cooperation and credit? There's no fixed formula. For individuals, the Commission looks at a number of different factors: the value of the cooperation, the significance of the underlying matter, the potential need to hold the cooperator accountable, the profile of the cooperator. In particular, is the cooperator a recidivist? For corporate entities, the Commission relies on what are called the Seaboard factors and the framework that is laid out in the Seaboard 21A report from about 20 years ago. Those factors are self-reporting, self-policing, cooperation, and remediation. So I mentioned there have been a number of cases recently where it is clear the benefits of cooperation, and I'll highlight a few of them. First, there have been a number of cases where the Commission has not imposed a penalty based at least in part on cooperation. A few examples: the Klupin matter, and in that case, Klupin summarized interviews of witnesses and translated key documents from Mandarin. And then also the View Inc. matter, and there View provided the staff with a detailed financial analysis, summaries of factual issues, and proactively identified key documents for the staff. A few other examples of cases where the Commission did not impose a penalty based at least in part on cooperation: the GTT Communications matter that Charlotte mentioned, Stanley Black & Decker, McDonald's, and Kronos Group. If you look at the underlying facts of all of those cases, you would typically expect the Commission to have imposed significant penalties, and in all those cases, there are no penalty settlements. Similarly, there have been several cases over the last few years where the Commission has imposed reduced penalties based, at least in part, on cooperation. A few examples there, the Surgalign matter. In that case, Surgalign conducted an internal investigation and provided staff with the results of that investigation. And the VoxelJet matter. There, the company shared facts uncovered in its internal investigation again and facilitated interviews with key witnesses. And that's it for cooperation. Another somewhat different way that you can end up interacting with staff is through the Wells process, and I'll send it back to Stacy for that.
Thanks, Sam. I suspect we could probably take the full hour to get the views of everyone on the panel about what makes an effective Wells process, and then probably another 3 or 4 hours hearing from everyone in the audience of what they like and don't like about our Wells process. But before I discuss what's most effective, I do want to comment on the Wells process overall. As an associate director overseeing a group of investigative attorneys, I can say the Wells process is very helpful. The investigative attorneys and enforcement are smart, and they want to get it right. And we put a great deal of thought into a case before we issue a Wells notice. When we do issue a Wells notice, we read the submissions carefully, and we consider the arguments that are raised to us. And this is also true of our front office. So like the investigative teams, Gurbir and Sanjay are reviewing the Wells submissions in every case, and they take the arguments raised very seriously. All of this is to say the Wells process really can impact the charges we ultimately decide to bring, including whether to recommend a case at all. But with that in mind, I do have a few comments on the process. First, and this sort of complements what Sam was saying, I think a productive Wells process begins long before a Wells notice is issued. As defense counsel, your credibility is everything, and establishing credibility from the beginning of an investigation, whether through cooperation or otherwise, I think that's critical at the Wells stage. Sam has discussed what cooperation looks like. I can talk about the flip side of that, how to destroy your credibility. There's conduct we routinely see from lawyers that you want to avoid because it impacts your credibility. I think some colleagues have referred to it in public statements as lawyers behaving badly. But examples of this can include unreasonable delays in document production, spurious privilege claims, witness coaching during testimony, ignoring conflicts of interest, attacks on the staff. So all of these tactics are beyond mere advocacy. They undermine your credibility, which in turn threatens your credibility during the Wells process. The second point I would make for an effective Wells process is be focused. Acknowledge where we have stronger positions or arguments, focus your submission or meeting on the issues in dispute and what really matters to your client. It'll be a much more productive discussion than trying to talk about every single issue in the case. And then lastly, I would say there are arguments that go to the heart of the case that actually may be appropriate to raise before you get to the Wells stage. So initiating a discussion of a key legal issue or clarifying key factual issues in an early stage often can be helpful if done thoughtfully. So with that, I do want to hand it over to Cree to talk about whistleblower program.
Thanks, Stacy. Good morning, everyone. The whistleblower program is a crucial part of the Commission's overall mission to protect the U.S. financial markets. We're better able to protect investors when whistleblowers come to us with information about potential misconduct. When folks learn of potential misconduct, it's critical that they have an avenue to report that information to the Commission. For whistleblowers to come forward, they need to understand a couple things. First, they are legally permitted to come directly to the Commission. Rule 21F17 prohibits the taking of an action to impede communication with the SEC. Second, they need to understand that they will not face retaliation for for reporting to the Commission. For this, we have an anti-retaliation provision in Dodd-Frank, which allows the SEC to charge and hold accountable companies that retaliate against whistleblowers. Finally, it's important for them to understand that we have a bounty program. So whistleblowers who voluntarily come forward with original information about potential securities law violations can potentially receive an award of between 10 and 30% of the monetary sanctions collected in the underlying enforcement action. So next, I want to highlight some of our recent retaliation and impeding cases, starting with the Gaia matter. which included both retaliation and impeding charges. The Commission found that Gaia retaliated against a whistleblower by terminating them for cause after they reported their concerns internally to Gaia management and to the Commission. Gaia also included provisions in several severance agreements that required employees to forgo any monetary recovery in connection with providing information to the Commission. Also, the Commission recently settled a 21F17 case against JP Morgan Securities. And this was one of 4 standalone 21F17 cases the Commission has brought in the last year. JPMS was charged with impeding hundreds of advisory clients and brokerage customers who had entered settlements with the firm and from reporting potential securities law violations to the Commission. The agreements required clients to keep the settlement itself confidential and the underlying facts. While the agreements permitted clients to respond to SEC inquiries, they did not permit clients to voluntarily contact the SEC. They agreed to pay an $18 million penalty, which was the largest penalty for a standalone 21-17 case. Finally, I'd like to highlight the D.E. Shaw settlement. The firm required new employees to sign agreements that prohibited them from disclosing confidential information to anyone outside the company unless authorized by the firm or required by law or court order. The firm also required hundreds of departing employees to sign releases affirming that they had not filed any complaints with any government agency. Although D.E. Shaw had circulated a firm-wide email notifying employees that they were not prohibited from communicating with regulators, the firm did not include the same whistleblower protection language in their employment agreements. And I think it's important to note at this point that the Commission brought its first 21F17 cases in 2016. We saw agreements requiring employees to waive their right to financial recovery or to seek company approval before talking to the Commission. And fast forward 8 years, and we're seeing the same violative language in agreements. So I'd like to discuss some best practices. And first, I want to highlight whistleblowers come in different forms. They can be current or former employees, contractors, partners, investors, anyone who is in the know. And so, one thing that we get a lot of questions about is, confidentiality agreements. The Commission understands that companies need to protect confidential information. We get that. Confidentiality provisions are entirely permissible, provided that the company makes it clear that the provisions do not apply to communications with the SEC. To the extent that employment agreements, handbooks, contracts, severance agreements, releases, et cetera, place limits on a person's ability to communicate about the company, include a clear and consistent carve-out for communications with regulatory agencies, including the Commission. Make sure that any such carve-out is not followed by confusing language that calls into question the applicability of the carve-out. Further, documents need to be consistent on the right to communicate with the Commission, both internally within the document itself and in relation to other company documents. Update template documents so that all of them consistently provide for a carve-out. Avoid situations where one document has a carve-out but another document doesn't, creating ambiguity for the individual and having a chilling effect in general on whistleblowing. Further, do not require individuals to forego monetary recovery in connection with their whistleblowing activity. That's why the program was started, to create a financial incentive for folks to come forward. Don't require folks to notify the company if the SEC reaches out, or to notify the company if they initiate communication with the SEC on their own, or to attest that they haven't previously reported to the Commission. Prospective and retrospective notification requirements are equally problematic. Finally, set the tone at the top and make clear to every employee, contractor, investor, partner that the company supports whistleblowers. Our whole financial system works better when wrongdoing is identified and addressed. making sure that whistleblowers know that they can come to the SEC without fear of reprisal is a huge part of keeping the market safe for everyone. And so at the top, Sanjay talked about the large numbers of whistleblower awards that the Commission granted last year, and those awards are based on the monetary sanctions that are collected in enforcement actions. So I want to turn it to Olivia to talk specifically about how the division is thinking about disgorgement post-Liu and post-Goebel.
Thanks, Cree. Disgorgement is one of the remedies, as some of my fellow panelists have mentioned. You know, it's in our enforcement toolkit, and the division is continuing to employ disgorgement aggressively. And what we've seen from the courts over the last year or so that I want to just speak about very briefly, by and large, really confirms the Commission's authority to seek disgorgement of ill-gotten gains from securities law violators. So for those in the audience who want to earn your CLE credit and you need a 30-second refresher on Liu and the NDAA, in 2020, as you'll recall, the Supreme Court decided in Liu v. SEC that disgorgement is a remedy available in Commission actions, and that it's an equitable remedy, and as an equitable remedy, it's subject to certain limitations. And among other things, the court ruled that disgorgement should generally be awarded for victims. Close on the heels of Liu, Congress passed in the National Defense Authorization Act, or the NDAA, in 2021, some amendments to Section 21D of the Exchange Act. D5 already existed, and it provided that the Commission could obtain equitable relief for the benefit of investors. But in 2021, Congress added D3 and D7. Don't ask me about the numbering or the sequencing, but those provisions provide express statutory authority for courts to award disgorgement. And unlike D5, those provisions are not limited to awards that are for the benefit of investors. So with that background, I want to touch on some recent decisions and some somewhat different approaches we've seen in the courts. From the Fifth Circuit, we've seen in the SEC v. Hallam decision an approach that interprets that new provision, D7, as providing for what the court called legal disgorgement, which it did distinguish from equitable disgorgement. In the Second Circuit, on the other hand, in the SEC v. Ahmed decision, what we saw from that Court of Appeals was the court interpreting Section 21D7 as providing for equitable disgorgement, so, you know, expressly declining to adopt the Fifth Circuit's approach. So the courts have drawn this distinction, and they discuss it at some length between so-called legal and equitable disgorgement. But I think the practical upshot that is really important coming out of these decisions is that both of them really confirm some very important things and basic principles about the Commission's disgorgement authority. Both courts have, and courts under them have confirmed that the SEC's burden in seeking disgorgement is simply to provide a reasonable approximation of the defendant's ill-gotten gains that are attributable to the defendant's violation. That was the standard that existed in the courts in the years before Liu. And at that point, the burden then really falls on the defendant to rebut that showing. So both courts have, you know, expressly confirmed that. And in Ahmed, the Second Circuit really underscored that disgorgement is about the defendant's ill-gotten gains. And it's about making sure that what the court called law-breaking is unprofitable for the lawbreaker. And in Ahmed, actually importantly, the Second Circuit held that disgorgement of those ill-gotten profits is appropriate even if the victim of the fraud obtained a benefit in the bargain, or a bargain in the transaction. Ahmed, of course, has to be squared with the Second Circuit's more recent decision in SEC v. Goebel. And in that case, the Second Circuit held that at the remedial phase of the litigation, it's an abuse of discretion for a district court to award disgorgement without finding pecuniary harm to a victim. The Commission disagreed with that ruling and did file a petition for rehearing, which the Second Circuit denied. But setting aside that disagreement, it is worth noting, I think, that Goebel, like Hallam and like Ahmed, confirms like very basic important things about the Commission's disgorgement authority. And I think importantly, Goebel recognizes that how to quantify those ill-gotten gains is a different issue from whether an investor has suffered pecuniary harm. Govil expressly notes that disgorgement is not about compensating victims, but about preventing wrongdoers from unjustly enriching themselves, and that the point of disgorgement is to divest a wrongdoer's profits. And what this means, practically speaking, is that while a district court must find pecuniary harm to a victim in imposing disgorgement under Govil in the Second Circuit, the amount of disgorgement is measured by the amount of those ill-gotten gains, and that might be less or more than a victim's losses. And so it's early days post-Govil, but in the months since that decision came out, what we've seen from the courts is that defendants have not been successful in trying to avoid disgorgement by citing to Govil. Courts have rejected efforts by defendants to try to inject Govil, which is about the remedies phase, into earlier stages of the litigation, like discovery. And in the Second Circuit, district courts have awarded disgorgement and concluded that Govil is satisfied where the commission makes a showing, for example, in a market manipulation case, that stock prices were inflated during the relevant period. So I think it's unclear what impact, if any, Govil will have outside the Second Circuit, but thus far within the Second Circuit, what we have seen has not been courts hampering the commission's ability to obtain disgorgement. I want to just briefly touch on another area where we've seen the courts really confirm the commission's broad authority, and that is in a couple of subpoena enforcement actions in the last year or so. The first involved the commission's subpoena to Covington and Burling, seeking, among other things, the names of clients affected by a cyber attack. Covington responded by arguing that that information was attorney-client privileged and that the subpoena exceeded the commission's investigative authority. And in granting in part the SEC's request to enforce the subpoena, the district court pretty resoundingly rejected both arguments. The court was unpersuaded by the privilege arguments, and with respect to the commission's authority and the Fourth Amendment argument, the court expressly confirmed that our authority to investigate, it's not limitless, but it is very broad, and affirmed the very deferential standard that courts apply to our subpoenas. And we've seen, very similar principles enunciated thus far in the commission's ongoing subpoena enforcement litigation against Elon Musk. That subpoena is a fairly standard subpoena for testimony in an ongoing investigation. And in an initial ruling, the magistrate judge has again really confirmed that our investigative authority is expansive as long as the information sought is minimally relevant to the investigation. And I'll just close by noting that, interestingly, the magistrate judge has also rejected an argument that the subpoena exceeds the constitutional authority of the commission because it was issued by a commission staff member rather than a constitutionally appointed officer. The ruling is being appealed by Mr. Musk, but what we have seen thus far is that arguments about the constitutional authority of the staff have not really gained any traction in the courts. So I think we have only a couple minutes left, and I may just turn it back to Sam to briefly touch on another area where we've had success, and that is taking it back to crypto.
Crypto in 1 minute. Fortunately, Gurbir, I think, covered a lot of it in his remarks. What I would say with only a minute is highly recommend that you read Judge Fela's opinion from last week in the Coinbase matter, where she denied in large part Coinbase's motion to dismiss. It is a really thoughtful, carefully crafted opinion that puts everything together in a way I haven't seen anywhere else. And I think if you want to know where the current state of the law is as to crypto, there's probably no better place to look. The one thing I will mention in particular from that case, Gurbir mentioned the major questions doctrine. There was also an argument raised by Coinbase on fair notice and APA grounds, and Judge Fela rejected that argument. Went through the history of the Dow report and other statements and guidance by staff, but most fundamentally, she explained that the SEC is not announcing a new regulatory policy, but rather is simply engaging in a fact-intensive application of an existing standard to determine whether certain transactions involving crypto assets meet the definition of an investment contract. And obviously, she's talking about the Howey test. Probably stop there since we've run out of time.
Thank you, everyone.
So good morning again. I want to thank my enforcement colleagues for such a thoughtful conversation about the what of our work. It's now my privilege to introduce our next speaker. We'll hear from Stacey Bowers, Director of the SEC's Office of the Advocate for Small Business Capital Formation, which works to advance the interests of small business and their investors in the capital formation process. Stacey began her legal career as a staff attorney in the SEC's Division of Corporation Finance before entering private practice. Since 2018, Stacey has served as director of the Corporate and Commercial Law Program at the University of Denver's Sturm College of Law, where she has also taught a number of classes on corporate and securities laws since joining the faculty in 2007. Stacey, welcome.
Good morning. Thank you to PLI for hosting this event and to the audience who is here and who is tuned in with us to listen. Because I love music, you will hear that theme woven in throughout my remarks. And to repeat what will be a familiar refrain today, I am speaking in my official capacity as the Director of the Office of the Advocate for Small Business Capital Formation, and my remarks do not necessarily reflect the views of the Commission, the Commissioners, or other members of the Commission staff. I've officially been the Director of the Small Business Advocacy Office for 79 days now. Some might say too short of a duration to know much of anything, and others might say long enough to have it all figured out. At this point, I know two things for sure. One, just like the Grateful Dead sang, the first days are the hardest days, but fortunately, the office's small but mighty team has made them easier. And two, George Jones was on to something when he asked, who's going to fill their shoes? Indeed, although I have a vision for what I want the office to achieve, I recognize that I have big shoes to fill as the new leader. Not just those of the inaugural director, Martha Legg Miller, who stood up this office in 2019, but also those of Deputy Director Sebastian Gomez, who carried the torch upon her departure, and Amy Reischauer, the most recent acting deputy director who stepped in after Sebastian to keep the office flourishing. It is with pride and enthusiasm that I accept the challenge of leading the passionate and dedicated staff of the office who work tirelessly through these leadership changes and have been there to guide and assist me during my first 79 days. They welcomed me with open arms and helped make my transition from academia and private practice in Colorado to this new role as smooth as Santana and Rob Thomas circa 1999. They made it easy to get through my first public-facing test on our 2023 Capital Call, a virtual event with live questions from the public just 2 weeks into my tenure. They made sure things went off without a hitch on our Incubate, Accelerate, Ignite event 7 days later, all while keeping this speech off my radar for at least a few weeks. And to them, I say thanks. I see this office as similar to a bridge in music, a connection between two sections of a song, bringing the pieces together. Our office is here to offer a bridge between the small business community and the agency, a crucial link to help the SEC fulfill its three-pronged mission. Because a bridge's essential function is to connect, under my leadership, this office will continue to listen to and support small businesses and their investors seeking to engage in capital formation and to amplify their voices inside the agency. And we are not just a one-way bridge. We recognize that listening is not enough. We also love sharing what we learn. Unlike Rod Stewart, we do want to talk about it. In fact, we like talking about it so much that we publish an annual report on the state of capital formation. For those who haven't seen our report, it is full of enlightening data and colorful graphics. For instance, did you know that 1 in 5 adults is currently founding or has founded a business in the past 3.5 years? What about the fact that 63% of net new jobs are created by small businesses, or that 44% of US GDP is created by those same small businesses? And were you aware that more than half of small businesses are only seeking $50,000 in capital to get started? Those are pretty impressive and informative statistics. It turns out that, as is often the case, conventional wisdom is right. Small businesses really are the backbone of America. If it hasn't dawned on you yet, I'm so nerdy that the Bare Naked Ladies could have written their Big Bang theme song about me and my love of numbers. Okay, maybe not that nerdy, but you get my point. I love data because it tells a story, and often an interesting one. So if you appreciate numbers, like the staff in our office and I do, and if you're looking for good stories, I encourage you to take some time and peruse our 2023 annual report. I promise you it is a surprisingly interesting read, and the graphics may make you question if it really is a government report. As you listen to me yammer on about statistics, you may be wondering why you should care. You should care because, much like the Beatles circa 1965, these small businesses need help. They need access to resources, connections, advice, and mentorship to help them get off the ground, keep their doors open, and succeed. Our office publishes and maintains a suite of educational resources on our capital raising hub to help these entrepreneurs and their investors break down the complexity of the securities laws and cut through the jargon. Our resources are also designed to help incubators, accelerators, and other organizations that support and mentor small businesses. And because so many startups tell us how difficult it is to find support, resources, and role models, helping them find these much-desired connections will be a priority of my directorship. This is where you can play a part. In the words of Patti Smith, people have the power. After all, facilitating capital formation is a prong of the SEC's mission in which most everyone can truly play a role. For those asking, how can I respond to the calls from small businesses saying, "Won't you please, please help me?" Perhaps you could consider volunteering with organizations that assist small businesses, exploring mentorship opportunities through entrepreneurial centers or other support organizations, or steering a small business owner or investor to our office's resources. While you ponder how you might get involved, we will continue to do our part as we shout, shout, let it all out, to quote Tears for Fears. And you know what makes us want to shout? Our office's resources, because they are tools that small businesses should not do without. If you're a small business owner or investor looking for guidance about how your world might intersect with the securities laws, take the bridge over to our capital raising hub at sec.gov/capital raising. While founders may not love every answer they get on the hub, we are big fans of the Rolling Stones in our office, and it is our duty to remind them, you can't always get what you want, but if you try sometimes, well, you might just find you get what you need. And what you need might be in our building blocks, a series of one-pagers breaking down fundamental securities law concepts into plain language. Or perhaps in our Grammy Award-worthy Cutting Through the Jargon glossary, which makes capital raising terminology as accessible as a Taylor Swift song. Or maybe you don't really know much about capital raising rules and what on earth the SEC has to do with your small business. In that case, you may want to start out with our Navigator. It's a choose-your-adventure type of tool that will point you to one or more of our user-friendly resources based on where you are in your capital raising journey. Perhaps you're a lawyer and your cost-sensitive client is requesting information about a new rule. While all of us in this room may be willing to wade through a 400-page release, hey, let's be honest, that's just a little light reading before bedtime. Your client may think you have lost your mind if you suggest they read the latest SEC rulemaking proposal to understand their legal obligations. Don't worry, we all know video killed the radio star, so you can send them over to our office's rulemaking video gallery, where we publish short videos summarizing how proposed and adopted rules affect small businesses,
And we promise we won't rickroll them, or will we? Of course, there is no substitute for a lawyer's sage legal advice, but the videos are a trustworthy source of background information, certainly much better than pulling a Marvin Gaye and hearing it through the grapevine. Hopefully this speech will prompt you to dive into our annual report to explore how we bring data to life and amplify the stories of small business capital formation, or prompt you to check out our capital raising hub if you are looking for educational resources. I suspect you will become a frequent user of both, like I was before I joined the office, and of course still am. And if a little voice inside of you tells you that you want to help us improve them, please heed the advice of Steely Dan, who said, "Ricky, don't lose that number," or in this case, don't lose our website and email addresses, because we really do want to hear your ideas. We are always working on expanding our resources to bring additional information based on user feedback. Next up in the playlist will be how to decipher financial statements and ways to seek out that much-needed mentorship. We truly welcome suggestions on further additions. And beyond our educational resources, we always want to hear your thoughts on specific statutes or rules, existing or proposed, and how they affect small businesses and their investors. In addition to submitting comments on proposed rules through the Commission's comment portal, you may also share your thoughts and insights with our office via smallbusiness@sec.gov. That email address you shouldn't lose. While I have only had the privilege of being a part of this office for 79 days, I am proud of what the team accomplishes on a daily basis. In addition to our annual report and educational resources, we review every SEC rulemaking to look at the impact it may have on small businesses and their investors. We also do dozens of outreach events throughout the year to engage with the small business community. Just around the corner, on April 16th through the 18th, we will host the SEC's Small Business Forum. Don't forget to register and encourage your clients to do so. And it's free. I look forward to this office continuing to be a strong advocate for the small business community, and I will do my best to improve the access that small businesses and investors have to the mentorship, guidance, and resources that they need to succeed. And remember, don't lose our contact information, because you can always reach out to us at smallbusiness@sec.gov with your questions or ideas, and visit our resources on our capital raising hub at sec.gov/capital raising. And now, to bring this speech to an end, it is time for the mandatory late 90s throwback. While it's closing time for me, all of you get to stay here and enjoy the rest of this wonderful conference. Thank you.
So we are on a break until 10:20, when we will resume with investment management.
All right. Hopefully everyone had a wonderful networking break. Welcome back. It's my privilege now to introduce the Division of Investment Management panel, which the director, Natasha Greiner, who we'll talk to you in a moment, has assured me will be better than any panel that William Birthistle, the former director, moderated. With that, Natasha is the new director of the Division of Enforcement. She'll now moderate a panel featuring senior staff from the division. Natasha was named director of IAM just last month. Before that, she was the deputy director of the Division of Examinations and the National Associate Director of the Investment Advisor Investment Company Examination Program. She began her SEC career in the Division of Examinations as a broker-dealer examiner and has served in a variety of roles across the agency for more than 20 years, including as acting chief counsel in the Division of Trading and Markets. Please consider the comments of the panelists. Natasha, over to you.
Thank you so much. You left out that I was in the Division of Enforcement. I thought you would have highlighted that, but
It's not the bio.
I'll work with your counsel. Good morning. Thank you so much for your kind introduction, Gurbir, and thank you for all of you for joining us today for the panel for the Division of Investment Management. As I'm sure you've come to expect, I'll begin with our customary disclaimer. My remarks today and those of my colleagues on this panel are provided in our official capacity and do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. I'm absolutely thrilled to be here today and also to have joined the Division of Investment Management last month. And what a better way to make my first official remarks at SEC Speaks among many of my former and current colleagues across the agency. I'm joined this morning with a few of my colleagues from the division, Caitlin Botok, who is co-chief counsel in the division's chief counsel's office, Brian Johnson, assistant director in the division's investment company and regulation office, Mike Spratt, who is the assistant director in the division's disclosure review and accounting office, and John Hertzke, assistant director in the division's analytics office. Before we get into the substance of this morning's discussion, I wanted to spend a few minutes just talking about the division. Division is comprised of over 200 staff members who oversee an industry with more than $100 trillion in assets and growing. This includes more than 14,000 mutual funds, and the division also oversees over 15,000 investment advisors who collectively provide advice to more than 50 million separately managed accounts. And as you'll hear a bit today, in addition to providing recommendations to the Commission on rulemaking initiatives, the division staff actively engage with industry participants, providing technical guidance and assistance on the interpretation and application of existing and new rules, review thousands of fund registration statements and other disclosure documents each year, and monitor industry trends and operations to provide critical insight and expertise about the asset management industry. One aspect of the division that I'd like to highlight is the division's analytics office. I think it's one of the offices that we don't speak a lot about because I think we focus a lot more on the rulemaking side. So I wanted to take a minute. The division, this office comprises of a mix of PhD, financial analysts, economists, and yes, some attorneys who collectively contribute to a unique perspective and provide the division and the Commission with deeply sound analytics and insight into the asset management industry. That insight and the analytics from this office is invaluable not only to the Commission, but it's particularly to the division. And I'd be remiss if I didn't highlight the division staff. In only a few weeks, I've been impressed by the staff's commitment to the mission and the wealth of experience that they bring to bear on every single project that moves throughout the division. I've been long a beneficiary of the division staff's significant contributions to the agency's work, but now I get to see it firsthand. Working directly with a diverse pool of talented professionals who are committed and contribute to the Commission's broader mission on a daily basis. And with that said, I'd like to invite my colleagues to join in this conversation to discuss the work in all of the offices within the division. And I'll hand it off quickly to Caitlin, who will talk about the Chief Counsel's office and give a quick overview of each of the offices within the division.
Great, thanks, Natasha. So we in the Chief Counsel's office, we assist the division and others in the commission, as well as external participants. So think other federal agencies, Congress, international organizations, multinational organizations, and also the public in understanding and interpreting the Investment Company Act and the Investment Advisors Act, their related rules, and other federal securities laws that apply to and affect investment companies, investment advisors, and private funds. In answering the questions that come to Chief Counsel's office, we consider whether or not exemptions or guidance under the relevant legal provision would be warranted, and if so, we work to issue those. To this end, and because our role in answering questions and providing legal guidance across the division and beyond is fairly broad, I'd note that sometimes you're going to find us in the background of other dialogues or conversations that you might be having with others in the division. I know we're going to spend some time today talking about examples of that kind of work, and I hope it's going to give you a better sense of what our role is in Chief Counsel's office. I'd also add that we spend a fair amount of time working on emerging trends matters, trying to kind of look around the corner, trying to anticipate future developments that might warrant our attention. The last thing I'd want to mention is since the last SEC Speaks, we've actually divided the Chief Counsel's office in a way that I think better supports the work that we do. So we've historically had 3 sub-offices in the Chief Counsel's office that focus on legal guidance matters. Now we've dedicated 2 of those sub-offices to work on matters arising under the Company Act and affecting registered funds, and 1 of those sub-offices to focus particularly on Advisors Act matters, advisors matters, private fund matters, as well as other external affairs. We also, of course, have our 4th sub-office that remains the same, the liaison office, and they work on matters, IM-related matters coming out of enforcement and exams. Brian, do you want to talk about rulemaking for a second?
Sure. So I think, as you might expect from the name of the office, in the rulemaking office, our focus is, of course, on the division's rulemaking agenda. To give you some color for that, the overall rulemaking office is divided into 2 sister offices, if you will. There's the Investment Company Regulation Office, which I head, and the Investment Advisor Regulation Office, which is headed by my colleague, Melissa Harkey. So, my office focuses on rules affecting investment companies, and Melissa's office focuses on rules affecting advisors, but there's sort of cross-staffing across the office and certainly overarching, collaboration, across the office. Just to give you some flavor for my office before I pass the mic over, I'll mention 2 quick points. One, and you'll hear this throughout my remarks, and I think from some others here as well, but just to preview it, is that although the rulemaking office leads the division's rulemaking efforts, it's really a collaborative activity, and we work with both within IM and across the commission with a number of stakeholders, and it's really very much a team effort. Maybe a final point I'll offer here is that our door is always open, and we're interested in hearing from people, both about proposed rules that are outstanding, about rules that have been recently adopted. I sometimes get the question, how does one arrange a meeting with the rulemaking team? And one simply has to ask. We meet with everyone who wants to come in and really benefit from that engagement. So with that, maybe we're passing to the left. Maybe we'll pass it to you, Mike.
Thanks, Brian. Sorry, it's kind of loud. I'm Assistant Director in the Disclosure Review and Accounting Office, which you may also hear referred to as DRAO. And similar to rulemaking, as the name suggests, the bread and butter work of the office is reviewing filings and disclosures made by registered funds of all types, whether it's an open-end fund like a mutual fund, an ETF, or a closed-end fund like a business development company. We review those with the goal to make sure that investors have the information that they need to make informed decisions. We're subdivided into 4 different offices, each headed by an assistant director. 3 of those offices focus on legal, regulatory issues. The 4th office focuses on accounting issues and is led by our chief accountant in the division. 2023 was a very busy year, and just to give you a sense of the flavor of the number of filings that we reviewed over 2,000 filings in 2023. That represented more than 1,800 filings by new funds, close to 1,500 by amendments by existing funds, more than 200 proxies, and we also reviewed around 2,400 filings related to annual reports. So it was a really busy year for our office, but I think more so than even the number of filings, which you kind of get a sense of how immense that can be, is the complexity. The days where we spent sort of the bulk of our time reviewing plain vanilla, long-only equity funds has kind of long passed, and we find ourselves increasingly facing reviews of funds pursuing investments in new asset classes like digital assets, using new types of technology in fund operations like blockchain, using complex strategies like investing with derivatives to provide leverage or inverse exposure to single stocks. So it certainly keeps things interesting and keeps us on our toes. And I think the last thing I'll mention is, while the bread and butter work of our office is the filing review process, there's also a number of other things that we do, which I think I'll talk about more on the panel, but those include some targeted reviews of disclosures in certain areas, working on different rulemakings that involve disclosures and helping to implement those rulemakings. And so that's some of the other work that we do as an office. So with that, I'll kick it over to John.
Thanks. Is that working? I can't tell. Yeah, okay. So I'm an assistant director in the analytics office. We're a relatively new office in the division, about a little over 10 years now, but that's in the course of the division, a relatively new office. We now have 2 assistant directors. I work with Dave Stevens, another assistant director in our office, and Tim Husson is the associate director who leads our office. One of the main focuses of our office is gathering and analyzing data and other information about the asset management industry. That analysis informs the division's work. I mean, people have talked about that. I think they may talk about that a little more later on, from rulemakings to disclosure reviews and to any number of the issues that the Chief Counsel's office sees during the year. Before I talk about some of our core functions, I did want to mention the makeup of the analytics office. It's a little unusual. We're a multidisciplinary team. We have quantitative analysts, we have financial analysts, we have examiners, we have accountants, we have attorneys, and other professionals. We also maintain a group of subject matter experts. That includes senior staff with extensive direct industry experience in particular asset management products or specialty areas. Those areas include experts, senior staff with expertise in exchange-traded funds, money market funds, portfolio management, risk management, and fund operations. Switching to sort of some of the core focus of the office, as the name would suggest, one of our core functions is analytics, analyzing available information and data about the asset management industry. For that, we have access to some commercial databases, but our core, what we focus on, are the information filed by asset management participants with the Commission. So to just give some examples of that I'm sure many of you are going to be aware of, and this is not an exhaustive list, but advisors file Form ADV, where they report a bunch of information about their operations. Form ADV is available to the public, but we also use that data a lot in what we do. Money market funds file Form NMFP, where they report detailed information about their portfolio holdings. Form NMFP filings are available to the public. Other registered funds, other than money market funds, file Form NPORT, where they also file detailed information about their portfolio holdings. Some of the data on import is public and some of the data on import is not public. Holdings for the third quarter of the fund's quarter are made available, but some information is not available. There are liquidity classifications, for example, are not available to the public, but we have that information and analyze that. And then finally, advisors to certain private funds report information about private funds that they advise on Form PF. Form PF contains information about operations and strategies of private funds. Form PF data is not available to the public. Another way that we can get information about the asset management industry is through outreach and engagement directly to industry participants. This engagement with the industry can take different forms, anywhere from a quick call to a more detailed examination. Outreach can be particularly helpful during fast-moving market events and to get more color on emerging issues. So if something's going on in the market and we want to get an on-the-ground perspective on what's happening, who is impacted, how are they impacted, who isn't impacted, any other nuances of the situation that we might not be able to get other than talking to people, we'll reach out and talk to folks about that. When we do this, we try and get a variety of perspectives and always appreciate it when people take the time to talk to us and provide us frank feedback and information about what's happening. In some cases where we may want to take a deeper dive into an issue or a certain set of issues, we might do an examination. That looks a little bit more like the examinations that some of you may be familiar with, that our friends in the Division of Examinations do. That's usually a longer engagement where we might request and review documents, and there may be a little bit more of a back and forth. Other outreach that we do regularly is related to the filings that I talked about. I talked about, the different forms from ADV, import, NMFP, and PF. I mentioned that analyzing this is a core function of the office and informs what the division does. For that reason, it's really important that the data is accurate and that we understand the data. We understand what the data says and any nuances that may be in the data. So if we see things that are inaccurate, or even if we see something that we may just want to understand better, we'll do outreach to filers. Sometimes we learn that the filer made a mistake and we get that corrected and we get the data corrected. Or we might learn there was a nuance about the data that applies only to a particular set of filers or just something that we didn't maybe fully appreciate, and then we get that information and that just improves our understanding of the data and improves what we can contribute to the division's work. And that's the analytics office.
Thanks so much. So we thought we'd talk a little bit first about implementation. Something that's in the forefront is the upcoming compliance date for T+1. This new rule set actually has a significant impact on a number of registrants throughout the industry, and I think the thing that we think is being lost is the impact on the investment advisor and ETF community. So we wanted to take a couple minutes today just to talk about the new requirements under the new rules. So Caitlin, can you talk a little bit about what we're seeing in this area and what we've done to be proactive in this space?
Sure, thanks. So last year, the Commission adopted a rule that shortened the settlement cycle for most securities to, surprise, T+1. The compliance date for the new rule is May 28th of this year, and so it's coming up pretty quickly. Just a quick overview, although the rules requiring the transition to T+1 settlement are Exchange Act rules affecting broker-dealers, the rulemaking also amended the Advisors Act record-keeping rule to require that investment advisors make and keep records of, 1, each confirmation received, and 2, any allocation and each affirmation sent or received, with a date and time stamp for each that indicates when the allocation or affirmation was sent or received. We, the SEC staff, are continuously engaging with market participants about their readiness for this change. In fact, as a result of that engagement, I wanted to highlight that we recently issued an FAQ concerning advisors' uncertainty about whether the source of the allocation, confirmation, or affirmation documentation or the timing by which such documentation is sent or received affects how such documentation is treated under the record-keeping rule. Cliff notes, it doesn't. The FAQ clarifies that the requirement applies irrespective of either the source or the timing. If advisors send or receive confirmation, affirmation, or allocation documentation, it's a record that they need to make and keep. Moreover, as part of this kind of continuous engagement that we're having on the rule, we're continuing to consider potential guidance in light of the feedback that we're hearing from market participants. I kind of wanted to highlight a couple of the themes that we've been hearing so far. So first, international considerations, and particularly advisors' ability to affirm trades on their trade date, given time zone differences and cash management practices for the normal T+2 settlement for foreign exchange transactions. Advisors will need to think about how to adapt to these issues. With respect to ETFs, ETFs should consider how the rule changes will impact what I'll call the ETF life cycle and their other fund operations, particularly with respect to any increased risks, and amend their policies and procedures to account for these changes. The last theme I want to highlight is advisors' uncertainty, or something we're hearing is advisors' uncertainty about whether they have any obligations beyond their record-keeping requirements. Advisors should understand that while record-keeping is the only rule obligation specific to them in this rulemaking package, they should also prepare for any operational changes necessary to enable brokers and other market participants to comply with the rules. I think you've already kind of been getting a sense of this today. I think I'm gonna go out there and say, I think it's gonna be a theme of this panel. But to the extent that you have questions or you have concerns or you need clarifications about this rule or any other rules, we encourage you to reach out and come talk to us, whether it's in Chief Counsel's office or in rulemaking. It's really important for us to know what issues you all are facing and so that we can react as necessary.
Thank you. And on the T+1 initiative, like I said, the impact is across the agency on a number of registrants. So we've been working very closely with the Division of Trading and Markets and also Division of Examinations. And recently they had issued their FAQ and TM and an exams risk alert that may be of use as well about all the work that we're doing within the commission. And so now another project that we're working on as it relates to implementation is the tailored shareholder reports rulemaking and the recent names rule amendments. And so Brian, maybe you can talk a little bit about those rulemakings generally, and then Mike can talk a little bit about our plans for reviewing these filings once they come through.
Thanks, Natasha. And I'm happy to speak to those. These were both actually in close collaboration with Mike and his team in disclosure. So I'll start first with the rulemaking on tailored shareholder reports. Just to give a bit of an overview here, these grew out of rulemaking amendments that the Commission adopted in October 2022. So under these new rules, funds will be required to send shareholders concise and we hope visually engaging shareholder reports that highlight key information and only that key information that the Commission thought was particularly important for retail investors in monitoring their investments. This includes information like fund expenses, performance, and a graphical depiction of the fund's holdings. More detailed information will remain available online and upon request. So, things like financial statements and maybe other information that, some investors want remains available, but making sure what investors have in their hands is readable and digestible and hits the information that we think they want to receive. So, as a result, these reports will be concise, just a few pages long, and also tailored to shareholders in that the report will cover just the fund in which that shareholder has invested, and if it's a multi-class fund, just the class of that fund in which the shareholder has invested, as opposed to a report covering, maybe a series of funds of which the shareholder has invested in just one. And to maybe draw a bit of a contrast here, today, fund shareholder reports, they can be quite lengthy and complex. As part of this rulemaking, we did some review on the staff just to get a sense of the length and complexity of shareholder reports. And just for example, what we found was that the average shareholder report is over 100 pages long, and there were some reports that exceed 1,000 pages, although that certainly wasn't the common situation. So the approach here was really to build on the Commission's layered disclosure framework and investors' preference for short, concise, approachable documents. Certain aspects of the report also were benefit from investor testing, which we found quite useful in forming policy development here. Funds will be required to start sending these new tailored shareholder reports this July, so that's coming up. And as we'll touch on later in the panel, the staff also has published some responses to frequently asked questions to help funds get ready. Maybe I'll turn now to the names rule and then pass it over to Mike to talk about implementation on both. So for the names rule, the Commission adopted changes to this rule in September of 2023. There really were a number of areas of the rule were affected, but I'm going to focus my remarks here on the expansion of the rule's 80% investment policy, which I think is regarded by most as the most significant change coming out of these amendments. Mike may also highlight some of the disclosure-related aspects when he speaks to it from his vantage point. To give some context for the change, under the current rule, if a fund's name, for example, suggests that it focuses in a type of investment, like say equity securities, the fund must adopt a policy to invest under normal circumstances at least 80% of the fund's assets in equity securities, or in the type of investment, but in this case, equity securities. This provision reflects sort of a basic truth in advertising principles, which is that if a fund chooses to use a name that indicates a particular investment focus, the fund should invest accordingly. This provision and also the underlying provision in the 40 Act that relates to fund names, I think it's also fair to say reflect that although the Commission has often cautioned investors not to rely solely on a fund's name for information about a fund, it is the first piece of information that investors will tend to see and probably has a sort of great deal of salience for investors. So against that backdrop, what the amendments did is they expanded the 80% investment policy requirement to cover fund names that also include terms that suggest the fund focuses investments that have or whose issuers have particular characteristics. And the amended rule text provides some examples to guide this and for example, covering fund names with terms such as growth or value, or terms indicate that the fund's investment decisions incorporate one or more environmental, social, or governance factors. In terms of some flavor for the underlying policy rationale, the Commission determined that the principles that underlie the investment, the 80% investment policy apply sort of just as well to terms like growth and value as they do to terms like types of investments and other things that currently require policy. The Commission also noted sort of the growth in the fund industry generally since the rule was adopted in 2001, but also in particular sort of the growth in certain categories of funds, including thematic funds that can sort of include buzzwords in their name to attract investor attention. It's sort of among the reasons the Commission made this change. So, one thing you'll hear about maybe in a little bit more is about the collaboration we have with the Bedreo staff and the policy development, but maybe in passing off to Mike, I'll mention their participation was crucial, but also hopefully positions the disclosure staff well to start receiving filings when they come in. So with that, Mike, I'll pass it to you.
Sure. Thanks, Brian. And, going back to my initial talking about what our office does, there's kind of the filing review process, the bread and butter work, but then the additional work, and I think these two projects that Brian talked about, tailored shareholder reports and names rule implementation, give me kind of a good opportunity to talk about something that we call first targeted reviews, which is relevant to the tailored shareholder report. And those are specialized reviews that we do outside the normal filing review process when we think there's either the potential for increased investor risk in an area, where we think disclosures can be enhanced in some regard, or where we're looking at implementation around a new particular rule, such as tailored shareholder reports. It's something that we've been doing for a number of years now, and there can be various triggers for these targeted reviews. It could be a news story, it could be a trend that we're seeing in the industry, it could be a new rulemaking, and so this coming later this year, we'll be looking at the tailored shareholder reports to make sure that funds are kind of complying with the legal requirements, and also to give our policymaking team a sense of kind of visually and content-wise what those reports are looking like, to see if they're delivering on sort of the policy expectations with respect to those rules. We also did a number of targeted reviews over the past year in other areas. For example, we looked at one point fund exposure to banks. That review was triggered by some stresses at Silicon Valley Bank and others. We looked at web posting requirements for ETFs and insurance products, which was, again, consistent with the theme of implementation of a new rule. We looked at fee and performance disclosure by funds, which is kind of a perennial area that we take a look at, given the importance of fees and performance to investors. And we're able to kind of quickly do a targeted review based on the tag data that we get on fees and performance in the prospectus for open-ended funds. So that just kind of gives a flavor of some of the targeted review work that our office does. To the names rule, I think that's a good example of rule implementation and how DRAIL is involved in implementation of various rules. To Brian's point, we're kind of involved on the front end, working on the rulemaking with the rulemaking team in these areas to bring kind of our in the trenches experience reviewing filings to those areas. And then on the back end, we're the ones that are in the names rule, for example, that are going to have to be reviewing the filings that come in, looking at the changes to the 80% policy, the additional disclosures that funds are adding, and seeing how they comport with the new regulatory requirements. I think even though that rule is not set to go into effect until 2025, or the compliance date is 2025, we've already started preparing for that implementation. Shortly after the rule was passed, we held internal training in our office to train our staff, and again, our office is about 70 staff, on the new requirements, some of the changes, some of the things that they might see in filings that come their way. We've also updated a number of our training materials. We have, for our staff, internal training materials in areas like the names rule that seek to drive consistent comments, so we've started to update those materials. We've also had periodic meetings with staff in both the rulemaking office and the chief counsel's office to talk about some early issues that we're seeing or some changes that we think we might see, potentially engaging with industry to hear what they're struggling with and wrestling with. And then as kind of we start to see the filings come in, we'll have periodic meetings as an office across our branches. I should have mentioned earlier that each of the 4 disclosure offices in turn have several branches, each run by a branch chief that review filings. And so it's important for us on implementation to kind of meet together as a group to make sure that we're being consistent and talking through similar issues and reaching a similar outcome. So that's something that I kind of expect to happen as we get closer to implementation. The last thing I'll leave funds with in the industry to consider is, as you're working through compliance and making those filings, to consider both selective review request and template filing review request. And for those of you that aren't familiar with template filing review, I think an example that I could give, Brian mentioned that terms like growth and value will now be subject to the rule. So if you're a fund complex that has a number of different growth funds and you're using or you plan to use a similar or the same 80% test across all those growth funds, rather than making a reviewable filing that the staff needs to review and that takes a certain amount of time to go effective for all those funds, you could start by making a reviewable filing for your first growth fund, have the staff review that, give you feedback, comments, incorporate those comments, and then use that filing as a template to allow you to make automatically effective filings for the other growth funds in your complex. And so that's something I think to definitely keep in mind, both to make for a more efficient implementation process for both the staff and for the industry as they seek to come into compliance with this new rule.
Thanks, Mike. So now I thought we would move on to staff guidance, FAQs, as we talked a little bit earlier, previewed in our T+1 FAQ, and no action letters. The division over the past years have provided staff guidance through informal conversations, but also through FAQs that are made public and no action letters. And so, Caitlin, can you talk a little bit about what your office does in this space and what you would recommend to industry participants who are thinking about engaging with the staff in this area, whether it's for staff guidance, FAQs, or no action letters?
Sure, yeah, thanks. We've put out, in Chief Counsel's office, we've put out a number of guidance pieces over the past year. I wanted to highlight two in particular before kind of turning to maybe some tips and tricks for engaging with us. The first is a no-action letter last year that we issued in October to Carlyle Global Credit under Section 17D and Rule 17D1. The letter confirmed that the staff would not recommend enforcement action to the Commission if, as specified in the transaction agreement that Carlyle had entered into with the Vertical Capital Income Fund, if Carlyle replaced Vertical's investment advisor, made a special one-time payment to shareholders, made a tender offer to purchase fund shares, invested itself in the fund by purchasing newly issued shares and acquired shares in private purchases, and entered into a series of voting agreements with certain shareholders, some of whom could have been affiliates of the fund. Two important, or what I think are important comments, two notes I want to stress about the letter. The first is it's a fairly short outgoing letter. The staff still spends almost an entire paragraph talking about the importance of Section 17D and Rule 17D1 to the 1940 Act's overall framework and its ability to protect investors from self-dealing and overreaching by affiliates. The second is the letter expressly states that due to the fact-specific nature of the request, other parties may not rely on that letter. We encourage parties contemplating similar transactions to contact us in Chief Counsel's office to discuss your particular facts and situations. The second piece I want to note is a guidance piece, a staff statement that we put out on 6/11, particularly regarding an ETF's description of its foreign currency holdings. As the staff noted in its statement, the staff saw a need for this guidance because it had observed certain ETFs disclosing portfolio holdings that were identifiable as foreign currency positions only as cash. In the guidance, the staff explains that because of the rules, the intent behind the rules disclosure requirement is to provide enough detail for APs to value the ETF's portfolio and identify arbitrage opportunities, while also providing retail investors with additional information to understand the ETF's holdings. The staff believes that foreign currency holdings should be more specifically disclosed to permit APs and retail investors, as well as other market participants, to distinguish between holdings of an ETF that are US dollars versus other currencies. Now, turning just for a minute to talk about engaging with the staff, I think I'd probably just highlight two things in particular. One is everything takes time. You know, if we're gonna issue formal written guidance, it's not gonna go out with just one set of eyes on it or two sets of eyes on it. So the earlier that you can bring us issues or start that dialogue with us, the better position we're gonna be in to meet your timing needs. The second thing I would note is that we really want to collaborate with you and work together to find solutions to the problems of the day. But it is most productive if you approach us directly with an issue. If we are in a position of uncovering something in a press release or in a filing, let's say that might be new, novel, or present a significant legal issue, we've not only lost valuable time, but sometimes we've also lost potential options for resolution. I think that's where I'll leave it.
And then, Mike, you and your colleagues in your office have issued an ADI recently relating to the WIXI status and other things that closed-end fund sponsors should keep in mind. Can you talk a little bit about the ADI, what an ADI is, and the issue the staff flagged in this particular instance?
Sure, happy to. And so, again, going back to the work of the office, in addition to the filing reviews, I think by now you kind of sense a theme that we do things in addition to that. ADIs are another. It stands for, we're not that creative, it just stands for Accounting Disclosure Information. So it's just our mechanism of getting guidance out to the industry, to investors, in places where we think it can improve compliance with disclosure obligations under the federal securities law. And it's really intended to help give funds guidance when they're making their filings to be, in compliance with those laws. And so the WIXI short form registration ADI that we published recently, I think last month, is kind of an example of some of the guidance that we may give. And for those of you that may recall it back in 2020, the commission adopted a rule that would allow closed-end funds and business development companies to take advantage of certain streamlined offering requirements that used to be only available to general corporate issuers. And I think an important thing in that rulemaking is that, similar to what I tell my kids when they want to use screens all the time, you kind of have to earn it, and there are conditions, and it's not a given that you're able to file on the short form. One of those conditions, and a key important condition for issuers that want to use that form, is you have to be timely on your filings. And so to the extent that you're not timely, you lose the ability to take advantage of that streamlined offering process. And unfortunately, since that rule was adopted, we as the staff have noticed a number of cases where funds were seeking to use the short form registration form and had not, in fact, been timely in their reporting obligations. And so we wanted to kind of draw additional attention to that issue, given that we had seen some areas of noncompliance.
Thanks. And so another area that we thought we'd highlight are FAQs on recently adopted rules, in particular the marketing rule, and as we talked earlier about the tailored shareholder reports requirements. And so, Caitlin, can you talk a little bit about the marketing rule FAQs that were issued? And Brian, maybe after that we could talk a little bit about the FAQs on the tailored shareholder reports rulemaking, and perhaps say a little bit more generally about the questions that you're hearing about both of these rules as they've been implemented.
Yeah, absolutely. We've issued a number of FAQs on the marketing rule. The most recent we issued in February of this year, addressing the presentation of net and gross net and gross internal rate of return by managers of private funds that use subscription credit facilities. In general, the marketing rule requires that when gross and net performance are shown, net performance has to be presented with at least equal prominence to and in a format designed to facilitate comparison with gross performance. And they have to be calculated over the same time period using the same type of return and methodology. As we state in our FAQ, when a subscription credit facility is used, fund IRRs can be calculated with or without the impact of the subscription facility. But given that the impact of the facility will affect the time period, return, and methodology used to calculate the IRR, whatever the choice, it must be consistently applied to both gross and net IRRs. In terms of questions that we're seeing, I'd say one kind of main theme and something I'd caution against is overly technical readings of the rule that run counter to the Commission's express intent. More broadly, in terms of our overall engagement on the rule, we, the staff, recognize it's not good for anybody when the industry learns of our views or our positions on a piecemeal basis through exams. And whenever possible, we seek to avoid that. As a result, when we learn of issues recurring across multiple exams, we've been issuing FAQs to try to level the playing field so that all industry participants know where we stand on a specific issue. We also regularly engage with the industry through conferences, industry associations, and questions from individual firms to better understand the issues that firms are facing. We encourage, again, firms to reach out to us and continue that engagement. Even though we can't promise an answer, a formal written answer to every question, it's very good for us to know what issues firms are encountering. Brian, do you want to take over now?
Certainly, thank you. Before I jump into some of the particular rules, I thought I also might just start with a few remarks about how we handle questions that come in particular on newly adopted rules, and how we over time sort of both work with and transition those over time to the Chief Counsel's office. So just as an initial matter, after a rule is adopted, we'll form a cross-office team to handle questions that come in. This will be members of the rule writing team that just complete the project, members of the Chief Counsel's office, and then also members of other offices in IM who worked with us on that rule, like quite often disclosure staff and rules that affect disclosure, for example. So this group then gets together both to sort of crowdsource questions wherever they might come into the division, and to sort of collect those questions in one place and compare notes on resolutions, including what form they can take. And one thing you've heard us talk about, and I'll mention some specifics in a minute, are FAQs, responses to frequently asked questions. This can make a lot of sense when we're, getting a question frequently, as that implies, or just a question's coming in that we think has a broader import, and it's important to put out our views, to the public, and FAQs are a good technique for that. Conversely, though, there are some areas where we get questions that are, quite either technical in various dimensions, perhaps very fact-dependent, firm-specific. In that case, we might just respond back to the firm who asked the question without any published guidance. Our general approach is that the rulemaking office sort of leads these efforts until the compliance date for the rule, after which the leadership then shifts over to the chief counsel's office. And the thinking here is to leverage the folks who just worked on the rule and just know that rule particularly well, but then over time sort of moving the responsibility to the chief counsel's office for sort of leading the responses to questions and interpretations. One maybe practical output of this is that one has a question about a recently adopted rule. Certainly feel free to contact the persons to contact in the rulemaking release, but at the same time, the virtue of this group is that whoever your usual contact might be, it should make its way to that group, for sort of a consolidated resolution. With that backdrop, maybe I'll give some examples of the different ways that we've, different questions that are coming in and how we've responded to those. So to start with the tailored shareholder reports, FAQs, yes, we issued a set of FAQs on those in January of this year. Many of these are really quite technical in nature. I'll put a plug for the breakout session later if you want to hear more about those details. But here, I'll just offer one key example. We've been receiving a lot of questions about the requirement in the fund shareholder report to compare the fund's performance to that of an appropriate broad-based securities market index. This is not a new requirement, but the Commission did amend the definition of the kind of index that could qualify for this presentation. Under the new rules, a permissible index must cover the overall applicable domestic or international equity or debt markets as appropriate. And this has resulted in some questions, things like what constitutes an overall market for this purpose, and sort of otherwise just some uncertainty among funds and their counsel as to whether indexes they previously used for this disclosure, could continue under the new rules. And the FAQs on this point confirmed that in the staff's view, there were certain types of indexes that were sort of put forward in the question. And the staff, in our view, those could be permissible indexes. Just to give some flavor for this, things like questions would be, could an Asia ex-Japan index qualify? Would that be the overall market? And the staff said yes. Maybe to pivot to a different sort of engagement, another upcoming compliance date, or in this case extended effective date, is funds will be required to file reports on amended Form NPX soon. Form NPX is the form that funds use to report their full voting records to the Commission and to the public. And the Commission adopted enhancements to this form in November 2022, both some changes to the manner in which the information is presented and some additional detail on voting matters. And voting reports that comply with these new amendments are due starting on July 1 of this year, so that is upcoming. So in the run-up to this compliance date, we have had some very good collaboration in that setting that I mentioned, working with our colleagues in Chief Counsel's office, both on identifying questions and resolutions. But to date, these have been, I would say, highly technical, and we've gotten back to the firm in each case, but have not yet had sort of broad-based import questions that we thought warranted FAQs. So I laid that juxtaposition in part to make the point, and this is the theme that you're hearing, is just because there isn't a set of FAQs doesn't mean there aren't questions being asked and answered. And so if you do have questions, feel free. And on that note, maybe I'll close my remarks here by just mentioning, since we've spoken a lot about tailored shareholder reports and also the names rule, we, as Mike was mentioning, are doing some preparation in anticipation of questions we might receive, although we haven't received any questions yet, which I think makes sense. The compliance dates for this are pretty far out. For larger fund groups, that's not until December 11, 2025, and smaller fund groups till June 11, 2026. So, funds have some time. That said, it certainly wouldn't surprise me if people do have questions as those dates approach, and we're certainly happy to engage on those. So maybe with that, I'll pass it back to you, Natasha.
Thanks. And so no conversation about the division will be complete without addressing our ongoing rulemaking work. And I know Brian is here representing the division's rulemaking office, but I think it's important to note here that the efforts coming throughout the division are collaborative amongst the staff. It is not just those that are in the rulemaking office that are work on rulemaking. We pull experts within the division throughout and also get a lot of input across the agency. And obviously, all of your input through the comment process has been critical in all of our ongoing rulemakings. And so I think, Brian, maybe you want to talk a little bit about the collaborative process that goes inside the division, and then also just talk a little bit about how other offices contribute to the rulemaking process.
Yeah, certainly. So, you've probably noticed this collaboration point has come up a few times in this panel, and I think that's for good reason. We in rulemaking, we certainly work closely with really every office in IM and across the commission in all aspects of our work, both in identifying areas that, where maybe areas of concern or potential concern, where maybe rulemaking is the right tool, and where we conclude that it is, and working with those offices on fashioning what might be the best response. For example, in terms of collaboration across divisions, we work particularly closely with economists in the Division of Economic and Risk Analysis, or DERA, in developing policy. They're really involved, from day one, and a core part of the team and with us, every step of the way. But maybe to focus more so on collaboration within IM, given we're sort of all gathered here in IM, certainly it's the case that I would say we virtually always, in any rulemaking of significance, always have input from other offices in IM in our rulemaking projects. And often members of those other offices will join the core rulemaking team and participate. As John was mentioning at the outset, Natasha as well, analytics is also a key player in rulemaking, helping us leverage data. This has really been critical in informing policy and analyzing different policy choices. And in my time doing rulemaking at the Commission since 2010, just the increase in our internal capability in IM for analytics has been both staggering and really beneficial to our office's work. The names rule amendments that we covered earlier actually provide, I think, a great example of this type of collaboration. The inspiration to consider updating the names rule was driven in large part by the Disclosure Office's extensive experience in administering this rule over the last 20 or so years that's been in place. It also was informed by a request for comment that the Disclosure staff spearheaded, working with rulemaking, but really driven by the Disclosure Office. In that request for comment, just sought feedback on how the rule is working, and different areas, many of which did end up being a focus of the commission's rulemaking ultimately. And to continue this example, from where I sit in rulemaking, the Disclosure Office sort of just practical experience was critical in identifying, where the rules seemed to work well, where perhaps it could use, some improvements. And it also, I think, was important programmatically to have Disclosure staff on the core team throughout the process. One, for that benefit that I mentioned, but also to ensure that the rule as adopted is both practical for funds who are subject to it, but also we can administer it effectively as well within the agency. I sort of focus my remarks on IM collaboration, but maybe I will just respond to one point Natasha made, which certainly, the public comment is an invaluable part of this. I might touch on this a bit in other areas, but one thing I'll mention just in response to that prompt is I don't know if I've ever seen a rule go from proposal to adoption without change, enough with significant change. So those comments really do have an impact and are important. But maybe pivoting back to IM, maybe Mike, can I pass the mic to you to talk about your perspective on collaboration in rulemaking?
Thanks, Brian. We're pretty much involved on every rulemaking project that involves fund disclosures, and I think it's been a great working relationship with Brian and his team, whether it's on kind of the RILA rule that the Commission recently proposed and that continue to work on, tailored shareholder reports, names rule. I think the names rule is a good example where the staff in Disclosure had decades of experience administering the rule. We kind of knew the thorniest issues that we struggled with as a staff, and were able to kind of elevate those to Brian and his team right away. Kind of mainly, first is something a type of investment in a strategy, and is it covered by the rule? How the rule applies to derivatives, where you have a rule whose text is based on value, but derivatives provide exposure that's significantly greater than that value, and how the rule should account for that. How the rule would apply in areas where there's sort of kind of emerging themes like artificial intelligence or cybersecurity, where companies might not have yet recognized or realized significant revenues in those places today, but that may in the future, and how the rules should account for those types of circumstances. So these are all examples that were kind of front of mind, top of mind to the Disclosure Office that we're able to elevate to the rulemaking team. And ultimately, kind of all the examples that I just discussed are things that the Commission ultimately weighed in on in the recent adoption. So I think it's another great example of collaboration. And to the broader theme of collaboration, I probably should emphasize this more in my opening remarks. Even when we get a filing in our office, particularly the complex ones that I discussed earlier, it is a truly collaborative effort. We work with John's team to analyze whether it's liquidity or market inputs or data related to a particular type of strategy. We work with Chief Counsel on interpretive issues that come up. For example, I mentioned the single stock funds and some of the 18F4 derivatives compliance issues that those raised are ones that we worked on with them. We work really across the agency, and so I think that can maybe delay the process for some respects with respect to issuers and wanting to get to the market, but that's kind of the reason why we're working across the division, across the Commission, sometimes even with the commissioners, to get their feedback and incorporate that into our comments that we're providing to funds.
Yeah, I mean, should I pick up from here on Chief Counsel's office? So, we also have a significant role to play in rulemaking. Many, though not all, of the rulemakings are, derived from or sometimes at least have a significant touch point with CCO guidance or exemptions. And so CCO can contribute to the policymaking process through sharing the history and our expertise with that guidance and those exemptions throughout the development of the rule. CCO is often directly involved in taking the lead on drafting certain parts of rulemakings, particularly when they include guidance. I think the SPACs rulemaking is a great example, as is TM's Treasury clearing rules, where the Commission ultimately adopted as part of a larger rulemaking CCO drafted guidance that impacts investment companies. And, finally, to just kind of harken back to something Brian was talking about earlier, we have an important role to play in the implementation process. We have this established process by which a new rule essentially moves from rulemaking to Chief Counsel's office throughout the implementation period. So by the time we get to the compliance date, Chief Counsel's office is, taking the lead on questions and inquiries that we might get about a rule, though, of course, we would continue to confer and dialogue with our rulemaking colleagues.
And maybe, Brian, you can give us a little insight into what other rulemakings that are front of mind for your office right now that are ongoing.
Yeah, I'm glad to do that. So I'll start off by mentioning a few outstanding proposals that are top of mind for me in no particular order. So to start, the Commission proposed a number of rule changes in November 2022 that would affect funds' liquidity risk management programs, order processing, and portfolio disclosure. So for example, these amendments would require funds to put in place a hard close and use swing pricing, and to make various changes to liquidity risk management programs. This proposal also would require funds to report portfolio information more quickly to the Commission and provide more transparency about holdings to the public. The goals of this rulemaking include mitigating dilution that can occur when funds experience heavy redemptions and better preparing funds for stress conditions. Really, the impetus to look at these areas was, at least look at them in this particular moment, was so if there were significant redemption pressures funds experienced in March 2020, and followed on by some outreach led by analytics actually about funds practices following that event. Another sort of outstanding proposal, a significant one, is that we are working on a proposed rule on cybersecurity. This proposal would require funds and advisors sort of both put in place sort of protection against cybersecurity risks, report certain significant cybersecurity events confidentially to the Commission, and also make certain public disclosures about cybersecurity incidents. The impetus this here is that just reflects that cyber threat actors have continued to grow in sophistication, and cybersecurity incidents affecting funds and advisors can result in substantial harm to investors. One sort of thematic point I'll highlight here is this is actually one of several rulemaking initiatives related to cybersecurity that are ongoing at the agency now. There's this, this rulemaking, there's another cybersecurity rulemaking related to certain entities that trading markets overseas, and some others, including one in IM that, although not overtly or specifically cyber-related, has a cyber dimension in the form of amendments to Regulation SP, which under that proposal would require certain financial institutions that we regulate to notify customers if their sensitive customer information has been subject to unauthorized access or use, whether in a cyber event or some other way. A different topic, moving on, would be another outstanding proposal would require funds and advisors to provide additional information about their ESG investing practices. In very broad terms, the amount of disclosure that would be required under this proposal would depend on the extent to which the fund, I'll focus on funds for now, considers is part of its investment strategy, with the most disclosure required for funds for which these factors are a primary focus of the strategy. And those funds, called ESG-focused funds, the proposal would be required to put forth some sort of standardized information about the way they think about ESG issues. One point I often sort of try to emphasize when talking about this rule proposal is that the Commission did not propose to define ESG or ES or G or any of those terms, but rather proposed to require funds that themselves incorporate these factors to themselves define those terms and tell investors what those terms mean in the context of that strategy. And this then lets an investor make a determination if that fund is a good fit. I think I have tended today to focus my remarks a bit more on funds. That sort of is my office's focus, but I certainly wanted to mention a few particularly significant outstanding proposals that would affect investment advisors more directly. I'll give two examples quickly here. One example is the Commission's proposal to address certain conflicts of interest associated with the use of predictive data analytics by advisors, and this also affects broker-dealers. This proposal is responding to firms' accelerated use of predictive data analytics, artificial intelligence, and other technologies. I think my sort of summary of this is I think the Commission recognizes certainly that those technologies can be beneficial to investors, but to the extent that they optimize in a manner that places the firm's interest ahead of investor interest, that can be problematic. Another rulemaking in this space, which I'll touch on very briefly, is the proposed safeguarding rule for investment advisors. This rule would make a number of changes to the Advisors Act custody rule. I'll just mention very quickly a few high points. The rule would expand, I should say, the assets that are covered by the rule beyond funds and securities to require advisors to maintain with a qualified custodian a broader range of assets. It would treat authorized trading expressly as creating custody, and it would also enhance some of the sort of baseline requirements around qualified custodians in the form of a written contract. This is obviously a high-level treatment here. One thing I'll very briefly mention, and then I'll pass it, I guess back to Natasha and over to John, is just last week the Commission adopted changes to the Internet Advisor exemption. So it felt so timely that I should give it a plug. So very generally speaking, some advisors are prohibited from registering with the Commission, small or mid-sized advisors, unless an exemption is available from that prohibition. The Internet Advisor exemption is one such exemption. So under the new amendments, an advisor that relies on the Internet Advisor exemption is no longer permitted to have any non-internet clients, whereas the rule currently permits a de minimis amount, and must provide advice to all of its clients exclusively through an operational interactive website at all times that relies on the exemption. But advisors do have some time to come into compliance because the compliance date is March 31st, 2025.
Thanks so much, Brian. And now, John, maybe you could talk a little bit about the analytics office. I know I highlighted it earlier and all the great work that your office does, not only for the division as a whole, but the agency as well. Can you talk a little bit about the public reports that AO publishes and some of the ways in which experts can use these reports and the insights that your office provides the public?
So quickly, because I think we're running a little out of time, but as I discussed before, our office's main function is analyzing data, or one of the main functions is analyzing data and in particular, analyzing data that's filed with the Commission. We very much like to, when we can, and when it's appropriate, provide some of that analysis to the public. And so I just want to talk quickly about two reports that we publish on the SEC website. It's available to everyone that gives it a little peek into what the office does and provides some insight into some of that information. One example of this is the Money Market Fund Statistics Report, which we publish monthly. That report contains summaries of various data reported on Form NMFP. As I mentioned, Form NMFP is already available to the public. The filings are available. But this report gives the staff sort of summary, census information, summaries of various different information that's reported on NMFP. And we also publish a downloadable structured data file that provides historical time series for the statistics in the report. We also publish on a quarterly basis a private fund statistics report. This report contains summaries of the various data from private funds reported on Form PF. Now, as I mentioned, Form PF is not public. That data is not available to the public. But we are able to publish, the Commission has approved us publishing this summary, aggregated, anonymous information. So it's designed to not reveal anything about particular filers or funds, but it does provide summary information about the private fund industry, and which I think, it's interesting because that data is not available to the public, but it really provides an insight into the private fund industry, and I recommend people who study that or interested in that to go on the website, look at that report. We've been doing that for several years now, and I think I'll close with that.
Thanks so much, John, and thank you to all of you for eliciting us today's panel. I just wanted to do takeaways. One is a plug for our IM workshop later today. The staff of the division will talk a little bit more in detail on some of the topics we talked about this morning. So please attend that if you can. And then I also just it was clear through the presentation, I would like to say we coordinated it, but we did not. Engagement is key. Whether you're engaging with us through the comment letter process, whether you're talking to DREO about particular filings, or through the Chief Counsel's office on particular interpretive issues, we are open for business, and we're always willing to engage with the industry. So please feel free to reach out, whether via email, our hotline number, or directly to any one of us. We're happy to chat about issues. We do our job better only because of all of you and your insight. We can't do it in a box. So engagement is key, and I want to leave you with that. And thank you to all of you and all of the panelists today.
Okay, thank you to Natasha and our IM colleagues. For the record, by a show of hands, was that better than William Birdthistle's panel from last year? He's listening online, by the way. So, William, I'll share with you the results later. Our next speaker, who will be joining us remotely, is Allison Wise. Allison is the acting director of the Office of Minority and Women Inclusion, which develops and implements programs and initiatives related to maintaining workforce diversity, cultivating workplace inclusion, and promoting supplier diversity in the SEC's business activities. Before joining the SEC, Allison was the program director for diversity and inclusion at the U.S. Office of Personnel Management. There, she led OPM's efforts to develop government-wide policies and guidance to assist federal agencies in building diverse, inclusive, and engaged workforces. Welcome, Allison.
Good morning, everyone, and thank you, Gabir. This speech is provided in my official capacity as the Commission's acting director for the Office of Minority and Women Inclusion, but does not necessarily reflect the views of the Commission, the commissioners, or other members of the staff. I'm very pleased to be with you here today. I'd like to start by briefly talking about the SEC's DEIA strategic plan for fiscal years 2023 through 2026, and then spend some time connecting the work that we do in OMWI with the work and why it matters to you. As many of you are aware, in September of last year, the SEC released its second Diversity, Equity, and Inclusion Accessibility Strategic Plan for fiscal years 2023 through 2026. For the new DEIA strategic plan, we built on the SEC's accomplishments from the last plan and expanded this plan to embed DEIA in all aspects of our work at the SEC, including our mission activities. Before I dive into that further, I want to briefly talk about the development of the DEIA strategic plan. We consulted multiple sources, starting with the Executive Order 14035, Diversity, Equity, Inclusion, and Accessibility in the Federal Workforce. We incorporated the spirit of the Executive Order 14035, particularly with the focus on equity and accessibility. We also researched and benchmarked other federal agencies, government plans, reviewed the Office of Personnel Management's government-wide DEIA strategic plan as well. In underscoring the interconnections between achieving the SEC's mission and the importance of DEIA, the DEIA strategic plan aligns with the SEC's strategic plan goal of supporting a skilled workforce that is diverse, equitable, and inclusive, and is fully equipped to advance the agency objectives. We recognize that DEIA are the cornerstones for the SEC's three-part mission, and the DEIA strategic plan seeks to embed DEIA in all aspects of the SEC's work and create an environment of belonging and respectfulness. We gathered and solicited feedback from internal key stakeholders and commissioners. We also invited all SEC staff to provide comments on the plan and held open office hours to collect feedback. Now I'd like to provide you with a brief overview of the actual strategic plan. The plan is constructed around a framework that contains three pillars: people, culture, and mission. And we developed one focused goal for each pillar. That we are referring to in these areas are goal number one, under people, build our future through our people. This is really about achieving a workforce that is representative of people from diverse backgrounds at all levels and across all teams and occupations at the Commission. Goal two, under culture, foster a culture of inclusivity, connectedness, and belonging. This refers to creating a culture that encourages collaboration, learning from differences, flexibility, fairness, and equal opportunity, in which workplace structures, policies, and practices enhance organizational effectiveness. Goal three, under mission, is about leveraging DEIA as a strategic business priority that enables us to better protect investors, maintain a fair and orderly and efficient market, and facilitate capital formation. By embedding DEIA in all aspects of the SEC, we are better situated to effectively meet the current and future needs of a changing and increasingly diverse world. As we developed goal three and corresponding actions, we considered the SEC's role in the DEIA space and the financial services industry, as well as the tenet that DEIA is a shared responsibility. When we talk about DEIA as a shared responsibility, we see that going beyond the confines of the SEC's workplace. We rely on partnerships with you and your organizations to help us further our DEIA goals and priorities. This brings me to the OMWI's work and why it matters to you. Including diverse perspectives in implementing our core mission work is a priority under the DEIA strategic plan. OMWI spearheads several efforts to achieve this priority. OMWI helps provide opportunities for individuals with diverse perspectives to serve on SEC advisory committees and task force. We've observed firsthand the positive impacts that diverse perspectives bring to our advisory committees. OMWI assisted the Investor Advisory Committee, IAC, regarding recommendations to fill open committee vacancies. One of our OMWI staff served as the chair of the IAC nominating committee that was responsible for making vacancy recommendations to the Commission for open IAC positions. The open positions were filled by individuals from diverse backgrounds and experiences. What we've seen as a result are more robust and expansive conversations with advisory committees. We also helps expand opportunities for diverse perspectives to be considered in rulemaking and regulatory policy processes. We focuses on outreach efforts and builds relationships with partner organizations to promote the inclusion of minority professional organizations in discussions pertaining to policy considerations and recommendations. For example, we facilitated discussions with the Asset Management Advisory Committee toward enhancing asset management opportunities for diverse asset managers. As a result of these efforts, the perspective of and input from partner organizations were considered by the AMAC in making recommendations regarding diverse asset managers. We also work to educate and promote the benefits and importance of DEIA in the financial services industry. We do this by not only sharing what the SEC is doing in the DEIA space, like talking about our DEIA strategic plan, but also by inviting entities regulated by the SEC to engage in self-assessments of their diversity policies and practices. Pursuant to the Dodd-Frank Act, the OMWI director is required to assess the diversity policies and practices of entities regulated by the SEC. Every 2 years, OMWI invites the SEC's regulated entities to complete a self-assessment for their diversity policies and practices and submit their self-assessments to the OMWI director. How do regulated entities, diversity policies, and how do we regulate that? In accordance with Dodd-Frank, we developed standards for assessing diversity policies and practices. To facilitate the use of standards by regulated entities that are subject to the regulations of more than one agency, the OMWI director of the Board of Governors of the Federal Reserve System, the Bureau of Consumer Financial Protection, and the Federal Deposit Insurance Company, and the National Credit Union Association, and the Office of the Comptroller of the Currency collaborated to develop joint standards for assessing diversity policies and practices. To help entities break the self-assessment process down even further, the SEC provides a template that entities can use to engage in a self-assessment, structured around these joint standards. I'm happy to share that we recently revised this template so that it is shorter, easier to understand, and aligns more closely with templates provided by some of the other financial institutions Reform, Recovery, and Enforcement Act agencies, which we call FIREAs. We call it the Diversity Self-Assessment Tool, or DSAT. Submitting a self-assessment, or DSAT, allows OMWI to learn more about diversity and inclusion within the financial services industry and informs OMWI of areas where additional guidance may be useful. OMWI also publishes reports based on information collected from self-assessments of diversity policies and practices, including leading practices, after each submission period. The report does not identify any particular entity or disclose confidential business information. We will be issuing a press release in April. Actually, we already issued it on the analysis for 2022 collection, along with our annual report to Congress. Later this year, we will be inviting entities regulated by the SEC to submit their self-assessments of their diversity policies and practices. So we will be reaching out to many of your organizations. We hope you will help us increase the submissions and close information gaps by encouraging your organizations to submit a self-assessment or encourage other entities regulated by the SEC to submit their self-assessment. You can find more information about the self-assessments, reports from prior years, as well as the template I mentioned on sec.gov/OMWI/regulated entities. In the coming months, please be on the lookout for an invitation from my office, the Office of Minority and Women Inclusion, to submit a self-assessment of your organization's diversity policies and practices. please feel free to reach out to my office at any time by emailing omwe@sec.gov. Leveraging DEIA is a strategic business priority that enables us to better protect investors, maintain a fair and orderly and efficient market, and facilitate capital formation. By embedding DEIA into all aspects of the SEC, we are better situated to effectively meet the current and future needs of a changing and increasingly diverse world. Thank you for your partnership in helping us to meet this strategic business priority, and I look forward to continuing our partnership with you. Thank you for your time today.
Thank you, Allison. And we are on a break now for lunch. There's lunch outside the room. And for everybody else, we will see you back here at 12:40 for the accounting panel. Thank you.
Great. Welcome back. I hope everyone had a good lunch. Now the real fun starts, and to keep up the post-lunch energy, I'm pleased to introduce our next panel featuring the SEC's chief accountants. The panel will be moderated by Jonathan Wiggins. Jonathan is Deputy Chief Accountant in the Office of the Chief Accountant. He leads the activities of OCA's accounting group, including supporting the Commission's oversight of the Financial Accounting Standards Board, rulemaking activities, and providing technical consultations to public companies, auditors, and divisions and offices within the SEC on the application of accounting standards and financial disclosure requirements. Please consider the comments of these panelists. Over to you.
Thank you for that kind introduction. My colleagues and I are honored to have the opportunity to speak at this conference this year. In today's session, I am joined by Ryan Wolf, the Chief Accountant of the Division of Enforcement, Sarah Lowe, the Deputy Chief Accountant in the Office of the Chief Accountant of the Division of Corporation Finance, and Jensen Wayne, the Chief Accountant in the Division of Investment Management. As a reminder, the views that we express today are provided in our official capacities and do not necessarily reflect views of the Commission, individual commissioners, or our colleagues on the staff. Also, to the extent that we discuss any enforcement matters, we are only referencing facts as alleged in the Commission's order or complaint. In this panel, we'll provide a number of updates on a wide range of accounting and financial reporting topics covering recent amendments to U.S. GAAP, issues related to audits, non-GAAP issues, which are a perennial favorite, and issues related to investment companies, among others. But before jumping into those specific topics, I thought it might be helpful for us to just each provide an overview of our roles and what we do in our offices, including any top priorities for each of our different groups. So starting with OCA, the SEC's Office of the Chief Accountant is led by Paul Munter, the Chief Accountant, who in that role is the principal advisor to the Commission on any accounting or auditing issue that arises in our administration of the federal securities laws. In OCA, we're very much focused on improving the quality of financial reporting and auditing for the benefit of investors in support of the SEC's threefold mission. Just to give you a sense for some of the activities that we do in the Office of the Chief Accountant, or OCA, activities including things like meeting with investors, registrants, other stakeholders, to understand their perspectives and priorities related to accounting and auditing issues, and for us to share our perspectives as well. We also have a robust consultation process through which companies, auditors, and others can come get formal staff views from our office, whether that be on auditor independence or application of US GAAP or IFRS or other issues, either on a pre-filing or a post-filing basis. So as always, I would encourage anyone who encounters a challenging, unique, novel issue to feel free to pick up the phone and give us a call and engage with us in a discussion on those issues on a formal or informal basis. We also work very closely with my colleagues here and their divisions on supporting their work related to accounting and auditing issues. So if CorpFin issues a comment letter related to a really meaty accounting issue, that may end up in our office as well to work with them to resolve that issue. Same with IM and enforcement. We also lead the commission efforts to oversee the FASB and accounting standard setting. We monitor the IASB and work closely with the IFRS monitoring board. Lead efforts to oversee the PCOB, including reviewing the PCOB budget and proposed and final standards and rules, and engage internationally broadly. But again, as we perform each of those activities, we're very much focused on how each of those activities ties back to the SEC's threefold mission of protecting investors, maintaining fair, orderly, and efficient markets, and facilitating capital formation. So with that, maybe I can hand it off to you, Sarah, to discuss CorpFin.
Sure, thanks, Jonathan. So you heard yesterday from the Division of Corporation Finance's director and deputy directors about what CorpFin does. So I'm going to keep my remarks focused on our office of the chief accountant, which again is often referred to as CFOCA. CFOCA's accounting and financial reporting is the division's accounting and financial reporting experts for the liaison on such matters to other divisions and offices, as Jonathan was mentioning previously. And in terms of how we support the CorpFin through its various work streams, those are mainly from the standpoint of assisting the disclosure review program with complex accounting and financial reporting matters, responding to requests from registrants or their advisors to substitute or waive certain financial statements and filings, and providing technical assistance on several rulemaking projects, for example, the recent Shell Company and SPACs adopting release. And one other point I just wanted to throw out there was in this last year, we had one substantial retirement, actually, which is irreplaceable, but we also hired 2 associate chief accountants and 4 assistant chief accountants. So our total headcount has blossomed to 16 now, which is very exciting to be able to continue to meet all of the ongoing projects. Jensen, do you want to say a few words?
Sure. Thanks, Sarah. And similar to CorpFin, you've heard this morning from, or I guess earlier this morning, from the Division of Investment Management and our director and the other leads of the various offices in the division. So I'll try to keep my remarks somewhat short here. But during the earlier session, you heard that we have 5 offices in IM. There's the Rulemaking Office, Chief Counsel's Office, our Analytics Office, Managing Executive's Office, and then the Disclosure Review and Accounting Office. Now, our Chief Accountant's Office, as we're referred to as IMCAO, because we just love our acronyms here, we sit within the Disclosure Review and Accounting Office. Our office is essentially broken into 2 groups. It's an operations group and a policy group. They're both overseen by me, and I talk about them as if they're distinct groups. They really, cross-pollinate across both policy and operations matters. But on the operations side, we have a couple of things that we're responsible for. We review certain filings that need to be declared effective, like registration statements and merger filings. In addition to that, it's completing the SOX mandate, so requiring every registrant's financial statements be reviewed at least once every 3 years. And with over 14,000 registrants, which include ETFs, money market funds, business development companies, We average about 4,000 to 5,000 reviews every year, so it's quite a large undertaking for the 13 staff accountants that we have on staff at the moment. And sort of rounding out our squad of staff accountants on the ops side are 2 branch chiefs that oversee those 13. We also did add a new position this year as well as a senior special accountant who focuses on a number of more specialized projects, mostly to deal with our office's use of data and automation in our monitoring and review process. Now, on the policy side, we have 3 excellent assistant chief accountants who join us from industry on 2 to 4 year fellowships. They work primarily on consultations. They work on accounting and auditing related matters related to investment funds. They support the rulemaking initiatives coming out of IM, in addition to supporting our chief counsel's office on certain exemptive orders that might have an accounting or auditing lean to them, and as well as collaborating with other offices and divisions. Today, I will plan to share some trends that we're seeing in IM and maybe some disclosure questions that we're providing during our SOX process. So since we're probably going to be getting over on time, I'll turn it over to Ryan to talk about the Division of Enforcement.
Thanks, Jensen. Hello again. Thank you all for indulging me on a second panel. And I just have to start. Stephanie Reinhardt in our enforcement front office reached out to me after the first panel and told me that I had missed a golden opportunity to say, when I was conveying like the role that all the folks in this room can have in protecting investors, what I should have said is we're all counting on you to protect investors. So thank her for jazzing up our talking points. If you listen to the descriptions that my colleagues gave of their offices, you'd probably be rightfully a little bit confused because the only thing we love more than acronyms is putting the words chief and accountant in our titles. So it's definitely us, it's not you. But I am in the Division of Enforcement, and we're responsible for enforcement of all of the federal securities laws. And we have over 100 accountants working on nearly every aspect of investigations and recommendations to the Commission for enforcement matters. In addition, a lot of our accountants play really important roles in litigation that's going on. So what do our division's accountants do? They're skilled investigators. They work alongside our talented attorneys. They're developing the records and analyzing the fact patterns to identify and establish violations of the law. What I also want to emphasize is one way that we use our skills and experience is to distinguish when an issue warrants an enforcement recommendation versus perhaps a referral to one of our colleagues, maybe in the Disclosure Review Program or in the SOX Review Program, or to our colleagues from the Division of Examinations. I just want to also say that I really echo Jonathan's comments earlier that we're all on the same team here. I'm really confident in the deep technical expertise of our folks within the division, but we do have a broad mandate. So we're certainly working closely with each of these offices with their deep policy and technical expertise for every enforcement recommendation that we're making to the Commission.
Thanks, Ryan. We are all on the same team, although I would point out it's OCA, Enforcement OCA, CorpFin OCA, and IMCAO. So one of these is not like the other, but we still love them. Thanks for that tee up. Maybe we can dive into a specific topic related to accounting and GAAP issues. And maybe starting with segment reporting. I mentioned that OCA is heavily involved in accounting standard setting and engaging with the FASB on that standard setting. We're really focused on oversight of the FASB, so their due process and structure, their governance, but also making sure that the standards that they finalize are sufficient to meet investors' needs in the public interest. And in part, the development of high-quality standards then requires high-quality application and implementation of those standards in order to get the high-quality financial reporting to investors. So, the Commission has long recognized the FASB as the independent accounting standard setter in the U.S. I would note, however, that independence doesn't mean isolation. They don't fulfill their role independent of you all, of stakeholders, And really, they can't do their job well. They can't produce high-quality accounting standards without meaningful input from investors, preparers, auditors, and even sometimes lawyers. So I would highly encourage you all to engage in their standard setting process. I would also note my belief that the most effective engagement with a standard setter is an approach that, that provides constructive feedback to address the need. So in the case of the FASB, identifying what the investor need is for additional information or better information, and coming up with a way to solve that issue in a way that is most cost-effective to provide timely information improvements to investors. So just to name a few projects that the FASB has finalized or issued recently, starting with a proposed ASU or accounting standards update that they issued the middle of last year regarding the disaggregation of income statement expenses. This is a significant project. It's gained a lot of attention, especially by registrants, and in particular, registrants with manufacturing operations, in part because it would require, the proposal would require disaggregation of income statement line items related to inventory and manufacturing activities, in addition to disaggregation of income statement line items with things like employee compensation, depreciation, amortization. So the FASB received a lot of comment letters on that proposal, held a public roundtable late last year, and are continuing redeliberations, and as always are looking for feedback from stakeholders to move that forward effectively. A few other projects that are top of mind for us, late last year, they finalized standards related to the accounting and disclosure for crypto assets, which would or will result in many crypto assets being recognized at fair value on the balance sheet and through the income statement. A update to income tax disclosures, increasing the disaggregation of income tax disclosures in the footnotes, and segment reporting, which I mentioned earlier. That segment reporting guidance is intended to provide additional segment information to users, particularly significant segment expenses that meet certain criteria will be disclosed in the footnotes. I know, and that standard is effective for this calendar year at year end, not the interim periods, but on a retrospective basis for all periods presented. Sarah, I know that we've worked together a lot on segment-related issues, so interested in your perspectives, if you have any observations, either on the existing segment requirements and comment trends that you've seen there, or on the new standard recently issued?
Sure. So I think in terms of current comment trends, segments definitely continues to be one of our top areas of comment. We see a lot of comments that are related to segment identification and aggregation. And this past year, we've had consults also on disclosure items, specifically revenues from external customers, and how those specific line items disclosure must comply with GAAP. So I think that's just, again, something kind of to keep in mind on the trend. But if we shift to the ever-popular ASU, in terms of the adoption of that, some just kind of key things that we wanted to make sure we clarified. In addition to the segment measure determined in accordance with the measurement principles most consistent with those used in the consolidated financial statements, that's always a mouthful, public entities are not precluded from reporting additional measures of a segment's profit or loss that are used by the CODM in assessing segment performance and deciding how to allocate resources. So the ASU does not mandate that the additional measures of a segment's profit or loss must be calculated consistent with GAAP. And as a result of this change, additional measures of segment profit or loss that are not consistent with US GAAP are not precluded from being reported in the notes to the financial statements under the amended standard. Now, the SEC non-GAAP rules specify that the definition of a non-GAAP measure excludes financial measures required to be disclosed by GAAP. It's a little confusing. Commission rules or a system of regulation of a government or governmental authority or self-regulatory organization that is applicable to the registrant. So that language in the new ASU is that additional measures of the segment profit or loss may be reported in the financial statement footnotes. Again, not that they are required to be. And so accordingly, the SEC rules consider such additional measures of segment profit or loss not calculated in accordance with the consolidated financial statements as non-GAAP financial measures subject to the non-GAAP regulations, rules, and guidance. So based on the new ASU that permits the additional measures in the footnotes with no requirement that they be calculated consistent with US GAAP, OCA and CorpFin expects that some registrants may disclose non-GAAP measures of segment profit or loss in their audited financial statements. However, please remember these measures need to be regularly reviewed and used by the CODM to allocate resources and assess segment performance to be disclosed. If a company is considering early adoption of the new standard and intends to disclose those additional measures of segment profit or loss that are non-GAAP measures in the footnotes to its consolidated financial statements, we encourage you to come talk to us about the SEC staff's expectations related to the disclosure in your fact pattern. And registrants can reach out to CFOCA via one of the methods noted on CorpFin's Contact Us page on the sec.gov website, and our non-GAAP team will be the point of contact for those discussions. Now, we would expect that any measure a company would want to disclose would comply with our Regulation G and Item 10E of Regulation SK as it relates to 1, not being misleading non-GAAP measure, and 2, the disclosures required by non-GAAP rules. For example, a registrant would need to provide a statement disclosing the reasons why the non-GAAP measure provides useful information to investors regarding their financial condition and results of operations. And lastly, for clarity, a company would be fully compliant with US GAAP and the new ASU if it presented the one required segment measure of profit or loss, which is the one most consistent with US GAAP and no other additional measures.
Thanks, Sarah. So if I understood that, the one required measure, nothing really changed there.
Correct.
It's still required, still not subject to our non-GAAP rules. I guess the new standard did clarify that for single segment entities, they are required to comply with all the segment disclosures, so they would have to comply. But then if an entity chooses to present additional measures, that's when they would be subject to the non-GAAP rules.
That's exactly correct.
And I guess if from my perspective, I would expect that a company that has a single operating segment entity that's managed on a consolidated basis, that one required measure would be net income. So then any additional measure that they would choose to present would be subject to non-GAAP rules.
Yes.
Maybe sticking with non-GAAP, like I said, that's a perennial favorite. Anything that you'd like to highlight with respect to recent comment trends in the non-GAAP space?
Sure, there's a few things. I think maybe just taking a step back, why does this continue to be a top area of comment? And why do we continue to speak about it consistently is really a few things. One is because it's one of the most frequent areas of comment. The second is that registrants, analysts, and investors appear to rely increasingly on these measures. And these measures can present an overly optimistic picture of profitability in some cases. We want to make sure that that's avoided. And finally, because there's no comprehensive basis of accounting for non-GAAP measures, they may be less reliable and consistent compared to those prepared and disclosed in accordance with GAAP. So again, those are closely looked at. Now, back in December 2022, we made a few updates to our CD&Is related to non-GAAP, and we've been fairly happy that the feedback we received has indicated that the changes that we did make have prompted preparers to consider whether their non-GAAP measures were complying with the non-GAAP disclosure requirements, kind of taking that fresh look and just reassessing from that perspective. So I'm not going to touch on all those updates that we made, but there are just a couple of areas that I wanted to elaborate on a little bit. You may recall that wording was added to the first non-GAAP C&DI that provides an example of a misleading non-GAAP measure in the form of a measure that is adjusted to exclude normal recurring operating expenses, and the revisions describe how these types of expenses are evaluated by the staff. So just as a reminder, the factors that are considered in analyzing whether an adjustment relates to a normal operating expense include how it relates to the company's operations, revenue-generating activities, business strategy, industry, and regulatory environment, to name a few. And for operating expenses considered to be recurring, the related amounts may be incurred repeatedly or occasionally, including at irregular intervals. So the staff may comment on non-GAAP measures that exclude items that appear to be normal recurring operating expenses from a performance measure, such as increases to allowances for receivables and inventory, startup costs, and loss on purchase commitments. Now, of course, those are just examples, and individual companies' facts and circumstances continue to drive our overall comment decisions. And I think one thing, again, here to just note in terms of past statements that we've made is we've referred to an example where a retailer incurs costs to open new stores as part of their normal operations and growth strategy on a recurring basis. I think it's worth noting that the thought process applied in this type of fact pattern is not solely relevant to companies that operate retail stores. We've seen companies in different industries make similar types of adjustments that are also deemed to be inconsistent with our non-GAAP guidance. So for example, we commented on a few companies that operate medical centers to provide healthcare and related services that make similar adjustments to their non-GAAP measures for costs incurred prior to the opening of new locations. These companies viewed these as one-time costs for each individual location. However, as our 2022 revisions to the C&DI noted, this division staff look at costs for the registrants as a whole, not just for each individual location. So in this fact pattern, the staff observed that the comment process and discussions with the companies that the costs for those opening of the new locations are often incurred ultimately as a part of the company's normal operations and broader strategy to generate additional revenue. And as a result, that led to, again, in this specific fact pattern, that these costs were inconsistent with the non-GAAP guidance. Okay, so moving on to tailored accounting principles. This was CD&I was revised in 2022 to explain that all non-GAAP measures with adjustments that change GAAP basis recognition and measurement principles may be misleading, not just those non-GAAP measures related to revenue. So for example, staff have commented on companies presenting a non-GAAP performance measure with adjustments that change the accounting for inventory to an internal basis used by management that would not be permitted based on the application of GAAP in a company's consolidated financial statements. Although it's one of the examples of potentially misleading measures mentioned in the CD&I, we do continue to frequently see non-GAAP revenue measures that deduct transaction costs as if the company acted as an agent in a transaction when gross presentation as the principle is required by GAAP. Okay, so those again were the two things there related to the CD&Is. Before we move on to other topics, though, just a couple of quick other reminders, because I'm sure, again, at the end of the day, everybody just wants to know, how can you help your company, or if you're advising a company, how can you help reach a quick resolution if you receive a comment letter on a non-GAAP item? So oftentimes, our comments are issued to better understand the non-GAAP measure or the individual adjustments, and it's really about, again, understanding why are these included, inputs to the adjustments, and what the company is trying to actually communicate to the investor with the non-GAAP disclosure. We appreciate that this information is often very clear to the registrant itself, but it's not always clear to those who are not involved intimately with the business. So at times, it takes multiple rounds of comments and responses and sometimes phone calls before the staff really has a clear understanding of the measure and the related adjustments. So that's why a thorough and clear response to the initial comment is our recommended approach. It ensures the right individual, and secondly is to just really make sure that the right individuals have reviewed the responses that are sent in, including not just those at the company that are most familiar with the non-GAAP measure, but also making sure that you have the right advisors. Although historically these measures have fallen outside of the financial statements, it's often can be helpful to involve your auditor as well. Because they have the experience of seeing similar comments across a variety of clients, so they can often also be a useful resource. So without a doubt, one of the most important pieces of advice that I can leave you with is if you are in an advisor role or responsible for preparing non-GAAP measures, is just again to ensure that each adjustment is appropriately labeled, the company disclosures are clear, transparent, and easy to understand for everyone, especially investors. And these disclosures should be prepared with the goal of providing investors with the information they need to understand the nature of the non-GAAP measure presented and why adjustments are being made in the reconciliation from the comparable GAAP number. I'm sure you see a theme there. So the staff understand how important it is for companies to communicate effectively and efficiently with investors. And we often hear that non-GAAP measures are just as important part of the story for many companies. But from our view, again, it's just as important to present measures that comply with SEC rules, especially as the nature of non-GAAP measures become increasingly complex.
So you mentioned compliance and telling a story. I think it's important to remember that financial reporting is principally a communication exercise, not just a compliance exercise. And so whether you're thinking about non-GAAP rules, financial statements, disclosures outside of the financial statements, always keep in mind the objective of your financial reporting, that you're really trying to communicate something meaningful and material to investors.
Yes.
Those are great reminders on communicating effectively and efficiently with investors. Ryan, maybe we can shift to you a little bit to continue that discussion from an enforcement perspective, and especially interested in how you think about communication to investors and how that might intersect with some of the cases you've seen on internal accounting controls.
Sure. So, Jonathan, you talked about some of the potential changes that are coming to financial statements and how that's going to benefit investors. And Sarah talked about non-GAAP measures, and notwithstanding the new ASU, those are usually included in places besides the financial statements. And there are important distinctions between where information is communicated to investors and how. And I think even some people in this room like to point out that geographical distinction to us in enforcement investigations. And I don't think anyone in the Division of Enforcement dismisses those points. But I do, as Jonathan was saying, think it's important to once in a while just step back and really think about and remember why we're here, which is to provide information to investors so that they can make investment decisions. And wherever that information is in the total communication package, it's really important that it's right. I think that if you sat down and you read a bunch of commission enforcement orders, particularly in the financial reporting and disclosure space, one of the overarching themes that might emerge to you is that so many of our cases really come down to an inconsistency between how a company views something internally and what it's communicating out to investors. And sometimes that communication failure is intentional. And in those cases, I just want to say unequivocally that has absolutely no place in our markets. If you think that's just the enforcement guy sitting up on the accounting panel trying to act tough, I just want to ask you to rethink that, because I don't think anyone in this room should think that that's a controversial statement. Let me say it again. Intentionally communicating information to investors in a way that's inconsistent with how that information is viewed internally has absolutely no place in our markets. But I also know that not every time that there's an inconsistency or a failure in communication that it's intentional. But that doesn't mean that investors aren't harmed. And whether a communication failure is intentional or unintentional, Another theme that you would find if you look through a lot of our enforcement cases is that there were insufficient systems to ensure that information getting to investors is correct. And now I'm going to deliver on my promise earlier to say it's not just about the gatekeepers, it's also about the gates. We're focused on the gates, but I also want you to know that we are thinking about the gates in a thoughtful way. And I want to just quickly delve into a few concepts. First, we're focused on issuers' requirements to devise and maintain a system of internal accounting controls, and this arises from Section 13B2B of the Exchange Act. And I'm a non-attorney, but I really do love talking about the Romanettes in the statute. So Romanet 2 is probably the one I think about most often, which is the requirement that public companies have internal accounting controls necessary to prepare financial statements in accordance with GAAP. And there are some great examples of our focus on these cases over the past year. I think that, some of these matters, like the matter against Fluor and 5 of its executives that also had material misstatements, but there are other matters that didn't have a material misstatement. There was a settled matter against RBC from November that was an alleged internal accounting control violation with respect to the bank's systems for preparing IFRS financial statements. But Romanet 2 doesn't stand alone. If you look at 13B2B, there's Romanet 1, which requires internal accounting controls to provide reasonable assurance public companies only engage in transactions authorized by management. And there's also Romanet 3, which requires public companies to provide reasonable assurance for the access to the public company's assets is only permitted in accordance with management's authorization. These are really important requirements because they speak to management's stewardship of the important assets of a company. There's a settled matter against Charter Communications. This was from the past fall. The commission alleged the company engaged in share buyback transactions that were not authorized by the company's board. And then I know that many in this room have probably been closely following the SolarWinds matter. That matter is litigating, so I generally refer you to the commission's complaint for those details. But I first want to be clear that the commission's complaint alleged a fraud. The company's public statements were at odds with what it understood internally. Again, this is not a novel theory. We're going to pursue companies and individuals who make material misstatements, even about their cybersecurity practices in other places. But in addition to the fraud charges, the complaint also alleges that there were failures related to the company's internal accounting controls that were meant to safeguard important assets of the company. And that next brings me to 2 other important sets of gates that investors rely on to ensure that the communication they receive from a company is correct. The requirements to maintain and evaluate internal control over financial reporting and disclosure controls and procedures, and those arise from Rule 13A15 of the Exchange Act. These requirements to maintain these systems really provides critical protection for investors. Sarah talked a lot about non-GAAP measures, which would be in the scope of DCP if they're included in filings to the commission. And we're focused on non-GAAP measures because investors are focused on non-GAAP measures. This is information that management is choosing to communicate to investors, so it's a reasonable expectation that it would be correct. And when that information in a filing is materially incorrect, not only is it a violation of Section 13A and Reg G, but it also illustrates that there's a problem with that company's process for communicating information to investors. The division has been active in this area. I would anticipate we're going to continue to be active in this area. If you're interested in this area in more detail, I would point out a couple of cases that I found important. For non-GAAP matters, the Newell Brands case from September of 2023 and the DXC technology matter from the previous March. For other DC matters, I'd recommend taking a look at the First Guarantee bank shares matter. That was a case from May of 2023. And then the View matter, which we've mentioned a couple of times from this past July, that also contained accounting misstatements. And while I didn't talk a lot about ICFR, I'd also just point out that we're active in that area too, and I would check out the Plug Power matter from August and the GTT Communications matter from September.
Thanks, Ryan. And just for the record, I think you're tough, especially when talking Romanettes. Moving down to you, Jensen, you mentioned that you all deal a lot with investment company status. I know that that's an issue that a lot of us collaborate on a lot, especially between you and CorpFin, when a registration statement comes into CorpFin and there may be a question about 40 Act status or investment company accounting. What key takeaways or types of questions have you considered recently in this space?
So, sure, and thank you. This is an area that we've seen an uptick in probably the last few years with respect to 1940 Act status questions. Primarily, the questions have come or stem from Chinese firm, VIE-related structures, as well as some entities that have exposure to real estate. As you mentioned, this is an area that we do collaborate across divisions, as these are often routed to our division from CorpFin to determine whether there are any implications from an investment company standpoint for certain registrants. And we collaborate internally as well with our own chief counsel's office as they look through it more so through a legal lens. But to provide a little bit of background on the Chinese firm VIEs, for those who are not familiar, generally these structures are organized through offshore holding companies, which in turn have a series of agreements with underlying businesses in mainland China, which is organized as a VIE or a variable interest entity. Now, as a result of these agreements, the offshore holding company becomes the primary beneficiary of the VIE and therefore consolidates for GAAP purposes, and that's sort of the key. So from an investment company standpoint, this does matter, as these structures can raise questions from a 40% test standpoint. That is Section 3(1)A)(C) of the Act, which, for those of you who don't know, it requires issuers with greater than 40% of their holdings in investment securities, they would be investment companies. So the consolidation of these VIEs is it has important implications for the status as an investment company or not. So that's one area. Another type of entity that we have seen similar questions raised on the topic is, as I mentioned, real estate entities. And while investment company status consultations have focused, the requirements primarily focus on the 40% test, this also takes more of an accounting lean in terms of are they following the right accounting framework, which is ASC 946, which is the accounting framework for investment companies. So I share this mostly just to demonstrate that there are multiple layers, both legal and accounting, that impact these 40 Act status questions. And now you've heard us say this a number of times before, I'll say it again, but each consultation that we see is pretty unique. They're all like snowflakes. But one aspect that sort of across the board raises a number of questions on our end is the definition of cash for the purposes of assessing the 40% test, which if something is determined to be cash, it is disregarded for the purposes of the 40% test. So this definition is very important. I think the thing to note here is that what constitutes cash and cash equivalents from a GAAP perspective doesn't always align with cash for purposes of the 40% test. So it's something to keep in mind. I know it sounds sort of like a novel issue, but we have seen quite an uptick in recent months, or recent years. So I'll pass it back to Jonathan.
Yeah, you mentioned consultations are all unique. I share that sentiment. We get a lot of accounting consultations. Also, they're all unique, but some of them do relate to scoping of the accounting guidance for investment companies that you mentioned in ASC 946 that requires fair value accounting for investments. And so, yeah, we'll get questions in. Obviously, your group and our group work closely together on those issues. But just as a few reminders for this group from an accounting perspective, when we get those consultations, and I won't get into any detailed fact patterns that we've seen, but we have seen issues where certain non-40 Act funds are investing in non-financial assets. And the question is whether they meet the criteria in US GAAP to qualify for that industry-specific guidance on fair value accounting. And I just think that it's worth noting that for the fact patterns that we've seen, while there's no individual factor that's determinative, there are some trends and takeaways. I think anybody who's addressing one of those issues, feel free to come talk to us. I think it's always important to perform a very robust analysis that's specific to your facts and circumstances. And so again, we're always available for pre-filing consultations on those or other accounting matters. Maybe shifting gears a little bit, I want to talk about another matter where I know that Jensen, you and Sarah as well have continued to spend quite a bit of time on, and that's that in 2020, the Commission issued amendments to the rules on financial disclosures about acquired and disposed businesses. So changes to the significance tests in the definition of significant subsidiary and the financial disclosure requirements in SX for acquisitions and dispositions of businesses, including real estate operations and investment companies. And I think specifically, among other matters, the amendments included changes to Rules 305 and 314 of SX and added new 611 to SX as well. So Sarah, maybe starting with you, 305, 314, or other issues, have you seen any trends in, say, waiver request volume in this area, and any observations you have for this group on the significance tests?
Sure. So I guess in terms of some trends, waiver volume has generally been lower due to the 2020 amendments as it relates to Rule 305. And the recent requests that we've received tend to be more, I guess the downside is that the requests that we are receiving now are more complex fact patterns involving multiple considerations within the request. With respect to Rule 309 and 314, we do still get some waiver requests. They also tend to be more one-offs based on particular facts and circumstances. So I guess maybe, for a moment, just turning for a moment on how do we evaluate these requests when the waiver requests under Rule 313, when we get the request to omit some or all of the required historical financial statements, as well as requests to substitute alternative periods or content, we evaluate requests using the total mix of information related to the company and their transaction. So this total mix of information includes both components of the income test, and it will often include various other financial statement measures and operating metrics. So we consider all relevant facts and circumstances regarding the size of the acquisition relative to the registrant size to determine whether a test result is anomalous or if a substitution may be appropriate. And in order to make that determination efficiently, it's again helpful for us to receive a request letter that is as complete as possible with respect to the relevant facts, circumstances, and analysis. Incomplete letters result in more follow-up questions from the staff, and they may slow down the ultimate process. Transparency is key. Please be clear about what happened in the past leading up to the acquisition. For example, was there a recent merger or formation transaction? And providing sufficient details about the current transaction and its expected impact to your business. Lastly, please also provide the results of all significance tests, including both components of the income test and how they were calculated, including inputs to the tests and where they were derived from, if that's not straightforward. So focusing on the significance test, a reminder to share here is when you're using the significance tests to determine whether another entity's financial statements need to be included in an SEC filing, these relate to acquisition of a business under Rule 305, but they may also apply again to the real estate acquisitions under 314 or the equity method investments under Rule 309 as applicable. So the financial statements used to determine significance are not required to be audited. However, those financial statements and the amounts used in the test must comply with US GAAP or IFRS as applicable. Specifically, a registrant that files its financial statements in accordance with US GAAP must use US GAAP financial statements for itself and non-registrant to determine significance, even if the other entity is foreign and its financial statements are in accordance with IFRS. So similarly, a foreign private issuer that files its financial statements in accordance with IFRS as issued by the IASB must determine significance then based on IFRS. Moving on to the investment test, a couple of reminders there. First, when it relates to an acquisition, the numerator is investments in the advances to the acquired business, and investments in means the consideration transferred measured as of the acquisition date, which includes 100% of the consideration transferred to acquire the business, the fair value of all contingent consideration if required to be recognized at fair value, and if required by GAAP or IFRS, or if contingent consideration is not required or recognized as fair value, all of the contingent consideration must be included unless the likelihood of payment is remote. And lastly, acquisition-related costs if GAAP or IFRS requires capitalization, such as related to an acquisition accounted for as an asset acquisition under U.S. GAAP or the purchase of an entity method investment. However, consideration transferred excludes acquisition-related costs that are expensed under U.S. GAAP or IFRS and the carrying value of assets transferred by the acquirer to the acquired business that will remain with the combined entity after the business combination. Okay, second, the denominator is determined using the average aggregate worldwide market value calculated for the last 5 trading days of the registrant's most recently completed month prior to the earlier of the announcement date or the agreement date of the acquisition. So the market value must be from a public market, even if it is a foreign market, if that is the market where the equity is traded. And the market value is of the common equity, whether voting or non-voting, and whether held by affiliates. It does not include preferred stock, even if it's convertible into a class of common equity that is traded on the public market, and common stock that is not traded on a public market, but is exchangeable for a share of common stock that is traded on a public market. So if the registrant does not have an aggregate worldwide market value, that total assets as of the end of the most recently completed fiscal year must be used in the investment test. Alternative valuations, such as valuation in anticipation of an IPO or net asset value, are not permitted as a substitute for aggregate worldwide market value. And the last thing I want to share on waiver requests is there is a circumstance where a waiver is not required. That is, separate financial statements of the acquired business are no longer required once the business has been included in the registrant's post-acquisition audited annual financial statements for either 9 months or a complete fiscal year, depending on the significance of the acquisition. So if a company seeks to meet the post-acquisition audited annual financial statements requirement with a combination of audited periods outside of its annual fiscal year, they would need to make a substitution request to CFOCA. Moving on, just lastly, I know we're getting short on time here, is interpretive requests. Just a reminder that when we receive interpretive requests about a company's assessment of its predecessor prior to initial registration statement, as an example, we've also received other letters related to the interpretation on the definition of a business under 1101D of Regulation SX. And so a few reminders there, just the definition of a business under Regulation SX differs from the U.S. GAAP or IFRS definition. It is reasonable that a transaction may be accounted for as an asset acquisition under U.S. GAAP, but for financial reporting purposes, that same transaction is a business under Regulation XX that requires audited financial statements of the acquiree if significant. And secondly, the definition of a business under Regulation SX does not include a requirement that the business generates revenue. That is, a pre-revenue entity, such as in the biotech or technology industry, may meet the definition of a business for financial reporting purposes and require audited acquiree financial statements under Rule 305 if significant.
Thanks, Sarah. I think that means that you're up, Jensen. I mentioned new SX Rule 611. If you could share some thoughts, explain it to us as if you were explaining it to your mother.
Who might be listening?
Who might be listening, thanks to this being available on our
This is
website.
available on our
And to
website.
make it easier on you, I will just assume that your mother is a securities lawyer.
That's a fair assessment, fair assessment. Just to go back, it is a new rule, and this was really helpful for investment companies, because prior to the adoption of Rule 611, IM registrants really applied sort of the general requirements of Rule 305 as sort of, we refer to them sort of like guideposts for these transactions. And similar to what Sarah mentioned, there were a lot of waiver requests that we got. And they were very facts and circumstances, took up a lot of the staff's time. I could say thankfully that doesn't happen as frequently as it used to. We would also get a lot of relief requests for Rule 309 and 408G of SX because of the way the significance tests were written. Ultimately, while not authoritative, it was at the time the staff's position that for investment companies that were purchasing portfolios of securities or investments from private funds, that what the registrant had to file was multiple years of audited financial statements prepared in accordance with SX, which is different than what a private fund would normally have to provide, and an audited special purpose schedule of investments to be acquired. So when 611 was adopted in 2020, it was primarily done to address the needs specific for investment companies. Just to provide some disclosure obligations for acquired funds and provide sort of a facts and circumstances analysis to capture sort of all of the situations where additional disclosure about fund acquisitions is appropriate, sort of regardless of the legal form that the transaction might take. So whether you call it a merger, acquisition, consolidation, asset sale, you still arrive at the same framework. In addition to the amendments that were made to the significance test that address specifically for investment companies and BDCs, so on the investment company side, this was, again, very helpful rule. Not a lot of this is all eye-opening, but hopefully just a quick recap. I'll put a quick plug out there, though, because we do still get some questions on this. In the rare case that folks believe that a particular transaction does not trigger the requirements of Rule 611, we're always happy to talk. We're not scary regulators. Just please pick up the phone and reach out to us. We will likely still request that something is disclosed, but we also need to hear these unique fact patterns that you have. Chances are, I mean, I will say that there might be a hybrid approach to be found in there, but there is no form or transaction type that will absolve you of making any sort of disclosure that is applicable to investors. So understanding sometimes these can be cumbersome, but at the same time, we're going to try to make sure that investors get what they need to make informed decisions. I will say we received a question regarding the disclosure requirements of a closed-end fund recently, purchasing a private fund that fell under 3C, 5C, and you do not need to know what 3C, 5C is. I will just say that 3C, 5C entities were not included on the adopting releases list of entities that would be part of this rule. And I think unfortunately, the list, maybe we didn't make it clear enough that it was a non-exclusive list of examples for folks. So just to be clear, the way we wrote the rule was facts and circumstances and intended to be as broad as possible to capture as many fund transactions that exist. So with that, I'm actually going to turn it back to Jonathan really quick.
Yeah, and I'd like to get back to you, Ryan, to talk about some audit issues, but maybe, sorry, before we do, anything else from an IM perspective that you wanted to hit at a high level?
Sure. I think just a couple of quick hit reminders. First is as it relates to change in auditors, when there is a change in auditor, the staff will ask for consent of both the current and the predecessor auditor included in the 485B pause filed after the change occurs. Recently, we've seen changes in auditors, and our team has seen a handful of instances where folks are missing the consent from the predecessor auditor. So just as a reminder to check out the handy December 1998 Dear CFO letter, which is now referred to as Dear CFO 1998-04 in the Accounting Matters Bibliography. If you're interested, you can just search for that online. Is very helpful, but I would also just, as a quick reminder, keep track of the consents. I would say the last couple notes here is on RIC tax matters. I'll try to make this quick. We've seen an increase in funds that are gaining exposure to asset classes that generate non-qualified or bad income, but they're failing to consider the relevant tax ramifications of that. I would say the best reminder for this is that all of these transactions or all of these new asset classes for certain fund types can be complicated. Make sure to have the right people at the table. Make sure to engage your tax experts early, throughout, and make sure that they're overseen appropriately by the investment advisor if that's who's doing the oversight. And then the very last is overissuance of shares. It's probably not something that people think about very frequently because shares are generally just authorized and there's an unlimited amount or very, very large amount. But there are accounting implications if the overissuance of shares is not authorized. It could result in different treatment of the overissuance as a liability rather than equity, which for investment companies, the ramifications there are quite significant. So apologies for running through it quickly, but trying to make sure that we have enough time for the group.
No, I appreciate that. And maybe going back to you, Ryan, sticking with the theme of gates and gatekeepers and their importance, any perspectives you'd like to share or highlight from an enforcement angle with respect to auditors or auditor independence?
Sure. Sure. So, I spoke at the earlier panel about the many individual cases that the division has brought related to auditors not meeting their professional standards. Obviously, hopefully the takeaway was that we plan to continue that focus. Certainly in the issuer and broker-dealer space, we continue to coordinate with the PCAOB, but I also want to point out that we continue to focus in other areas like the private fund space where audits are used to comply with the custody rule and audits of municipal advisors as well. And we're going to continue that focus on individual gatekeepers, meaning the engagement team members who fail to meet their professional obligations. But this is also a situation where it's not just about the gatekeepers, it is also about the gates. And in this context, it's about the firm's system of quality controls, or QC. And anytime we're looking at any single audit engagement, we're also looking at the firm's QC environment. And I know that kind of sounds ominous, especially to people that might be here from the defense bar, but I really want to be clear that a strong QC environment is just as likely to limit the scope of what we're looking at as a poor QC environment is to expand that scope. I think we do see situations where there are really poor quality control environments, maybe more than we perhaps should. But we do also see situations where strong systems of quality control caught issues early, they provided support to engagement teams in the field, and they just generally protected investors by making financial reporting better. I think overlapping with the firm's QC environment is certainly the emphasis on auditor independence, which we are always focused on. The Commission articulates its qualifications for auditor independence in Rule 201 of SX. The point is that not just anyone can be an auditor of financial statements for a public company. It's a valuable franchise and it comes with high expectations. There's going to be an enforcement panel plug for this afternoon. Glenn Gordon is going to talk more about the Prager-Metis matter, but that was an enforcement matter that alleges over 60 engagements at this firm included indemnification provisions that prevent the firm from being independent. And I think an important aspect of this case is that this issue was brought to the attention of the firm as problematic and they didn't do anything. And so I guess if the practical tip or takeaway for this audience is if you see something, say something. And also if you see something and say something, then do something about it. And the last thing I want to mention on auditor independence is a case that the Commission filed in February against Lordstown Motors. This was a SPAC. The case against the company involved misleading statements to investors about sales of its electric pickup truck, but at the same time that matter was filed, there was also an administrative proceeding that was settled, filed against the former auditor of the company, Clark Schaefer Hackett, for violating the independence rules. The story here was this auditor had done an audit pursuant to AICPA audit standards back when the company was private. During that engagement, it had assisted the company with preparing its financial statements and perform bookkeeping services. So when the SPAC transaction came around, they said, we're going to do an audit now purportedly following PCAOB standards, and we're going to claim that we are independent pursuant to Rule 201 of SX. The problem there is that 201 would say the audit firm is not independent if at any point during the audit and professional engagement period that auditor had provided non-audit services, including preparing financial statements or performing bookkeeping services. And so there are obviously some important messages coming out of this case. One, I think that firms who audit private companies that might one day go public need to be attuned to these important independence issues. And more broadly, I think that's applicable to everyone, is that once independence is impaired during the audit and professional engagement period, it can't be cured through additional procedures. There are no do-overs. So, Jensen, I don't know if you want to jump in on the
Yeah, I mean, I can do. Sorry, thank you. Very quickly, from an investment company perspective, you mentioned the custody rule. We have seen recently a handful of pooled investment vehicles where they're using or attempting to utilize the audit exemption under the custody rule, but they're receiving qualified opinions. From our standpoint, a qualified opinion on an audit will not satisfy the audit exemption within the custody rule. The rule states very, very clearly that the audited financial statements must be prepared in accordance with GAAP. So sort of any clear departure from GAAP or any material misstatement or a scope limitation would not meet the requirements set forth in the rule. So quick plug for custody rule.
Thanks, Ryan and Jensen. In a minute and 20 seconds, anything you'd like to cover on pay versus performance, Sarah?
Maybe just the top three things. Just one is, again, just a reminder that accountants actually play an important role in the drafting of these disclosures because the text of the release makes the link between pay versus performance disclosures and financial statement preparation clear. One other thing as it relates to company-selected measures and, again, just implementation of these items is that those company-selected measures must be derived from measures included in the financial statements. We've been seeing some that have not been. And lastly, just to plug again that I know there has been a lot of questions that have been asked related to these rules. So in response to the questions from preparers and advisors, an observed disclosure that had been provided by registrants and their proxies. We did issue 3 batches actually of CNDIs last year specific to this topic. The first came out in February, the second was in September, and there was a third tranche in November that was released. So if you are not familiar with those, I would recommend to take a look and just make sure, again, that you're clear on kind of some of the additional points that we laid out.
Perfect timing. Thank you, Sarah. One benefit of moderating is that I get the last word. So the second to last word, since you plugged a panel, I'll just shamelessly plug the accounting panel from OCA here on the front row. It's going to be excellent this afternoon. But really, thank you all. On behalf of Jensen and Sarah and Ryan, we all thank you for the opportunity to be here to share some perspectives with you today, and we hope that you enjoy the rest of the conference.
Thank you to the accounting panel, and we're now on a break until 2 o'clock. We'll see everybody back then for judicial and legislative panel.
All right, good afternoon, everyone, and welcome back. We'll now hear from senior staff from the Office of General Counsel. They'll discuss judicial and legislative developments with you. The panel will be led by Megan Barbero, the SEC's General Counsel. Megan joined the SEC in July 2021 and has been General Counsel since January of 2023. Before joining the SEC, Megan served as Deputy General Counsel for the U.S. House of Representatives, where she managed strategic litigation for the House. Prior to her work at the House, Megan served as an attorney for the U.S. Department of Justice Civil Appellate staff. Please consider the comments of these panelists. Over to you, Megan.
Thank you, Gurbir. One of the best parts of my job as the General Counsel is that the work of our office and our portfolio touches every part of the agency. OGC's 3 legal policy groups advise on all SEC rulemaking and enforcement matters. The General Litigation Group represents the agency in matters ranging from employment and labor relations to issues involving leasing and attorney disciplinary actions. And the office's Adjudication and Oversight Group assists in preparing commission orders and opinions in administrative proceedings and appeals from SRO disciplinary actions, as well as in congressional oversight and legislative matters. The members of our panel this afternoon are all part of the remaining branch of OGC, our appellate group. And for those of you who don't know, the appellate group represents the commission in appeals from district court enforcement actions, in challenges to commission adjudicatory orders and rules, and as amicus in cases that are non-SEC cases where the commission appears. The appellate group also works closely with the Office of the Solicitor General in all securities matters before the U.S. Supreme Court. I'm very pleased to introduce the members of that group who make up our panel today. To my immediate left is Michael Conley, the SEC's solicitor. The next 2 panelists are Donnie Frieda and Jeff Berger, who are both assistant general counsels. And to Jeff's left are appellate counsel Brooke Wagner and assistant general counsel Dan Staroselsky, followed by appellate counsel Archith Ramkumar and senior appellate counsel David Lasitsa. And rounding out our panel at the end down there are assistant general counsel Tracy Harden and senior appellate counsel Dan Matro. This is an exceptionally talented group of lawyers who have achieved great results for the agency and the investors and markets that we protect. Now I will turn it over to Michael to lead off our discussion of some of the many interesting legal issues that are before us.
Thanks very much, Megan. One of our recent cases that reached the Supreme Court is SEC v. Cochran, in which the Supreme Court held that a federal district court may hear a suit in which the respondent in a commission administrative proceeding seeks to enjoin that proceeding based on alleged structural constitutional defects. In that case, it involved the tenure protection of the SEC's ALJs. The case was consolidated with Axon v. FTC, which raised a similar question related to the Federal Trade Commission statutory review scheme. And we'll start, Donnie, can you give us some background on Cochran?
Sure thing. The case arose out of an administrative proceeding that the Commission instituted to determine whether Michelle Cochran, a certified public accountant, engaged in improper professional conduct in connection with her audits of publicly traded companies. After the winding road with the Supreme Court's Lucia decision, Cochran sued the SEC in federal district court in Texas, seeking to enjoin the administrative proceeding based on 2 constitutional claims. The first was that the tenure protection according to the SEC's ALJs violates Article 2 of the Constitution, and second, that the SEC's processes for conducting adjudications violate the Due Process Clause. The district court dismissed the case based on the Thunder Basin body of case law, but the en banc Fifth Circuit reversed.
And what did the Supreme Court ultimately decide?
The court held that the normal rule that an exclusive statutory review scheme for each agency that precludes a district court's exercise of general federal question jurisdiction does not apply when the claim challenges the agency's structure or existence.
And how did the court get to that point?
Well, the essential difference between this case and the Thunder Basin type of cases was the type of claim brought. Because Cochran and Axon in the FTC's case alleged that they were being subjected to an unconstitutional proceeding, which the court characterized as a here and now injury, the harm would be impossible to remedy once the proceeding was over and appellate review was available. The court likened this to the collateral order doctrine's treatment of immunity claims. Just as a party can immediately appeal from a denial of a claim that they, as of right, are immune from trial because that right would otherwise be lost, so would Cochran's ability to remedy the harm from being subjected to an unconstitutionally structured administrative proceeding be irretrievably lost if a district court were not allowed to exercise jurisdiction to review that claim.
Well, that strikes me as a fairly broad ruling. Did the court limit the scope of it in any way?
It did. The court numerous times emphasized that it was the nature of the constitutional claim as challenging the structure or very existence of the agency that allowed for these types of cases to proceed. Absent those type of extraordinary claims, the Thunder Basin approach would still apply.
Okay, thanks. And now moving on to Jarkissi, can you tell us a bit about that case?
Sure thing. George Jarkissi and his advisory firm controlled 2 hedge funds, and at the conclusion of an administrative proceeding, the commission found that he violated the securities laws by misrepresenting numerous material aspects of his firm's supervision of those funds. Jarkissi appealed that decision to the Fifth Circuit, raising only constitutional challenges to the proceeding. In a split decision, a panel of the court ruled in Jarkissi's favor on 3 constitutional questions, and the en banc court declined to review the decision.
And what were the 3 issues there?
Well, first, the court held that Congress had violated the 7th Amendment by authorizing the commission to impose civil penalties in an administrative proceeding. Second, the court held that Congress had impermissibly delegated legislative power to the commission by giving it the choice to seek civil remedies in either administrative proceedings or in district court. And the third holding was based on the same structural constitutional argument that Cochran raised in her district court action, that the statutory restrictions on ALJ's removal violated Article 2.
And did the government wind up seeking cert on all 3 of those questions?
Yes, it did, and the court granted the petition on all 3 questions presented.
Briefly, can you tell us what the SG's arguments were on each of those issues?
Well, on the 7th Amendment ruling, the SG pointed out that it was contrary to Atlas Roofing, a unanimous decision from the 70s in which the court held that Congress can assign the adjudication of public rights to administrative proceedings, even when such a claim would require a jury if it were brought in district court. As for the non-delegation argument, the SG pointed out that the doctrine simply doesn't apply since deciding where to bring an enforcement action is an executive and not a legislative function. You see, the so-called non-delegation doctrine applies where Congress has delegated its legislative powers to an executive agency and normally turns on whether Congress has provided sufficient guidance regarding an agency's authority to promulgate general rules governing private conduct. And finally, the SG argued that the ALJ's statutory removal protections do not violate Article 2, both because the ALJ's exercise of quasi-judicial functions does not violate Article 2, and that, in any event, an ALJ's good cause removal could be justified by a failure to follow precedent or to take supervision, and thus did not impede the President's Article 2 power.
So argument in that case was heard in November, and we're still awaiting the court's decision. Just as some sort of a view into it, did the court focus on any of the 3 issues in particular during the argument?
Yes, Michael, it did. It spent most of the argument discussing the 7th Amendment issue, a brief time on the ALJ removal issue, and I don't believe the non-delegation issue ever came up.
Okay, thank you, Donnie. Now we'll move on to another issue that's popped up in recent years after having lain dormant for many decades. And there's been increased interest in the way that the Commission settles cases through consent judgments. In particular, courts have been asked to assess the Commission's policy of requiring defendants to agree not to deny the allegations against them when they settle cases without admitting those allegations. And this policy is often referred to as the no admit, no deny policy. And Jeff Berger will discuss some recent litigation concerning the policy. And just to start us off, Jeff, can you tell us a little bit about the origin of that policy?
Thanks, Michael. The Commission adopted the policy in 1972, around the same time it adopted the rules setting out the Wells process. And as you suggested, in many instances, the Commission will agree to settlements without admissions. However, in such a no-admit context, the Commission stated in its 1972 policy that it will not agree to a settlement imposing a sanction unless a defendant also agrees not to deny the allegations in the complaint. So while a defendant need not admit, that the defendant also cannot deny without consequence. And this policy only applies when a defendant chooses to settle. The policy itself does not require settlements. Defendants are always free to litigate.
And so what's the purpose of this policy, and why did the Commission decide to adopt it?
Sure. It avoids situations where the Commission gives up its day in court, its ability to present evidence and obtain findings of fact, only to have the defendant publicly deny the allegations and then have the courthouse doors slam on the Commission. The Commission's unable to get back into court. So the objective of the policy is tied to the only relief available if the defendant breaches what is in essence a contractual agreement. The Commission can ask a court to basically abrogate the settlement and to give the Commission its day back in court, basically to return the parties to where they were. Now, whether or not a court grants that relief, whether it returns the case to its active docket, turns on multiple factors and would be left to the court's discretion.
And as I alluded to at the outset, for most of its existence, beginning in 1972, this no admit, no deny policy was fairly uncontroversial, and that changed in about 2016 when a defendant attempted to revive a very old case in the SDNY. Can you tell us what happened there?
Yeah, the case involved Barry Romero, who was the CFO of Xerox in the 1990s, and the Commission filed a series of actions, including against Romero in 2003, in connection with a massive accounting fraud at Xerox. Mr. Romero signed a consent and agreed to resolve the case in 2003. That consent contained a no-deny provision. Then in 2019, so 16 years later, Mr. Romero sought to alter the deal and, in essence, abrogate the no-deny provision while keeping all the other aspects of the settlement.
So I think we all know that final judgments, as a general rule, are supposed to remain final. What did Romero argue in asking for an exception to that general rule and requesting that the district court go ahead and line edit the consent that he had signed so many years earlier?
So Mr. Romero invoked Federal Rule of Civil Procedure 60B4, which concerns relief from final judgments, and that particular sub-provision authorizes relief from void judgments. And his argument was that the no-deny provision he voluntarily signed so many years earlier made the judgment partially void because, in his view, it violated the First Amendment by precluding him from denying the allegations in the complaint.
And how did the Commission respond to that?
Sure. The Commission argued that the motion, the 60B motion, should be denied for two reasons, one procedural and one constitutional. So first, the procedural. Under binding precedent, the word void in 60B is very narrowly construed, and it applies to two and only two possible situations. The first is a lack of jurisdiction, and the second is a particular due process defect, namely a lack of notice and opportunity to be heard. So the Commission's argument was that Romero had never argued that the district court lacked jurisdiction. He, in fact, admitted jurisdiction in 2003 and then continued to admit jurisdiction when he filed his 60B motion so many years later. And Mr. Romero had ample opportunity and notice to respond to the suit back in 2003, so there are no grounds on which to deem the 16-year-old judgment void for due process reasons.
And so that was the procedural argument. And what's the substantive reason that the commission offered for denying that motion?
Sure. First Amendment rights, like most constitutional rights, can be waived as part of a settlement. Defendants waive their rights all the time when resolving litigation. Think of plea bargaining, among other situations. There's no per se rule against knowing, intentional, and voluntary waivers of constitutional rights as part of a settlement. Rather, waivers are permissible, and if a government entity later seeks to enforce the waiver, courts can engage in a balancing of interests to determine whether to enforce the waiver. In this instance, Mr. Romero was represented by counsel. He was a high-ranking officer of a large corporate entity, and he made a rational decision to resolve the enforcement action against him via a settlement that contained a no-deny provision.
So how did the court wind up ruling on that?
So the district court agreed with the commission and denied the 6dB4 motion. Mr. Romero appealed to the Second Circuit, which affirmed. And the Second Circuit held that Romero could not use the Rule 6dB4 vehicle because he didn't identify any jurisdictional or due process defect that would render the consent judgment void. And the Second Circuit also held that there was no constitutional issue in any event because Mr. Romero had waived his First Amendment rights when he voluntarily agreed to the no-deny provision. After the Second Circuit denied a petition for rehearing, Mr. Romero sought Supreme Court review, and the Supreme Court denied cert.
And so this wasn't the only case, right, that challenged the use of no-deny provisions in commission settlements on First Amendment grounds. What were the other cases that raised a similar argument?
Sure. So the same attorneys who represented Mr. Romero also sought to revive a 5-year-old case in the Northern District of Texas called Novinger. And in Novinger, the defendant had settled in 2016 and filed a nearly identical motion as Romero did, making pretty much the same First Amendment arguments. And citing the same Supreme Court precedent about Rule 6dB4 and the meaning of the word void, as the Second Circuit, the district court denied the motion without reaching any of the constitutional issues.
So a similar path here in this case, the defendant appeals and the Fifth Circuit affirms. And what did the Fifth Circuit say in its opinion?
Sure. The Fifth Circuit unanimously held that Novinger had not presented any grounds for 6dB relief. Similar to the Second Circuit, the Fifth Circuit ruled that the defendant had not identified any jurisdictional defects, particularly since he had admitted jurisdiction and appeared in the action, in fact, litigating the case for about a year before choosing to settle. Moreover, the panel held there was no due process issue precisely because Mr. Novinger had received notice and an opportunity to be heard. Now, interesting, 2 of the judges on the panel signed a concurrence, agreeing with the 6dB ruling, but noting that the commission's use of the no-deny provision would likely face further judicial scrutiny in the future.
And so, in light of that concurrence, and likely spurred by it, Mr. Novinger tried an unusual procedural maneuver here, going back to district court and filing what was termed a motion for declaratory relief that essentially repeated the request for Rule 60 relief under a different banner. And so how did that fare?
Yeah, so the district court denied the motion, in essence holding that Novinger could not use a motion in an existing case to obtain what it was in essence a declaratory judgment about an existing judgment. Novinger appealed that district court ruling, and the Fifth Circuit rejected his arguments again in a decision that was issued just a few weeks ago. The court first held that it lacked jurisdiction to hear his appeal, and that even if it had jurisdiction, Novinger couldn't seek declaratory relief by filing a motion in an action that ended years earlier and in essence repeated a 6dB motion that the court had already rejected.
And so what's the current status of the no-admit, no-deny policy?
Sure. So the commission recently denied a petition for rulemaking that sought the elimination of the policy and confirmed that the policy is still in place. That petition for rulemaking was also filed by the same attorneys who represented Mr. Romero and Mr. Novinger. In its denial, the commission explained that the policy remains in effect and that the commission will not agree to a no-admit settlement unless that settlement contains a no-deny provision. Again, no defendant is required to settle with the commission, but if they settle on a no-admit basis, the commission may seek a voluntary waiver of rights as part of that deal. And for this waiver, there is that tailored form of contractual relief, namely if a defendant breaches by later publicly denying the allegations in the complaint, all the commission can do is ask the district court to rip up the deal and return the parties to where they were before. So if a defendant, in essence, wants to deny after settling, the commission retains the opportunity to test those denials in court pursuant to the rules of evidence and civil procedure. Last week, a group of petitioners challenged the rulemaking petition denial in the Ninth Circuit, and we anticipate that this appeal in the upcoming months will raise various constitutional and statutory issues regarding the no-deny policy.
Thanks a lot, Jeff. Next, we'd like to discuss a private securities fraud suit where we were recently asked to weigh in by the Second Circuit. That case, which is New England Carpenters versus DiCarlo, raises interesting questions about the audit certifications that are included in securities filings, and specifically about when an auditor's false claim to have properly conducted an audit may be material to investors. Brooke, could you start us off on this one by telling us a bit about the facts of the case?
Sure. As you mentioned, the case is a putative class action that primarily involves securities fraud claims brought by shareholders against the insurer AmTrust. They allege that AmTrust made certain accounting errors that caused it to overstate its revenue for several years before it issued restated financials and its share price dropped. But the plaintiffs also brought securities fraud claims under Section 10B of the Exchange Act against AmTrust's auditor, BDO, for misstatements in its audit certifications included in AmTrust's annual filings. BDO had issued unqualified audit opinions on AmTrust's financial statements for several years. These opinions included standard language in which BDO affirmed that it had conducted its audit in accordance with applicable auditing standards, and that its audit provided a reasonable basis for BDO to determine that AmTrust's financials were fairly presented. According to the plaintiffs, however, BDO lied in making these statements. Plaintiffs cited an SEC order finding that BDO's auditors had engaged in improper professional conduct by, among other things, failing to complete audit work on time, loading blank documents onto its system, signing work papers unreviewed, and failing to verify that all the necessary audit work was done before issuing the opinion. Given that conduct, the plaintiffs claimed, BDO did not comply with auditing standards, and its certification was materially false. They also alleged that the disclosure of BDO's misstatements in a Wall Street Journal article caused AmTrust's share price to drop.
Thanks, Brooke. That's helpful. And turning to Dan, can you give us an idea what happened with the claim against BDO?
Of course. So defendants moved to dismiss the claim in the district court, and the district court granted the motion. The court found that plaintiffs had failed to adequately allege materiality and loss causation. Now, on appeal, the Second Circuit affirmed on materiality grounds, holding that BDO's false audit certification was not material, at least as pleaded, as a matter of law. The Second Circuit's decision on this point essentially rests on two bases. First, the court said that BDO's certification was too general to be material, and it likened the statements to puffery. And second, the court indicates that a false audit certification must be tied to the particular accounting errors that infected the company's financials in order to be material. And so, because the plaintiffs failed to allege facts that directly linked BDO's misstatements to the material errors contained in AmTrust's 10K that caused AmTrust's share price to drop, the court concluded that plaintiffs failed to plead materiality.
And so, Brooke, what happened next?
So plaintiffs moved for rehearing, arguing, among other things, that the panel had overlooked factual allegations supporting the materiality of the false audit certification. And 3 former SEC accounting officials filed an amicus brief in support of rehearing, emphasizing the importance of the auditor's certification and urging the court to reconsider both prongs of its materiality analysis. Then the Second Circuit invited the Commission to file a brief providing its views on the arguments raised by amici, which we filed in February.
And what views did the commission share with the court?
Sure. So at a high level, we agree with amici that the Second Circuit's materiality analysis should be reconsidered. Audit certifications convey important information to the market, and the knowledge that a professional audit has been done affects investor confidence and decision-making, and investors would certainly care if they knew that a company's financials had not been properly audited. And given the high bar for finding a statement immaterial as a matter of law at the motion to dismiss stage, false audit certifications should generally suffice to plead materiality. We also agree with amici that both parts of the Second Circuit's analysis understate the significance of audit certifications to investors. First, audit certifications are not like puffery because they convey substantial and specific meaning to investors. And the fact that certifications use a standardized form helps enhance rather than diminish investors' understanding of that meaning. Second, we argue that a false audit certification need not be tied to errors in financial statements to be material. A false certification concealing a deficient audit subjects investors to increased risk, and it can thus matter to investors regardless whether the specific audit deficiencies resulted in misstated financials. Finally, we note that the court may have been seeking, in its opinion, to ensure that false audit certifications are sufficiently tethered to the actual harm suffered by plaintiffs. But we argue that other elements of the private right of action, such as reliance and loss causation, rather than materiality, offer recourse for that concern. And so we encourage the court to clarify its materiality discussion to reflect the value of audit certifications to the investing public.
Thanks, Dan. And can you tell us where exactly does the case stand now?
Sure. So right now we're waiting for a response from BDO on our position, and then the court will consider whether to grant rehearing or to clarify its opinion.
Thank you, Brooke and Dan, and we'll all look forward to seeing what the court decides. And now we'll turn to another Supreme Court matter in which the Commission has been involved. Last September, the Supreme Court granted cert in Macquarie Infrastructure Corp v. Moab Partners to decide whether failing to disclose information required by a Commission regulation can give rise to liability under Section 10b and Rule 10b-5. The case was argued in January, and I'll note, however, that this wasn't the first time that this precise issue came before the court. Jeff, can you give us a little information on that history?
Sure. So this is another case where the commission is participating as amicus in a private action. And the Supreme Court had granted cert to decide what was in essence the same question back in 2017 in a case called Leidos. But that case settled before oral argument, and it took several years for the issue to wend its way back to the court.
And so did Leidos and Macquarie involve the same regulatory disclosure requirement?
Yes, both these cases involve Item 303 of Regulation SK, which lays out what issuers have to disclose in the management's discussion and analysis of financial conditions and results of operations, what everyone seems to refer to as an MD&A, that's included in a 10K or a 10Q.
So that item 303, covers a lot of ground. What part of the regulation was at issue in these cases?
Sure. More specifically at this case, it's the part of Item 303 that requires issuers to describe any known trends or uncertainties that have had or that reasonably likely to have a material favorable or unfavorable impact on net sales or revenues or income from continuing operations. And the purpose of the MD&A in this provision in particular is to provide a narrative context to accompany the financial reporting in these forms.
And how did that requirement come up in Macquarie?
So the plaintiffs, the private plaintiffs, claim that Macquarie artificially inflated its stock price by disclosing some known trends and uncertainties, but failing to disclose an additional known uncertainty, in particular, that forthcoming international regulations would adversely affect a line of business regarding fuel storage and thus impact its revenues. The plaintiffs claim that this omission violated Section 10B because the information was material and because Macquarie had acted with scienter in omitting it.
And I think understanding the form of the action that was brought, it's helpful to realize that unlike the commission, private plaintiffs can't bring actions for violations of item 303 itself. But as everyone is aware, I'm sure, they can bring 10B claims, and in that context, there needs to be a duty to speak in order for an omission to be actionable. And the duty to speak can arise in a few different ways. A 10B claim can be predicated on the theory that was first set out in Basic v. Levinson, that silence or non-disclosure can be actionable under Section 10B, where there's a duty to disclose, such as under item 303. The court has also stated that when an issuer speaks, it cannot speak in half-truths. It must disclose information that would make what it said not misleading. And finally, the court has also discussed a duty based on common law, as in the insider trading context, where there's a relationship of trust and confidence between parties to a transaction, there can be a duty to disclose or abstain from trading. And that leads us to this case. So can you tell us why the Supreme Court granted cert and did so twice on this issue?
It's really because of a perceived circuit split. So the Second Circuit in Macquarie and Leidos and other cases held that an omission of information required by item 303 can give rise to liability under Section 10B when all the other elements of a private right of action are present. Now, the Third Circuit had also addressed this issue in an opinion by then-Judge Alito in a case called Iran. And Iran said that item 303 requires the disclosure of information that would not necessarily be material for purposes of Section 10B. So the court, in essence, concluded that a violation of item 303 does not automatically give rise to a material omission under Rule 10b-5 and Section 10b. But the court didn't foreclose the possibility that a violation of item 303 could be the basis for a private right of action. The Fifth and 11th Circuits reached similar conclusions, citing Iran, but the Ninth Circuit read that language in Iran as foreclosing any possibility that item 303 could create an actionable disclosure duty and held that an omission is actionable under Section 10b only if it fits into the half-truth rubric you were just talking about. An omission makes something that was disclosed misleading.
So the government, as we've mentioned, filed an amicus brief in support of the plaintiffs at the merit stage in both Macquarie and in Leidos. Consistent with what the Commission has said and done in enforcement actions and rulemakings going back at least 30 years, the government took the position that the disclosure of some, but not all, of the information required by item 303 fits comfortably within the half-truth rubric that we've been talking about. And if you think about it, I mean, it's based on the idea that an issuer is always speaking in a 10K, and a reasonable investor would expect the MD&A section to disclose all the required information. And if an issuer omits what item 303 requires, there is a misleading statement that may be actionable if the other required elements of a private action, namely materiality, scienter, and so on, can be established. And so you might think of it this way. If an SEC rule requires an issuer to identify every pending lawsuit against the issuer that's seeking more than $10 million, and the issuer lists 10 such suits, a reasonable investor would read the filing of that filing as a representation that the list is exhaustive. And so the failure to disclose an 11th suit seeking $20 million would in those circumstances be misleading.
Right, and then another way to look at it is that a duty to disclose just means a legal obligation to disclose, and a regulatory mandate plainly creates a legal obligation. Against the backdrop of such a disclosure requirement, silence then carries just as much meaning as an affirmative statement. So for example, if Congress required issuers to disclose any tender offer within 24 hours, a reasonable investor would understand an issuer's silence to mean that no tender offer had been made within the previous 24 hours. If the issuer had in fact received a tender offer, that silence is misleading. And if the issuer deliberately deceived potential investors by keeping that tender offer secret, and the existence of that offer is material, then that silence may be the basis for a 10B claim. It may be fraudulent.
And so based on the oral argument itself, were both of those theories discussed at oral argument, or did the court have a specific focus?
Yeah, the court really focused more on the half-truth theory. I mean, it kind of makes sense, again, because of what you were saying. There's a financial statement. There's always someone speaking. But I will say, as has happened recently with some of the securities cases that reached the Supreme Court, the dispute had really narrowed by the time of argument. Justice Kagan put it, in quotes, what everybody's arguing about is how narrow or how capacious we should understand the requirement that there needs to be another statement that's rendered misleading. So there's a lot of focus on the statement theory. And the plaintiffs and the government, which also had oral argument time, argued that the relevant statement is the MD&A, which is rendered misleading again by leaving out known trends or uncertainties that are likely to materially affect the company's financial condition. McQuarrie argued that plaintiffs, by contrast, have to identify a specific misleading statement that's like in kind. The justices pressed the plaintiffs and the government on the fact that in voluntary disclosure cases, courts typically do require the plaintiffs to identify more specific statements that are rendered misleading by the omission. And the government argued in response that the presence of the disclosure requirement of item 303 makes a critical difference. Because when you have a regulation calling for all information in a particular category, the omission of information in that category will necessarily be misleading. McQuarrie didn't really offer a test for what would constitute a sufficiently specific statement rendered misleading by the omission of information. But in response to some of the justices' questions, McQuarrie did agree that if a company says in its MDA that there are 3 trends that an investor should know about, and it only lists 3 trends, but it didn't list a more consequential 4th trend, that would satisfy the requirement of a misleading statement.
So McQuarrie argued that allowing for the possibility of 10B liability in these circumstances would open up the floodgates of private litigation under 10B for violations of disclosure requirements. Is McQuarrie right about that?
I think the floodgate notion McQuarrie floated is a bit overstated. The Commission has said for decades that a duty to disclose can make silence misleading, including in item 303 cases. And the Second Circuit has indicated as far back as 2001 that such cases were viable. But there's been no apparent flood of cases or litigation, likely because the necessity of pleading and proving the other elements, as well as the requirements of the PSLRA, serve as significant litigation barriers. The fact that alone that it took 6 years for this case to get its way back to the Supreme Court should be instructive about the full universe of cases out there. And in fact, in the 6 years between Leidos and McQuarrie, the Second Circuit dismissed item 303 based claims in all but 1 case, excluding McQuarrie.
Thank you, Jeff. Now we'll turn to Archith Ramkumar and David Lisitsa to discuss an 11th Circuit case that addressed dealer registration issues. As part of its enforcement of the securities laws, the Commission has brought actions against persons engaged in the business of purchasing and selling microcap securities. Those are stocks that have very low prices and thus are more amenable to being used in fraudulent schemes. And the purpose of those cases was to require persons engaged in that business to register as dealers under the Exchange Act. Defendants in those cases have responded by asserting that the Commission's position that they're operating as dealers is inconsistent with the Exchange Act. In February, the 11th Circuit issued an important dealer registration decision in the SEC v. Almagarby case. And Archith, can you start by giving us an overview of Almagarby?
Sure. The place to start is Section 3 of the Exchange Act, which defines a dealer as any person engaged in the business of buying and selling securities for that person's own account through a broker or otherwise. But individuals are excluded from the dealer definition if they do not buy and sell securities for their own account as part of a regular business. And this carve-out is colloquially known as the trader exception. So putting those 2 pieces together, whether or not someone is a dealer turns on whether that person is in the regular business of buying and selling securities. Al-Magharbi, through the company he established, acquired and sold billions of shares of microcap stock over a 3-year period. The mechanism Al-Magharbi used to acquire the shares is important. Al-Magharbi agreed to acquire the debt of microcap companies from those companies' creditors. In exchange, the companies entered into agreements allowing Al-Magharbi to convert the debt into shares of the issuer securities at a discounted price. The parties would not agree on a set number of shares in advance, but would instead set forth a fixed value that would determine the number of shares Al-Magharbi would receive. Once he received the shares, Al-Magharbi resold them on the public markets. He received over $2.8 million in proceeds from stock sales. Because of the fixed value feature I described above, arrangements like this one have been described as death spiral financing. Selling a large quantity of microcap issuer shares invariably drives down the share price, so a financier like Al-Magharbi, who negotiates to receive his discounted shares in tranches, receives more and more shares each time he converts. So eventually that cycle leads to the share price approaching zero, hence the term death spiral financing.
Thank you, Archit. That's helpful background. And can you tell us a bit about the lawsuit that the commission brought against Al-Magharbi and the arguments that he made on appeal?
Sure. The commission brought suit in district court, contending that Al-Magharbi, through his company, was acting as an unregistered dealer. The district court agreed and ordered Al-Magharbi to disgorge the profits he earned, entered an injunction permanently barring Al-Magharbi from resuming his dealer activity unless he registered, and imposed a penny stock bar preventing Al-Magharbi from participating in any future penny stock offering. On appeal, Al-Magharbi argued that he lacked fair notice of the risk of violating the dealer registration provision because, he claimed, the commission's interpretation was inconsistent with public guidance issued by its staff. Al-Magharbi also contended that neither disgorgement nor injunctive relief were appropriate remedies.
And what did the 11th Circuit decide in the case?
The 11th Circuit concluded that Al-Magharbi acted as an unregistered dealer and violated the Exchange Act. It reached that conclusion because its precedents established that acquiring new issues of stock for resale is traditional dealer activity. Applying those precedents, the 11th Circuit found that from both a qualitative and a quantitative perspective, Al-Magharbi was a dealer. Qualitatively, Al-Magharbi did not behave like a trader or ordinary investor because his goal was to turn his money around as fast as possible, and his profits resulted from the difference between the discounted price he paid and the market price at which he sold. This allowed him to avoid taking on price risk. The 11th Circuit also attached importance to the fact that by proliferating new shares in the marketplace, Al-Magharbi engaged in underwriting activity, which has long been a hallmark of someone who is a dealer. From a quantitative perspective, the 11th Circuit found that Al-Magharbi's transactions were both regular and voluminous. His business was based on the purchase and sale of securities for his own account, and over a 3-year period, he received 8.5 billion shares of stock while selling 7.6 billion shares, making over $885,000 in net profits. The 11th Circuit concluded its analysis by addressing a point made by a number of amici who filed briefs in support of Al-Magharbi's position. Those amici argued that dealers under the Exchange Act must effectuate customer orders. The 11th Circuit rejected that argument, finding that a customer requirement has no grounding in either the statutory text or dealer regulations.
Thanks very much, Archit. And David, I'm going to ask you to talk to us a bit about the 11th Circuit's remedies discussion, and in particular, how the 11th Circuit treated the disgorgement award that was at issue in the case.
Sure, Michael. The 11th Circuit first concluded that the disgorgement award was causally linked to Al-Magharbi's failure to register as a dealer, because under Section 15A of the Exchange Act, unregistered dealers are prohibited from effecting any securities transactions. And since Al-Magharbi was foreclosed from engaging in any transactions as an unregistered dealer, any profits he obtained from his prohibited transactions were causally linked to his failure to register. And in reaching that conclusion, the 11th Circuit rejected as impossibly speculative Al-Magharbi's argument that he could have engaged in the same conduct without registering. The 11th Circuit then also went on to find that the disgorgement award was for the benefit of investors because the Commission could identify the counterparties to Al-Magharbi's trades. And those counterparties were harmed by Al-Magharbi's conduct since the value of their shares plummeted when they were caught in his death spiral.
And what did the 11th Circuit have to say about the injunctive relief that the district court imposed?
The panel unanimously upheld the injunction preventing Al-Magharbi from transacting in securities without registering as a dealer, and noted that Al-Magharbi engaged in hundreds of unlawful transactions, and that he also operated additional business entities that were active and could allow him to resume his unlawful activity. With respect to the penny stock bar, however, the panel was split. 2 of the judges agreed to vacate the penny stock bar. These judges characterized Al-Magharbi's conduct as not egregious. They also credited Al-Magharbi's assurance that he would not engage in the same behavior without registering. But Chief Judge Pryor, who authored the rest of the opinion on liability, dissented from the penny stock bar determination. He would have upheld the penny stock bar because, in his view, the district court did not abuse its discretion in determining that the violative conduct that Al-Magharbi engaged in over a 3-year period was egregious. Chief Judge Pryor also explained the well-recognized principle that a defendant's promises to voluntarily cease misconduct are not dispositive in evaluating whether to order injunctive relief.
Thank you very much, Archith and David. Now we'll turn to Tracy Harden and Dan Matro, who will discuss a case pending in the 5th Circuit. Tracy?
Thanks, Michael. We're going to turn now to discuss a challenge to the Commission's approval of NASDAQ's board diversity rules. The case is currently pending in the 5th Circuit and is titled Alliance for Fair Board Recruitment versus the SEC. In October of 2023, a panel of the court upheld the Commission's approval of NASDAQ's rules, but the court has since granted rehearing en banc with oral argument scheduled in May. Dan, do you want to start by giving us a bit of background about NASDAQ's rules?
Sure. So in December 2020, NASDAQ filed with the Commission proposals to adopt listing rules relating to board diversity. The rules have several components. First, they require that NASDAQ-listed companies publicly disclose in aggregated form certain data on the diversity of their boards. Second, they require each NASDAQ-listed company to either have or explain why it does not have at least 2 members of its board who are diverse. And third, NASDAQ proposed to offer certain listed companies 1-year complimentary access to a board recruiting service.
So what happened before the Commission?
So the Commission approved NASDAQ's proposal in August 2021. Under Section 19B of the Exchange Act, the Commission must approve an exchange's proposed rule change if it finds the proposal is consistent with the requirements of the Act and regulations thereunder. And under Section 6B5 of the Act, exchange rules must be designed to promote specified objectives and may not regulate matters unrelated to the purposes of the Act. The Commission concluded that NASDAQ's rules were consistent with these requirements because they would provide widely available, consistent, and comparable information that would contribute to investors' investment and proxy voting decisions.
So who challenged the Commission's approval of the rules, and what did they argue?
The petitioners in the case are the Alliance for Fair Board Recruitment and the National Center for Public Policy Research. They raise constitutional, statutory, and APA challenges to the Commission's order. Starting with the constitutional arguments, the petitioners contend that the rules, NASDAQ's rules, violate equal protection under the Fifth Amendment because they encourage racial and gender discrimination. And they argue that the rules violate the First Amendment by compelling companies to disclose controversial information without adequate justification. As for their statutory claims, the petitioners contend that NASDAQ's rules are inconsistent with the requirements of the Exchange Act. Among other things, they argue that disclosure rules must be limited to material information, which in their view means having a demonstrable link to corporate performance. They argue that the materiality requirement is not met because the empirical evidence does not prove such a link, and because NASDAQ was merely responding to demand for board diversity information from a small number of activists.
How did the panel decision address the petitioner's constitutional claims?
So it did not reach them. In a unanimous opinion by Judge Higginson, the panel agreed with us that the rules are not subject to constitutional scrutiny because they are not state action. Applying the test from LeBron versus National Railroad Passenger Corporation, the panel concluded that NASDAQ itself is a private actor, not a part of the government, because it was not created by the government and its leaders are not chosen by the government. As a result, NASDAQ's rules constitute state action only if they are fairly attributable to the government. But the panel found none of the few limited circumstances in which private conduct may be so attributed present here. Exchange listing standards are not a traditional exclusive public function. The Commission did not compel or significantly encourage the rules, and the yes or no approval process for NASDAQ's rules falls short of the kind of pervasive entwinement between government and a private entity that leads to state action. The panel also rejected the petitioner's analogy to the Supreme Court's decisions in Moose Lodge versus Irvis and Shelley versus Kramer, which held that government enforcement of racially discriminatory private rules can be state action. The panel pointed out that the petitioners are not seeking to enjoin any statutory provision requiring enforcement of the rules, but instead seek constitutional review of the rules themselves. The panel did not decide whether future enforcement of the rules would be state action. Finally, the panel rejected the petitioner's argument that NASDAQ must be considered a state actor because otherwise its rules would violate the private non-delegation doctrine.
Thanks for that. How about the statutory and APA claims?
The panel rejected those as well. The panel addressed each of petitioner's arguments at some length, but for now I'll focus on just a couple of its conclusions. First, the panel concluded that there is no textual basis for limiting exchange disclosure rules to information that would meet the materiality requirement for a securities fraud claim, and that imposing that fact-specific standard would be unworkable. Second, the panel found that substantial evidence supported the Commission's findings that the rules establish a disclosure-based framework, not a mandatory or de facto quota, and that they would provide information that would contribute to investors' investment and voting decisions. In particular, the panel pointed to the evidence in the record that there is broad demand for enhanced board diversity disclosures among investors who already use that information to make investments, and that market participants have been deprived of fair access to that kind of information. As a result, the Commission reasonably concluded, the panel found, that the rules were designed to promote the Exchange Act's objectives and were related to the purposes of the Exchange Act, in particular, the Act's fundamental purpose to implement a philosophy of full disclosure.
Thanks, Dan. As I mentioned at the start, the Fifth Circuit has granted rehearing en banc, so we will just have to stay tuned to see whether the full court reaches a different result.
Thanks very much, Tracy and Dan. And as we've discussed at SEC Speaks the last few years, courts are continuing to interpret the Supreme Court's decision in Liu versus SEC concerning the court's ability to award disgorgement as a remedy in commission actions. Liu was decided at the end of the court's 2019 term, and shortly afterwards, Congress passed the National Defense Authorization Act, or NDAA, which contained provisions that further solidify the Commission's authority to seek disgorgement and also establish a statute of limitations for disgorgement claims. One of the attorneys who've been working on the post-Liu cases is Dan Staroselsky. And Dan, could you remind us of the background of the Liu case?
Sure thing, Michael. So Liu resolved an issue that the Supreme Court left open in its 2017 decision in a case called Kokesh against SEC. And the issue is whether courts and commission enforcement actions have authority to require defendants to disgorge, that is, give up, the amount of money obtained from their wrongdoing. And in an 8-1 decision, the Supreme Court held that a disgorgement award that does not exceed a wrongdoer's net profits and is awarded for victims is permissible equitable relief under Section 21D5 of the Exchange Act. And in addition to affirming courts' authority to award disgorgement, the Supreme Court discussed principles to guide how disgorgement is measured, apportioned, and distributed.
Thank you, Dan. And can you take us through the court's guidance and how the lower courts have applied it?
Of course. So let me start with the measure of disgorgement. Lou said that courts must deduct legitimate expenses before ordering disgorgement. And the court provided guidance, as I mentioned earlier, about how to distinguish expenses that should be deducted from those that shouldn't. So on the one hand, a deduction is appropriate for what the courts have called the marginal costs incurred in producing the revenues that are subject to disgorgement, also for expenses that have value independent of fueling a fraudulent scheme. And on the other hand, a deduction is not appropriate, for example, for extraordinary salaries that appear merely to be dividends of profit or other wrongful gains under another name, and also payments for personal services. And whether a particular claimed expense should be deducted under this rubric is a fact-specific question. So courts have deducted, in appropriate circumstances, commissions and fees that a defendant paid on trades that generated the unlawful profits, but they've declined to deduct amounts that a fraudster is paid as quote-unquote salary for services that furthered a fraud, and also for fixed costs that would be the same whether or not the defendant committed the violations.
Thanks, Dan. That's helpful. And now, if we could turn to Lou's guidance about how disgorgement judgment should be apportioned in cases involving multiple violators. Could you remind us what the Supreme Court said about joint and several liability?
Sure, Michael. So Lou instructed that the imposition of joint and several liability for disgorgement must be consistent with equitable principles. And again, the court gave some guideposts for assessing that issue. So the court first cited the common law rule that requires individual liability for wrongful profits. But the court also said that the common law permitted liability for partners engaged in concerted wrongdoing. And the court underscored that the historic profits remedy thus allows some flexibility to impose collective liability. And since then, courts have really followed both teachings of Lou, so they hold wrongdoers individually liable for the profits that accrued to them, and in appropriate circumstances, courts also apply the concerted wrongdoing standard from Lou to hold wrongdoers liable on a joint and several basis when that's appropriate and equitable. One example where joint and several liability was ordered is in a Fourth Circuit case called SEC against Johnson. For our purposes, there were two defendants in that case, Johnson, who's an individual, and Owings Group, which was an entity that Johnson founded and controlled. And the Fourth Circuit first explained that Johnson and Owings not only engaged in concerted wrongdoing, but Owings's conduct in the scheme generated its ill-gotten gains, and Johnson controlled that very conduct. And the court also noted that Johnson wore just about every hat of importance in the company, so the Supreme Court's concern in Lou about liability being imposed on mere affiliates or those with no participation in the unlawful scheme was just not implicated.
And so this brings us to the other bit of guidance that you talked about the Lou Court providing, and that's as to how disgorged profits should be distributed. And can you talk to us a little bit about how the lower courts have handled that question?
Yes, of course. So Lou said that Section 21D5 of the Exchange Act restricts equitable relief to that which may be appropriate or necessary for the benefit of investors. And the court said that the equitable nature of the profits remedy generally requires the SEC to return a defendant's gains to wronged investors for their benefit. The court also stated that it's an open question whether under Section 21D5 and equitable principles, disgorged funds may be deposited with the Treasury when it's infeasible to distribute collected funds to investors. And as with the net profits calculation and joint and several liability, the Liu court left it to the lower courts to flesh out that issue.
And so the Fifth Circuit was the first to rule on the distribution question, right?
Yes, that's right. The Fifth Circuit addressed that issue in a case called SEC against Blackburn. And in that case, the district court had initially ordered the disgorged funds to be dispersed to the Treasury. After the Supreme Court issued Liu, the commission requested the Fifth Circuit to remand the case so that the district court could take another look at the distribution issue with the benefit of the Supreme Court's guidance. So on remand, the district court concluded that the SEC had identified the victims of the defendant's fraud and created a process for the return of disgorged funds. Under that process, any funds recovered would go to the commission, but the commission would then disperse those funds to victims only after the district court's approval.
And did the Fifth Circuit approve of that method of distribution?
It did. The court said that the process that the district court ordered easily satisfies Liu, and the court also made clear that it was not saying that this scheme was the only way to satisfy Liu.
And so I take it that in light of this conclusion, the Fifth Circuit did not have to address whether and under what circumstances disgorged funds may be dispersed to Treasury.
Yes, that's right. The Blackburn court recognized that Liu left open that issue, but the court also explained that under Liu, the Treasury question arises only when it's infeasible to distribute the collected funds to investors. So in Blackburn, the courts said that it didn't have to decide that issue because it was not only feasible to identify the victims to whom the funds will be distributed, that work had already been done. But that issue that Liu left open is before the 11th Circuit right now in a case called SEC against Spartan Securities Group. The issue there arose because the commission and the defendants stipulated that distribution to investors of the disgorgement amount requested would be infeasible. And the district court reasoned that between the money staying with the defendant, which was a key player in a scheme to put dubious equities on the market, or a fund at the Treasury, it's more equitable to order disgorgement. The defendants in that case appealed to the 11th Circuit. We've briefed the case. The 11th Circuit heard oral argument in October 2023, and so we're awaiting the court's resolution.
Thank you very much, Dan. And we have just a little bit of time remaining, and so I thought I might touch briefly on something. It's a question that we often get asked in this group, which is, how does somebody contact the commission about potential amicus participation in a case? You heard me talk today about two of the common ways that we've participated, and that's when courts ask us. In the Second Circuit, it was the New England Carpenters case. The court came and asked the commission for its views. And in the Supreme Court, sometimes private securities cases there are issues that arise and the government will participate. We work together with the Solicitor General in those cases, but we not infrequently file briefs in those cases because it's something that the court is interested in. But another mechanism is when parties come to us. And there is on our website actually a place that you can go to make a submission seeking commission participation. And we always review those and see if it might be an issue that warrants recommendation to the commission. But just one tip on that one for folks who are interested in that is to come to us as early as possible. And the reason that I say that is because in the circumstance where the commission would be considering amicus participation, it would not have already authorized a case. So the staff has to review the materials, come up with a recommendation, and go to the commission for it to decide in the first instance whether it wants to participate in the case, and if so, what it wants to say, which side of the issue does it want to come in on. And so it is important, and we're happy to do it, but we need more than, people asking us for a brief next week. We just can't do it that quickly. So thank you very much, everyone. Thanks to all of the panel members, and that concludes our presentation for the day.
All right, you started the morning and came for the enforcement panel, and now you stayed for the ethics credits. Our final panel is led by Tracy Sasser, Associate General Counsel for Litigation and Administrative Practice in the Office of the General Counsel at the SEC. She'll moderate a discussion of ethical issues for securities attorneys. Tracy leads a team that represents and advises the agency on a wide range of matters involving operations and management, defense of third-party litigation, and allegations of attorney misconduct. Prior to joining the SEC, Tracy served as the Assistant General Counsel for the Division of Business and Administrative Law at the U.S. Department of Education. Please consider the comments of these panelists. Tracy, over to you.
Thank you. Thank you so much for that very warm introduction. It's my pleasure to introduce a few members of the Office of General Counsel's Litigation and Administrative Practice Group's dynamic team of attorneys. I'd like to start with Tom Carr. Mr. Carr has served as the Assistant General Counsel for Professional Misconduct in the Litigation and Administrative Practice Group since 2006. He began his service with the SEC in 1998. Mr. Carr assisted in drafting the Part 205 attorney conduct rules and is involved in investigating attorney misconduct and bringing administrative proceedings against attorneys pursuant to SEC Rule of Practice 102E. He was also involved in drafting the anti-retaliation and other provisions of the Commission's rules implementing its Dodd-Frank whistleblower program and has worked on amicus briefs on whistleblower issues. He is a graduate of Harvard University and of the University of Virginia School of Law. We also have Mr. Philip J. Holmes. Mr. Holmes is a special trial counsel in the Litigation and Administrative Practice Group. Mr. Holmes investigates and prosecutes attorney misconduct cases under SEC Rule of Practice 102E and the SEC's Part 205 Standards of Professional Conduct for Attorneys Appearing and Practicing Before the Commission in the representation of an issuer. Mr. Holmes is a graduate of Dartmouth College and Cornell Law School. We also have Ms. Karen Shemp. Ms. Shemp is a special trial counsel also in the Litigation and Administrative Practice Group. Since 2006, Ms. Shemp has focused her practice on investigating possible attorney misconduct and bringing administrative proceedings against attorneys pursuant to SEC Rule of Practice 102E. She is also actively involved in examining whistleblower issues that involve attorneys. Ms. Shemp is a graduate of Harvard Law School. We'd like to thank PLI for inviting us to speak to you today, and we promise to do our very best to keep you awake and engaged at this last session, or next to last session of the day. Thank you.
Thanks, Tracy. I know that you've heard this before, but I always feel compelled to say it again. This presentation and panel discussion are provided in the author's official capacities as staff in the Commission's Office of the General Counsel, but do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. I'll also note that I think I was first in this room when I was a paralegal at Covington and Burling for their 1984 holiday party. So it's good to be back. Okay, the roadmap of our presentation today. We're going to go through just a few Rule 102E statistics for actions against attorneys. Now, as I hope people know, Rule 102E applies for regulating other professionals who appear in practice before the Commission as well. But our office is charged with doing it for attorneys, so, you know, their enforcement handles accountants and other professionals. Okay, then we're going to go through the history and I guess a roadmap of Rule 102E as applied to attorneys and some recent illustrative proceedings. These would include Rule 102E3 proceedings, which are follow-ons to enforcement actions. Rule 102E2, which are forthwith suspensions. We'll be talking more about that based on bar suspensions or criminal convictions. And Rule 102E1, which is Office of the General Counsel, original investigations and proceedings. We'll also be talking some about reinstatement, the process for reinstatements under Rule 102E5. And we'll do a little nod there to explain what appearing and practicing means under the Commission's rules. We will talk a little about our work with bars, state bar associations or state Supreme Courts that are responsible for the state regulation of attorneys. And then, time permitting, we will get into briefly the attorney reporting requirements and avenues under our Part 205 rules. So now always when we always talk about statistics, I try to find some interesting or colorful quotes about statistics. One thing I will say I did learn in doing this is how many popular quotes, it's apocryphal as to who said them. But these are quotes that I feel pretty good that we've gotten hammered out who said it. George Bernard Shaw, it is the mark of a truly intelligent person to be moved by statistics. Hopefully we can move you today. Edwards Deming, statistics professor, In God We Trust, all others must bring data. And Bradley Efron, those who ignore statistics are condemned to reinvent it. I guess we're talking about statistics as a singular entity there, otherwise we've got a subject-verb agreement problem. But anyway, moving on. If you had to guess, what has happened to the types of suspensions over the past several years? Do we have more follow-on E3s than E2s? That is, relatively more attorneys being charged with serious civil securities law violations, or more E2s than E3s, which are forthwith, relatively more attorneys being criminally convicted or suspended or disbarred, or neither A nor B. I'm just curious, who would say it's A, more E3s? Okay, got like at least three. Who would say more E2s, the criminal convictions? And who would say neither? Okay, and actually always like a split. So the trends for the past 6 years, and I think this is probably fairly consistent with even prior years, is there's more E3s as percentage. That's the blue or the right-hand column in these year trends from 2018 to 2024, of course, being only a few months in, and E2s being the yellow. There has been some fluctuation. You might see that in 2021 especially, there was a much higher ratio of E3s to E2s. But generally, it's been relatively constant that we seem to have more of the E3 follow-ons done.
All right, so what are some of the most common types of misconduct that we see? And this is just from 2019 through the first quarter of 2024. It doesn't go all the way back as far as we've done E2s. But so in recent years, in number 6, there's a tie between insider trading and UPL, or facilitating the unauthorized practice of law. In 5th place, other registration violations. In 4th, false filings with or misrepresentations to the commission. 3rd place, again a tie, conversion of investor funds and other crimes like money laundering, fraudulent opinion letters, and far and away, for number 1, misrepresentations to investors and offering frauds. Now, these numbers, what we've done is just tried to take the most severe or most prevalent. We didn't double count, so the numbers aren't going to add up exactly, but we wanted to give you guys an idea of the types of things that we're seeing. All right, so lengths of suspensions, you'll notice far and away most are permanent. Then I'll note on the permanent suspensions, that includes all our follow-on E2s, so criminal convictions, disbarments, bar suspensions. The ones that aren't in the E2 category are predominantly cases where the attorney agreed to a permanent suspension in a follow-on to an enforcement action. In the less than 5 years group, there's many different suspension lengths, but none less than 6 months. And in the 5+ years group, there are 35 5-year suspensions and a single 10-year suspension. So that just gives you an idea what, it was a little too crowded to try to put all those numbers on a single chart, so.
Karen, what percentage of the permanent suspensions are under Rule 102E?
So the permanent suspensions under 102E are just over 38%.
E2.
E2. I was going to say under E2. I was getting confused for a minute. The E2 suspensions are just about 38%, so 120 out of the 311. So somebody who can do math more quickly than me can figure out how many then are agreed as part of a follow-on to an enforcement action.
Thank you.
Okay, we're going to talk a little bit about Rule 102E3s, otherwise known as follow-ons. The basis for a follow-on is pretty simple. The commission has to be involved in the case, and there are 2 hooks. 1, a permanent injunction against violating, aiding, and abetting the violation of federal security laws, or 2, any finding by a court that a person violated or aided and abetted the violation of any provisions of the federal securities laws. So like I said, 2 hooks, permanent injunction, and a finding by the court. Most 102E follow-ons are part of a settlement package with the underlying enforcement matter. If a follow-on is brought where there hasn't been a settlement, then the Office of General Counsel handles the institution and litigation of an administrative proceeding to determine what, if any, Rule 102E relief may be appropriate. A non-settled order instituting an E3 proceeding will immediately temporarily suspend that person for the duration of the litigation. And that person has 30 days to file with the commission a motion to lift the suspension. If they do not file it within the 30 days, the suspension becomes permanent. If a respondent does reply, the proceeding is generally handled via summary disposition by an ALJ because the merits ruled on cannot be relitigated under our Rule 102E3(4). And the focus of a hearing under a 102E3 is really on the Stedman factors. And the Stedman factors include the egregiousness of the conduct, the recognition of any wrongdoing, and the opportunity for that respondent for any future violations.
How does Rule 102E34 work if the underlying enforcement action was settled?
Under Rule 102E34 provides that a person who consented to a permanent injunction without admitting the facts in the complaint shall be presumed for all purposes to have been enjoined by reason of the misconduct alleged in the complaint. Let's look at some recent 102E3 examples. We're going to start with the settled ones because those are the most common. First one involves Mr. John Paciullo. At least I think that's what his name is. Here he was charged for his role in a multi-million-dollar unregistered fraudulent offering of securities where he made material misstatements and omissions in private placement memoranda that he had prepared for many investment funds. He also made material misstatements and omissions to investors and potential investors in in-person meetings and in videos. Among other things, those misrepresentations included the offerings that he had talked about did not need to be registered with the SEC, and the offerings complied with the federal securities laws. His key omission in all of this was that the issuer's undisclosed control person had a criminal history that he didn't talk about. As such, Mr. Paciullo was new or was reckless in not knowing that there was no exemption for a registration available for him. Mr. Paciullo settled with the commission. His settlement included a commission finding that he violated Section 5 and 17A, Section 10B and 10B5. He received a $125,000 civil penalty, a cease and desist order, and a 102E suspension with the right to apply for reinstatement after 5 years.
Now we're going to talk about a litigated follow-on, so you can get a little feel for the process of adjudication. Thank you. Now we're going to talk a little bit about a litigated 102E3, so you can get a feel for the process of how those are adjudicated. This involves an attorney named Norman Reynolds. He was involved in a matter where an attorney named Saeed orchestrated the unlawful resale of 4 million restricted unregistered shares in Nuvo. Saeed needed an attorney letter opining that the shares qualified for an exemption from registration before the restrictive legend could be removed. For removal of the restrictions, stock transfer agreements that led to the issuance of the stock needed to have been completed by July of 2012 to qualify for a one-year holding period under 17 CFR 230.144. Reynolds, who had reviewed documents that indicated the execution date was later than that, in September of 2012, initially told Saeed that the proposed transaction did not meet the one-year holding period, but later relented on that. The problem was that he relented after Saeed gave Reynolds falsely backdated agreements that made it appear the transactions complied with the one-year holding period. Reynolds, despite his suspicions, relied upon Saeed's false representations and never independently verified the execution dates of the stock transfer agreements. The commission filed a district court action against Reynolds, along with the one they'd filed against Saeed, where Reynolds was permanently enjoined from violating Section 5 and 17A of the Securities Act and Section 10B of the Exchange Act and Rule 10b-5 thereunder. He was subjected to permanent penny stock and officer and director bars, and he was permanently enjoined from participating in the preparation or issuance of any opinion letter in connection with the offer or sale of securities, the last part being what's commonly referred to as a conduct-based injunction. Based on the permanent injunction in the district court action against Reynolds, a follow-on E3 proceeding was instituted. A non-settled one, the way it works is the commission will issue an immediate temporary suspension from appearing or practicing before the commission. In this case, as is commonly the case, the commission denied Reynolds' request to lift his temporary suspension, and with the suspension in place, the case was assigned to an ALJ. It was initially stayed pending settlement talks. There is a provision in our rules of practice that allow for staying of matters if there's pending settlement talks. After settlement was not achieved, we went back before the ALJ, who scheduled motion for summary disposition, which is akin to a motion for summary judgment. In the ultimate decision, the ALJ noted that the Commission considers violations of the anti-fraud provisions to be particularly reprehensible and found that Reynolds' conduct was egregious and involved a reckless degree of scienter. His occupation included representing issuers before the Commission, presenting opportunities for future violations, and he had not recognized the wrongful nature of his conduct. Also, his lack of disciplinary history did not remove the need for sanctions. His conduct was essentially not recurrent. 2 opinion letters concerning the same issue or stock in a short time period. And he had made assurances against future violations. Based on all of that, the ALJ found that a 4-year suspension was appropriate.
Tom, so in this case, Reynolds' misconduct involved doing work for another attorney. Does this happen often?
It actually happens a fair deal. There are cases where attorneys have done work for other attorneys, and both of them have gotten involved, have basically had cases brought against them. Here, Saeed, who was also an attorney, was permanently suspended when he'd been temporarily suspended, and then he did not challenge the temporary suspension. We've also had cases involving attorneys Rubin and Kraft, Dalmy and Woodford, Mullerly and Nguyen. And by the way, a lot of these names we'll see a little later. There is a link on the Commission website where you can type in the name of an individual and you can see if they've been subject to any Commission proceedings or sanctions. But yes, it does tend to happen. I mean, often or sometimes it's a suspended attorney getting a licensed attorney do an opinion letter or do other work for them. So, I mean, there are legitimate reasons, I suppose, where a attorney no longer with a license might ask a licensed attorney to do work. You know, perhaps the unlicensed attorney has gone off to the business side of the world and is no longer practicing law. But it is a cautionary thing that when you're working for other people, you still have other attorneys, you still have to do your due diligence. And Reynolds did not petition to review the ALJ's decision, so it automatically became final, and he also did not appeal the final decision or otherwise appeal up to the Court of Appeals where he could have gone had he continued to press the point.
All right, so we're going to shift gears now to E2s, which we also call forthwith suspensions, which is very clever because it says right in the rule that you can be forthwith suspended. So, you know, we try to find clever ways to remember things like that. The key point here is that if you're convicted of a crime or if you lose your license, whether through disbarment or suspension, then you can be suspended from appearing or practicing before the SEC, even if the actions that would be a basis for a follow-on have nothing to do with securities laws or securities work. So something to be mindful of, that this is a remedy that we can use even when you're not convicted of, for example, securities fraud. So one of the first examples that we have for recent ones is the case of Mr. Stephen Bashar. His 22-year career ended in disbarment when he violated Colorado's version of Rule 8.4C, engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. What he did was he was engaged in conversion of client funds, civil theft, breach of contract, negligent misrepresentation, and unjust enrichment in 2 separate civil suits. And then he was ordered to, but did not, pay damages of $4.5 million. Mr. Bashar also pled guilty to 1 count of felony theft based on allegations that he made misrepresentations and omissions in order to get funds from an investor that he then used for his personal expenses. I wish we could say that this is uncommon, but this is one of the types of things that we tend to see come across our desk. He was sentenced to 3 years in prison and ordered to pay $182,000 in restitution. So the SEC suspended him based on both the disbarment and the conviction. Next, we have the case of Douglas Hawkins. Hawkins was a lawyer, an investment advisor representative, and a certified financial planner. And keeping the trio theme going, he landed convictions for 3 types of fraud: securities fraud, investor advisement fraud, and mail fraud. In those cases, he made many material misrepresentations to his clients in order to get them to invest, including assuring them that there was little risk of financial loss, always a red flag, and he failed to disclose numerous facts to his investors that he had a fiduciary duty to disclose. And you can see those facts that I just said come from the indictment, and we've given you that there. I don't know if you guys get a copy of the slides, but you can take a picture. They do. Okay, great. So you can look at the indictment if you want. All right, so Hawkins was sentenced to 10 years in prison, 3 years of supervised release, restitution of more than $1.7 million, and forfeiture of $86,000 roughly, an SEC suspension under E2, and suspension of his license by the Kentucky and Texas bars. Although, to be fair, all we know from Kentucky is that he's suspended with no explanation, and from Texas, all their public document says is that he's not eligible to practice for administrative reasons. And just to go back to point 2 for a second, it was a proactive team of our enforcement staff in the Chicago office that found the case, and it's an example of the commission suspending an attorney even though there was no associated enforcement case and thus no potential for a follow-on or E3 action. Okay. Phil.
A second case of an example of an E2 is a man by the name of Ronald Swanson. He was the former CEO and general counsel of a private company. His legal career was ended when the D.C. Court of Appeals disbarred him for, among other things, misappropriating investor funds for his own personal use, something we see a fair amount. The SEC suspended him based on that disbarment in E2 in 2020. With the disbarment and the E2 suspensions finished, but the commission's underlying case was still ongoing. His fraudulent scheme netted him more than $2 million from investors based on his exaggerating the level of interest in a large publicly traded company had in his company's technology, falsely stating that a reputable research and development firm had independently verified the technology and its use in a practical setting in Russia, and finally providing false information about investment terms and risk. Mr. Swanson settled with the commission. His settlement included a permanent injunction, a 10-year O&D bar, nearly $1 million in disgorgement and prejudgment interest, a $250,000 civil penalty, and a temporary follow-on suspension pursuant to 102E3. And because he did not file a petition to lift the suspension within the 30 days, it automatically became permanent. So against Mr. Swanson, we had 2 102E suspensions, a 102E2 for the disbarment and a 102E3 for the injunction.
Now, you may be wondering, why do both? Why do a Rule 102E3 suspension against someone who's already suspended under 102E2? In answer, is to provide maximum complete relief for the commission. 102E2 suspension might be lifted if a person's law license is reinstated or their criminal conviction is overturned, in which case you can't rest on that. You still have to, if you believe it is appropriate for that person to be suspended, you still need to continue the E3 track. And I guess the flip side question is, why do a 102E2 suspension if we know we might be able to do a complete suspension under 102E3? And again, there is, where the commission believes there is reason and grounds for it, is to get the attorney suspended as quickly as possible. You will note that here, because the E2 suspension, the bar had suspended him quickly, and the commission was still in the process of prosecuting its case, the basis for the E3, which later got, a less subject to appeal or challenge suspension, the E3 bit grounds or basis did not exist for over 2.5 years.
All right, so the third type, going in reverse order, from most common to least common, is E1, which are OGC investigations. And you can see there, we've given you the text of the rule, but the key points are under Romanet 1, the requisite qualifications, is the attorney actively licensed by at least one state? And for a while, we had a number of cases where counsel for, like general counsels who were in business, who didn't go to court, had let all their licenses lapse. So even if you're not in court, don't let all your licenses lapse. Romanet 2 is where most of our investigations are focused. We do not have a separate set of rules for what is unethical or improper professional conduct for attorneys. What we do is we look at the laws and rules the attorney is already subject to and therefore on notice that they could be held to, including the state bar rules for every jurisdiction where the attorney is licensed. And then for Romanet 3, you may remember in an earlier slide, we referenced E1, 3i, and said that for statistical purposes, it's similar to E3. That's because generally actions under E1, 3i have been part of a global settlement with enforcement in a case that was brought as a C&D administrative proceeding. And our group handles all aspects of an E1 investigation. We have the same basic tools as enforcement. We handle settlement negotiations and recommendations. And if there's litigation, we handle all aspects. The administrative proceedings, we handle district court actions to enforce SEC suspensions under the court rules 21E1. And we handle any appeals, including into the federal courts. So I'm going to start by noting that the examples we're discussing today can all be found at the link that Tom mentioned earlier. We have given it to you, so since you have handouts, you have it there. It's that SEC action lookup. So a lot of times we're just going to reference somebody's last name, but that should be enough information. You can go there and you can find everything about the case that you might want to know. So examples of E1s have been where someone has violated their suspension order, and we'll talk a little bit more later about what our remedies are for that. An E1, if someone violates the conflict of interest rules for ex-government employees. There was a rather highly publicized case involving Mr. Barish a few years ago. Engaging or assisting in the unauthorized practice of law. If you were here at our last presentation 2 years ago, you heard more than you ever wanted to about that in the case of Gowerter, Dowling, and Hackman. If you missed that, it's kind of an entertaining read. You might want to go see a list of things not to do. And engaging in dishonest conduct or conduct prejudicial to the administration of justice. And so some examples there, which aren't coming up for some reason, are Tamman, McCarthy, and Altman. And we'll be talking about McCarthy right now, actually.
Let me ask a question first. Where do the 102E cases come from?
They can come from a multitude of sources. We certainly get many come to us as referrals arising out of enforcement investigations. Also referrals from other commission divisions or offices. They can be from news reports. We've had them from TCRs. And we've had actually referrals to us from bar authorities, among other places. So a pretty decent variety of sources. And the one we're going to talk about now is a very, very recent case and involves an attorney named Ellen McCarthy. In May of 2018, in an enforcement AP, the Commission entered an order that was requiring Manhattan Transfer to comply with certain undertakings, including retaining an independent consultant. Manhattan Transfer hired an independent consultant, which in turn retained McCarthy to serve as engagement manager. The independent consultant was to prepare a report identifying deficiencies and weaknesses in Manhattan Transfer's policies, procedures, supervisory controls, or in the implementation thereof. Both McCarthy and the independent consultant were required to remain independent of Manhattan Transfer, that is to do no further work for them during the engagement and for a period of 2 years thereafter. In August of 2018, McCarthy asked the Commission staff if they would permit her to do additional work implementing the recommendations made in the report, which was being prepared. In September of 2018, the IC and McCarthy submitted their report to the Commission, thus completing their engagement with Manhattan Transfer and triggering the 2-year independence requirement. Before receiving a response from the Commission staff, and in violation of what would have been agreed to about remaining independent, McCarthy agreed to serve as engagement manager for revising Manhattan Transfer's written policies and procedures, which was referred to as Phase 2 of the IC's work, and for closing Manhattan Transfer's Colorado office. In September, the Commission staff informed McCarthy that they would not waive or modify the independence requirements and reiterated that neither she nor the IC were permitted to do any further work for Manhattan Transfer for 2 years. Okay. Based on that scenario, what happened? Did McCarthy, A, decline to do additional work for Manhattan Transfer, or B, do the additional work for Manhattan Transfer mentioned above, that'd be Phase 2 and Phase 3, C, do even more additional work for Manhattan Transfer, D, take steps she knew or should have known would conceal her continued work for Manhattan Transfer by 1, making it appear through payment flow that an alternative entity rather than the IC was doing the work on Phases 2 and 3, 2, following questions from examination staff, participating in drafting a fictitious backdated contract to make it appear the alternative entity was hired to do the work, and also participating in drafting a misleading email sent to the Commission staff. And last, 3, when the Commission enforcement staff began investigating whether Manhattan Transfer had violated the independent consultant requirement in the 2018 order, giving testimony that was false or inaccurate. Could ask who thought she did A, but obviously we wouldn't be here. But the short answer was she did all of the remaining ones, B through D, including subparts 1 through 3. So, in a settled AP brought pursuant to 102E1, the Commission found that McCarthy had engaged in improper professional conduct. And again, there's both a statutory and a rules provision that applies there. In that, respondent violated New York Rule Professional Conduct 8.4, which states in relevant parts that a lawyer or law firm shall not, D, engage in conduct prejudicial to the administration of justice, or H, engage in any other conduct that adversely reflects on a lawyer's fitness as a lawyer, and denied her the privilege of appearing and practicing before the commission.
Tom, in these matters, does the commission have to wait for the bar to act?
No, we can act even absent prior bar discipline. As part of the DC Circuit's decision, so many, 13 years ago, in Altman versus SEC, which is 666 F3rd 1322, it held that attorneys are on notice that the commission may apply state conduct rules to them, and that doing that with regard to Altman, when the New York bar at that time had not brought any action against him, was permissible. Next, we're going to talk about reinstatements. An application for reinstatement of someone permanently suspended or disqualified under either E1 or E3 may be made at any time, and the commission can give them a hearing. However, the suspension or disqualification shall continue unless and until the applicant has been reinstated for good cause shown. And two, for someone suspended under paragraph 102E2, which is a bar suspension or criminal conviction, they can make an application for reinstatement at any time. They can make one of those applications if the basis for the underlying matter has gone away. In other words, the criminal conviction has been overturned or a bar suspension has been lifted and the person has been reinstated. In those situations, if those grounds for suspension have been removed, they can apply for and be eligible for reinstatement. Now, if they have a criminal conviction which hasn't been lifted, they can apply for in discretion asking to have it lifted. But under E2, if bases go away, it's a different path. Okay, in reviewing a petition for reinstatement, we will see, among other things, if the attorney complied with the suspension order, term of years suspensions, detail in the order what must be shown, and we have a variety of tools to make further inquiry if we have any questions based on our compliance research. Generally, an application to have a suspension lifted and be reinstated gets sent to the Office of the General Counsel for review, and then we'll do whatever advising of the commission is appropriate. And again, we do that for attorneys. There's another mechanism for accountants and other professionals.
All right, so a slight segue, say that 3 times fast. Because one of the key things that we look at when we're assessing a reinstatement request is whether or not the person has complied with that suspension, our review looks at a number of things, but a key thing is that we focus on whether they have appeared or practiced during the time of their suspension. Appearing and practicing is defined in 2 places, in Rule 102F and then again in Part 205. We're not going to go into detail about it, but I will say if any of you here, despite all our admonishments, find yourselves subject to an SEC suspension, we strongly encourage you to carefully review each of these rules and the language in Part 205 proposing and adopting releases. And the key point that we want you to take away is that appearing and practicing is intentionally defined very broadly. So if you're subject to a suspension, look at these rules and tread carefully if you want to seek reinstatement at some point. Even if you don't want to seek reinstatement, we have remedies if we find noncompliance, either because somebody has applied for reinstatement or because we do continuing reviews just to check and see if people who have been suspended appear to be abiding by the terms of that. So our remedies include, if you were suspended for a term of years, we can increase that to and including a permanent suspension. The example we've given is Riley, where a 3-year suspension became a permanent suspension. We can convert our order to a federal court order. That's where I was mentioning earlier, Section 21E1. Two cases where we have done that include Mr. Hackman. We referenced him earlier. Again, if you weren't here 2 years ago, you can look at that court order, and SEC v. Vinson.
Karen, as an example, how did Riley come to the commission's attention?
So in Riley, what happened, the order notes that a registration statement that was filed with the commission incorporated a legal opinion that was signed by Riley, identified him as, quote, counsel to the registrant in connection with the filing of its registration statement, and that he consented to the use of that opinion as an exhibit to the registration statement, and to reference the opinion under the caption legal opinion, and I believe all those things were filed on Edgar.
Yep.
So he made it a little easy, but so the last one that might, if the others aren't enough to get your attention, we can also get disgorgement of fees that you receive for work that violates the SEC suspension. Disgorgement was first awarded in accountant 102E cases back in 2013, and it was first applied to attorney 102E cases in Vinson, where Vinson agreed to disgorge $6,000 back in 2020. And most recently, it was applied in the Hackman case, where he was ordered to pay, I can't do it, but nearly $1 million in disgorgement and prejudgment interest, and that was in 2022. So we do have a lot of remedies. If you're suspended, abide by your suspension, pay attention to what constitutes appearing and practicing.
And I would just also note that there are also a number of cases out there involving disgorgement for accountants who did practice, did appearing and practicing in violation of their 102E suspensions. So there's actually a fairly developing body of law there.
Okay, we're going to talk about two reinstatements, one that was granted and one that was denied. The first one is Mr. Adam Bering. He was a principal at Ernst & Young, and between 2009 and 2018 was the engagement partner for tax credit services E&Y provided for one of its clients. Bering learned that the staff during this time was using improper contingent fee billing arrangements, but failed to conduct a reasonable inquiry or halt that practice. As such, in December 2021, Mr. Bering settled with the commission on settled charges, and part of those charges, the agreed remedies included a 102E suspension with the right to apply for reinstatement after 1 year, and subject to several conditions. In December 22, Mr. Bering applied for reinstatement. First, he notified us that he paid the civil penalty imposed by the commission in the underlying enforcement action, and he submitted a sworn affidavit that attested to, one, that he complied with the suspension, was not suspended or disbarred or subject to any disciplinary action, had not been charged with or convicted of a criminal charge that might support an E2 suspension, had not been charged with or found to have violated the federal securities laws, had not been charged with or found to have committed an act of moral turpitude, and finally was not the subject of an SEC or criminal law enforcement investigation or bar complaints or any other investigations. As a result of his application of reinstatement was approved, the commission found that did not discover any information contrary to the attestations in his affidavit, and found that no information had come to the commission, the attention of the commission, relating to Bering's character, integrity, professional conduct, or qualifications to practice before the commission that would be the basis for an adverse action against him pursuant to 102E, or that otherwise indicates reinstatement would not be in the public interest. Now we're going to Mr. Masters, who was, his reinstatement was denied. In 2020, Mr. Masters was, September of 2020, was permanently suspended by agreement, settled agreement, as part of selling his commission case alleging fraudulent misrepresentations and omissions. 16 months later, Mr. Masters filed a motion to vacate the entire underlying commission's order, including the 102E suspension. The Office of General Counsel opposed this reinstatement for a number of reasons, including the short period of time that he had been suspended, along with the seriousness of his misconduct. As stated before, to be reinstated after a permanent suspension, Rule 102E5 requires a showing of good cause.
Phil, are there any commission cases discussing good cause in the reinstatement context?
There are, other than Mr. Masters' case. The main cases were an accountant named Wolfe, W-O-L-F-E. He had 2 cases, 1 and 2. The latter one reinstated him based on the length of time that he was suspended, which was 7 years, and a number of mitigating other factors.
Thank you.
The Office of General Counsel opposed Mr. Masters' motion to vacate, and the commission denied it, stating that he had not established the requisite compelling circumstances to justify vacating the settlement, and 2, he had not shown good cause for reinstatement. Mr. Masters appealed this final agency decision to the Ninth Circuit. He argued, among other things, that the commission overreached in claiming it had subject matter jurisdiction over the case. The 2020 consent order interfered with his bankruptcy law practice, that there was a lack of subject matter jurisdiction because there was no offer, no purchase, or fraud in connection with the offer or purchase or sale of securities. And despite specific language in the 2020 consent offer, arguments about subject matter jurisdiction can never be waived. He further argued that this SEC did not have subject matter jurisdiction under either the 34 or the 33 Act, that the SEC had violated his First Amendment rights. The SEC violated the standards of justice by sanctioning him after he withdrew from the underlying bankruptcy matter. And then on the 102E part, even if the 2020 order wasn't vacated, his 102E suspension should be lifted because the decision to suspend him was both arbitrary and capricious. The Ninth Circuit denied Mr. Masters' appeal. First, they stated that he knowingly and voluntarily signed the 2020 consent order with the commission, including its waiver of all post-hearing procedures, that there were no compelling circumstances, including misconduct or fraud on the SEC's part, that would have brought vacating that order. And on the 102E part, the SEC did not abuse its discretion in concluding that Masters failed to establish good cause to be reinstated based on the seriousness of his misconduct and the absence of any other favorable circumstances.
Okay, now we're going to talk about work with bars. Not exactly in the bar rescue context, but in terms of the state bars. I know they're groaner jokes, but I got to try something. So, a question could ask is what state rules professional conduct have been applied to attorneys for misconduct related to securities work or commission matters? And the answer is many. Beyond the state bar rules that have figured in the 102E1 proceedings that Karen and I outlined earlier, the following rules of professional conduct have been applied by state bars in their own disciplinary actions that have some relation to SEC proceedings. One is Rule 1.2D. A lawyer shall not counsel a client to engage or assist the client in conduct that they know is criminal or fraudulent. We give you the detailed cites here because these aren't ones that are searchable on the SEC database, but you can look at these decisions. Okay, next 1.8A. Limiting the circumstances where an attorney may acquire an ownership, possessory, security, or other pecuniary interest adverse to a client. Rule 1.15A and B, requiring lawyers to keep their clients' funds separate from their own. Rule 3.4A through 3.4C, altering or falsification of evidence. Rule 4.1, a lawyer shall not knowingly make a false statement of material fact or law to a third person. Rule 5.5A, a lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction. Rule 7.1, a lawyer may not make a false or misleading communication about the lawyer or the lawyer's services. And Rule 8.1b, a lawyer in a disciplinary matter shall not knowingly fail to respond to a lawful demand for information from an admissions or disciplinary authority. Going further, the very popular 8.4. A, lawyers shall not violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through the acts of another. B, commit a criminal act that reflects adversely on the lawyer's honesty, et cetera, et cetera. C, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And D, engage in conduct that is prejudicial to the administration of justice. A recent bar proceeding.
So we had a case with Mr. Ian Horn, who provided a penny stock issuer's transfer agent with fraudulent Rule 144 opinion letters, and as a result of those opinion letters, other defendants were able to obtain unrestricted shares, which they then sold at manipulatively inflated prices. Mr. Horn's settlement with the commission included a $1,000 disgorgement, a $10,000 penalty, and a permanent 102E suspension. So in crux, he was only paid $1,000, and it cost him $11,000 and a permanent SEC suspension. We referred Mr. Horn's misconduct to the Florida bar, but Mr. Horn had other legal issues in Florida. He was found guilty of one count of making false declarations before a grand jury, which is a felony, and he did not notify the Florida bar about those charges. The Florida bar found that he violated their rules of professional conduct 4-8.4b, which is misconduct, and 3-7.2c, which is failure to notify the bar of felony charges. The Florida Supreme Court ultimately disbarred Mr. Horn.
And one thing that Phil noted there that I'd echo is, when we refer something to a state bar, we don't know what else they're looking at with that attorney. We, on several occasions, have learned that apparently the conduct that we noted in our investigations, or that was what resulted in what we did, that the attorney, that was not the only time the attorney had engaged in professional misconduct. Often we've seen orders from the state bars that's like, oh, they did that as well.
All right, so with a minute 42 left, you've almost made it to the end of your ethics. I'm going to just go through the high points of how attorneys can use confidential information sometimes. So the first is internal reporting. What if you have some concerns about the actions of a client if you're outside counsel, or your employer if you're inside counsel? If it's a material violation, under Part 205.3, you have to at least report it internally. We're not going to go through, it's a lengthy provision, we're not going to go through all the ins and outs right now, but we do encourage you to become familiar with it, because not doing what is required under Part 205 is itself a primary violation of the securities laws that the attorney can be charged for. Even if they had no involvement in the underlying misconduct, not reporting it properly and not taking appropriate actions is a violation. So what if you follow Part 205 and are retaliated against for it? Well, the Supreme Court has recognized that it's important that we have anti-retaliation protection. And since you have the slides, I'm not going to read all this to you, but the bottom line is that there are provisions that, that Part 205 and that some states have that would allow the use of confidential information in order to defend against a retaliatory action. And to the extent a state's rules might conflict with Part 205, we want you to know that the Commission takes the position, and at least 2 tribunals have agreed that Part 205 preempts state law, and you can see those 2 decisions. You can read those. And then there's external reporting, but we're out of time, so you have that slide.
So we will leave you with an inspirational quote or 2 about doing the right thing, and thank you for being here for our presentation.
Thank you.
Thank you to the ethics panel. Just right quick, the Division of Enforcement will be in this room for the workshop. The Division of Investment Management is in the State Room, and Accounting is in Treasury Room. The State and Treasury rooms are just up the escalator, one flight, make a left, and you will find them. Thank you all. Hello, and we are back, and we are starting the enforcement workshop, and we have our panel remotely, and I'm going to turn it over to Antonia Apps now. Thank you. Take it away.
Thank you, and welcome, everyone. I am the Regional Director for the SEC's New York Regional Office, and I am thrilled to be moderating the next and final panel for this year's SEC Speaks program. We will first cover recent sweeps, initiatives, and subject areas of focus across the regions. And second, we will turn to some tips for practitioners who represent clients in enforcement investigations. For this panel, I am joined by associate regional directors from 4 regional offices across the country. Glenn Gordon from the Miami Regional Office, Jason Lee from the San Francisco Regional Office, Kay Priska from the Chicago Regional Office, and Tejal Shah from the New York Regional Office. Before we begin, I have the customary disclaimer on behalf of myself and our panelists. We are each speaking in our official capacity as regional or associate regional directors, but our remarks do not necessarily reflect the views of the Commission, the commissioners, or other members of the staff. With that, let's get started. So I want to turn first to enforcement sweeps and initiatives that specifically target recurring issues. These proactive, coordinated actions can have a more pronounced deterrent effect and, in turn, shape market behavior for participants going forward. Tejal, could you speak about some recent examples?
Thank you, Antonia, and thank you to PLI and my fellow panelists as well. It is a pleasure to be here this afternoon. So just as Antonia said, tackling an issue on an industry-wide basis through a sweep can be the most efficient and effective way to shape behavior. When we bring more than one case for the same type of misconduct, it tends to get greater attention by sounding greater alarms and in turn prompt a more significant response. I'm taking a wild guess that almost everyone participating today is familiar with our off-channel communications suite. So I'll start out talking about that one and touch on a couple of others as well. We have thus far charged about 60 financial firms for their widespread and long-standing failures to maintain and preserve electronic communications. The record-keeping and books and records obligations are critically important to the SEC's enforcement and examinations work. As technology evolves, the expectation is that firms will assess their policies and procedures to ensure that they are sufficient to ensure compliance with the laws. So as I noted, we have thus far entered into settlements with about 60 financial firms for their failures. These settlements included significant terms, over $1.7 billion in penalties and custom undertakings designed to remediate past failures and prevent future misconduct. And importantly, they put the industry on notice that this is an issue that we take very seriously. Many firms in the industry have since taken hard looks at their own policies and procedures and made necessary changes to ensure that their business communications are being preserved. In that way, we have effectively shaped behavior. So though it's gotten the most attention, the off-channel communication sweep is just one of a few sweeps we've conducted recently. I'd like to turn to a few others. A few months ago, we conducted a sweep in which we charged 9 registered investment advisors with violating the marketing rule. On December 22, 2020, the SEC adopted an amended marketing rule that replaced the previous advertising and cash solicitation rules under the Investment Advisors Act. The amended marketing rule became effective on May 4, 2021, with a compliance date of November 4, 2022. Pursuant to the amended marketing rule, registered investment advisors are prohibited from including any hypothetical performance in their advertisements unless they have adopted and implemented policies and procedures reasonably designed to ensure that the hypothetical performance is relevant to the likely financial situation and investment objectives of the intended audience of the advertisement. This is because hypothetical performance advertisements may present an elevated risk for prospective investors whose likely financial situation and investment objectives don't match the advertised investment strategy. We allege that the 9 firms that we charged advertised hypothetical performance to the general public on their websites without adopting and/or implementing the policies and procedures required by the amended marketing rule. The charged firms agreed to pay penalties from $50,000 to $175,000 and to comply with undertakings. As we noted in that press release, our investigation into potential marketing rule violations is ongoing. So an important thing to note here is that these actions were brought less than a year after the compliance date of the rule. As the SEC enacts new rules, the expectation is that firms will review their policies and procedures and take whatever steps are necessary to expeditiously come into compliance with the new rules. In the press release for this marketing rule sweep, our enforcement director, Gurbir Grewal, noted, "It is crucial that investment advisors implement policies and procedures to ensure their compliance with the rule. Until that is the case, we will remain vigilant and continue our ongoing sweep to ensure that investment advisors comply with the marketing rule, including the requirements for hypothetical performance advertisements." So in conducting this initial sweep so quickly after the new rule was enacted, the hope is that we can quickly shape behavior by prompting other investment advisors in the industry to take a hard look at their own policies and procedures to ensure compliance with the marketing rule and to make changes and conduct necessary training if it's warranted. Speaking of ongoing, I'd also like to mention the delinquent filer sweep. In September, we filed charges against several corporate insiders for failing to timely report information about their holdings and transactions in company stock. 5 publicly traded companies were also charged for contributing to those failures. An important thing to note about these actions is that they're the latest in an ongoing enforcement initiative by the SEC that began 10 years ago, in 2014, and thus demonstrate the SEC's commitment to enforcing reporting requirements. Our staff used data analytics to identify the charged insiders as repeatedly filing these reports late. An important takeaway from this is that industry participants shouldn't be complacent if they weren't included in a sweep. A sweep could just be the start of more actions. Thus, firms should take note of sweeps and ensure that they're in compliance with the rules at issue. Relatedly, in the context of sweeps, firms should be on notice that the penalty numbers associated with a sweep are not necessarily the same numbers that would apply for the same violations down the line. As time passes, firms could be on the hook for higher penalties for the same violations, depending on the circumstance. For example, in the press release for the custody rule sweep that the division conducted in 2022, Director Grewal noted explicitly that these matters presented a unique circumstance for promptly resolving our investigations with this group of advisors. Counsel should not assume that the division will recommend similar resolutions going forward. Finally, before I turn it back over to Antonia, I'll mention the case we filed against Goldman Sachs in September for failing to provide complete and accurate securities trading information known as blue sheet data. According to our order, over a period of approximately 10 years, Goldman made more than 22,000 deficient blue sheet submissions to the SEC, and that Goldman lacked adequate processes to verify the accuracy of its blue sheet submissions. Fundamentally, the issue in that matter was the same as in our off-channel communications sweep. Firms must provide complete and accurate data in response to our request and make sure that they have the policies and procedures in place that are necessary to do so. It is vital to our ability to carry out enforcement and regulatory functions. When we learn that firms are not doing so, it is something we take very seriously and will attempt to tackle across the industry.
Thank you, Tejal. As we heard this morning, another area of focus for the Enforcement Division is individual accountability. The Commission has recently brought several actions against individual auditors who serve an important gatekeeping role. Glenn, can you speak about some of the cases in this space?
Sure. Thank you, Antonia. And before I do start, I just want to assure anyone in the audience who is worried about where their tax dollars are going that, unlike my colleagues, I am actually presenting from home. So this is not a background that the Commission's budget would typically allow in the office. Having said that, I do want to focus on auditor cases, and I'm doing that because the Commission continues to be focused on the key role gatekeepers play in protecting investors and holding them liable when their conduct doesn't meet the requirements of the federal securities laws. Auditors are among the most important gatekeepers, and they have been since Congress passed the Securities Act of 1933. Auditor independence is critical to protecting the integrity of financial reporting and promoting public trust. Before I talk about individual auditor cases, As Ryan Wolf promised you earlier on, I do want to talk a little bit about the Commission's case against Prager Metis CPAs, LLC, and its California firm, Prager Metis CPAs, LLP. This is a civil action that the Commission filed last year in the Southern District of Florida. I should note that Prager is defending the action, and currently pending before the court is their motion to dismiss, which we have opposed. We're waiting for a ruling. And my factual statements about the conduct are based on allegations in the Commission's complaint. The Commission filed a 66-page complaint that alleges Prager failed to maintain its independence when it entered into 87 engagement letters that contained indemnity provisions with a combination of clients that included public issuers, registered investment advisors, and registered broker-dealers. We allege that Prager Metis did this over the course of almost 3 years. The complaint identifies two types of indemnity provisions that Prager used in the relevant engagement letters, including one in which the client agreed to indemnify Prager, quote, and its personnel from any liability and cost relating to our services under this agreement attributable to any knowing misrepresentation by management. And as you're all probably familiar, management typically provides management representations to the auditors in all the audits. So I ask you to think about the impact of such a provision on an auditor's incentive to go beyond just accepting management's representations when it encounters areas of concern during the audit that should lead it to engage in further testing. And what is going to happen later on if there's a conflict between the auditor and the client over that provision and they enter into litigation based on that agreement? Will they be fighting over the auditor and the client over whether the client provided inaccurate information about whether the auditor didn't properly do its job? That would be a problem, I think, for independent audit reports. The complaint further alleges that in early January 2019, a new BD engagement partner at Prager raised concerns about the indemnification provision to the firm's senior management. Nevertheless, Prager entered into 51 engagement letters after January. Twice again, the BD partner brought the issue to senior management, once later in January and again in June 2019. Prager did not actually remove the indemnification provision from its public company audit engagement letter template until December 2019. When it did change the template, it did not specifically point out the change or context for it. Instead, what it merely told its staff was the new template followed a review with legal counsel and the firm's insurance carrier. That was it. According to the complaint, Prager entered into 6 new engagement letters that contained an indemnification provision even after it changed the template. The Commission also alleges that Prager did not disclose the independence impairment to the relevant clients. So the Commission's charges include violating Rule 202B of Regulation SX, which sets forth the independence standards, the requirement that an auditor be independent, and various aiding and abetting certain clients' reporting violations. Now, the Commission last year, as it always does, has continued to also file cases against individual auditors, typically in the 102E context, Rule 102E context. 2 of those cases include one against an auditor named David D. Brooks that was instituted as a settled administrative action. In that case, the Commission found that, among other things, Mr. Brooks did not preserve the documentation required under auditing standards to demonstrate that certain testing and certain work had been done. The other case I find is somewhat particularly interesting in light of the indemnity provision, which I just mentioned. I should say, there is no indemnity provision at issue at this other case, the second case. That's a 102E proceeding, and cease and desist proceeding against a Markham partner, Alan J. Markowitz, and we filed that as a litigated administrative action. It has since been stayed, pending further developments in the Supreme Court. But interestingly, one of the division's allegations in that proceeding is that Markowitz failed to exercise due professional care because he improperly relied on representations by management of the company he was auditing. So what are some of the takeaways here? Well, with the commission and within the division are committed to investigating possible independence violations. And if we think the facts support it, we're going to recommend that the commission bring in enforcement action, and the commission has demonstrated it has an appetite to do so. The commission is not standing down on cases against auditors that it alleges failed to comply with the relevant requirements of the federal securities laws. A number of those are still being filed as administrative actions, but as you can see from the Prager Meadows case, the commission has also filed at least one case litigated in federal district court. So I think a takeaway from that is that to those out there who think that the commission is not willing to take these cases to a jury, that they're too complicated or too difficult for us to explain, we disagree. We feel confident when the facts support a case that we can demonstrate this to a jury, and we believe that we will emerge with a finding of liability. So thank you very much, Antonia.
Thanks, Glenn. Another important issue for the division, including your office, has been combating affinity fraud. Could you spend a minute talking about Miami's Fraud Against Minorities initiative?
Sure. We're very proud of this initiative. About 2 years ago, we got together with a group of folks in our office to find out how we could better combat affinity fraud in our region. Our region includes, among other states, Florida. And it probably won't surprise anyone here that there's a lot of frauds in Florida. We also have a lot of immigration, new Americans, first-generation Americans. We see a lot of affinity fraud. All offices in the commission have previously brought offering fraud cases that involved affinity fraud. So what's different here really are a couple of points. One is that we have been able to leverage our commitment to principles of diversity, equity, and inclusion. And as part of that commitment, we've been able to diversify, increase diversification within our staff. And that's helped us better investigate cases involving some of these affinity groups because it enables us to develop a better sense of trust when someone who is like a member of that affinity fraud group is actually investing a case and talking to investors who might otherwise be leery of talking to the government. But we've also increased our language abilities. We have more Spanish speakers than we ever had, and importantly in our office, we now have Haitian Creole speaking attorneys, and we do find that the Haitian American community is one that is often targeted. The other thing, just to wrap up, I would say is that we are using these cases as leverage to work with our investor outreach program because the cases are important, but if we can use one case to teach investors about the signs of a possible fraud, often dozens or even hundreds of investors, that's surely going to help put a dent in this kind of opportunism.
Thank you, Glenn. Jason, turning to you for the West Coast perspective, you have also been focused on affinity fraud. Can you tell us about some of those cases that your office has brought?
Sure, my pleasure. And first, I'd like to just start by highlighting that in order to address the important issue of tackling affinity fraud, on the West Coast, the SEC San Francisco Regional Office and Los Angeles Regional Office recently started a joint task force called the Western Alliance to Protect Targeted Communities, which has two main goals. First, to identify and bring more enforcement actions covering investment frauds that target identifiable communities at an early stage. And second, to direct more tailored outreach to affected communities. This task force, like multiple others organized by SEC enforcement staff across the country, including, for example, what Glenn just mentioned at the Miami office, is actively working to protect investors who may be targets of affinity fraud and to also prosecute those who engage in it. And just to highlight one example of our work in this area, at the end of 2023, staff in the San Francisco office charged a woman named Talila Walker-Sumchai, who operated out of Northern California, for allegedly perpetrating a nearly $12 million Ponzi scheme targeting the Tongan American community. Our complaint alleges that the fraudulent scheme impacted over 1,000 retail investors located throughout the country. The case is called SEC versus Talila Walker-Sumchai, and sadly, the allegations in the complaint reflect a common fact pattern across affinity frauds, with one member of a community using her status and connections within that community to gain the trust of others and then ultimately scamming investors with promises of extremely high returns that are too good to be true. As alleged, the defendant targeted first Tongan American leaders who were paid substantial returns on their investments and thus thought that the defendant's investment scheme was legitimate. Then the defendant utilized the support of the community leaders to promote and convince other Tongan Americans to invest as well. The complaint alleges that the defendant then never used the invested funds in the way that she had promised, but instead misappropriated money for her personal use, like for shopping and casino trips, and also made Ponzi payments to earlier investors in order to keep her scheme alive as long as she could. My hope is that with the Division of Enforcement's focus on this space, we will be able to continue to root out and stop frauds like the one I just described. I think that it's a very important component of the SEC's mission of protecting investors.
Jason, another important division initiative, particularly pertinent to the San Francisco regional office, given its proximity to Silicon Valley, where we see many tech startups, is the use by startups of false or misleading statements to raise funds from investors. Can you tell us more about the Commission's work in this area?
Yeah, I'd be happy to. So this space, private startup fraud or pre-IPO fraud, is another area of important work for staff in the Division of Enforcement. One of the very bright spots of the U.S. economy and business sector over the last several decades has been the country's startup industry. Companies and individuals in this space have contributed to innovation in technology and several other fields that have made a major global impact. At the same time, the private startup space and specifically the private startup securities market has certain conditions that make it particularly susceptible to fraud by bad actors. To help protect the integrity of this market, the Division of Enforcement has actively investigated instances of misconduct and brought several enforcement actions where warranted. And again, given that San Francisco regional office's proximity to Silicon Valley, both in terms of the location of many startups and in terms also of location of several investors in such companies, investigating and charging fraud in the startup space has been a major part of the San Francisco office's enforcement program. Although certainly several regional offices, including the New York office, have brought very important and impactful cases in this area as well. So I just want to give you a few examples of the work San Francisco has done in this space recently. Last November, enforcement staff in the San Francisco office filed offering fraud charges against the co-CEOs of a California-based startup called Bitwise Industries. The complaint alleges that the company's co-CEOs, Jake Soberall and Irma Alguin Jr., raised over $7 million by means of material misrepresentation and falsified documents concerning Bitwise Industries' cash position and historical financial performance. Among other things, the complaint alleges that the defendants provided investors with falsified bank records and a fake audit report. Inevitably, the scheme collapsed when the company, which was operating severely in the red, could no longer make payroll and keep its doors open. Ultimately, the company entered bankruptcy and all of its staff lost their jobs. In another recent example, in December 2023, enforcement staff in the San Francisco regional office brought an action against Laura Perryman, the founder and former CEO of medical device startup StimWave Technologies, Inc. In the complaint in that case, the commission alleged that Perryman defrauded investors out of approximately $41 million by making false and misleading statements about one of StimWave's key medical device products. According to the complaint, the medical device included a receiver that was implanted into patients' bodies that was supposed to help amplify electrical signals to treat chronic pain. In reality, though, the SEC alleged that the receiver was fake and was nothing more than a non-functional piece of plastic. Furthermore, the complaint alleges that Perryman also provided investors with misleading historical revenue and projected revenue figures, which was facilitated by her complete control over the key aspects of StimWave's financial statements and sales records. Last, I just want to briefly mention the SEC's case against Manish Lakwani, the former CEO of Silicon Valley-based tech startup Headspin. This action was filed in 2021 and alleged that Lakwani defrauded investors out of $80 million and propelled Headspin into unicorn status, with a valuation over $1 billion, by falsely inflating the company's key financial metrics and also doctoring internal sales records. According to the complaint, Lakwani controlled all important aspects of Headspin's financial and sales operations and inflated the value of numerous customer deals. He allegedly created fake invoices and also allegedly altered real invoices to make it appear as though customers had been billed higher amounts. So this matter involved fabricated annual recurring revenue, which we call ARR, which is a non-GAAP metric commonly used by software companies and subscription-based companies. It was the fake ARR that was used to generate Headspin's $1 billion valuation. So quickly to conclude, I'd like to briefly note that while the facts and circumstances will certainly differ in each enforcement action, some common fact patterns and themes can be discerned from the cases I just mentioned, as well as the various other private startup fraud actions that the Commission has brought over the last several years. I'll just highlight a couple of them really quickly. First, each matter involved founders or top executives who exercise total or near total control over the company at issue, especially the company's finances and management of contracts with customers. And this allowed for those control persons to engage in conduct such as creating fake financial records and fake numbers. Second common fact pattern is the siloing of employees and limiting what different employees know about the company's operations so that they're unable to detect the fraudulent conduct. And then third, and related to the two other points I just mentioned, the companies involved in the fraud generally have missing or severely deficient internal controls. To conclude, I just want to reiterate that detecting and charging misconduct in the private startup space has been and continues to be an important area of work for the SEC's enforcement staff, including in particular out of the San Francisco office.
Thank you, Jason. I'd now like to turn it over to Kay in Chicago to discuss a recent initiative involving microcap issuers and Regulation A. Kay, can you tell us about that sweep?
Yes, thank you, Antonia. So the Chicago Regional Office, along with the Los Angeles Regional Office, conducted a sweep that resulted in settled administrative proceedings against 11 microcap companies for offering and selling securities in unregistered offerings that failed to comply with Regulation A. This enforcement Regulation A initiative arose out of the work of the exam staff in the broker-dealer exam staff in the Chicago, Los Angeles, and New York regional offices in connection with an exam staff Regulation A initiative. According to the SEC's settled orders, the companies obtained qualification from the SEC for their securities offerings using Regulation A, which provides companies with a limited exemption from registration under the Securities Act as long as they meet specific requirements. However, the companies subsequently made one or more significant changes to their offerings such that they no longer complied with the requirements of the exemption. The firms, which did not file registration statements for their Regulation A offerings with the Commission and whose offerings did not qualify for other exemptions, were all charged with violating Section 5 of the Securities Act, and they agreed to pay more than $390,000 in combined civil penalties to settle the charges. A little background on Regulation A: it exempts from registration certain public offerings by small companies. To rely on a Regulation A exemption, issuers must disclose material information in an offering statement filed with the Commission, and they must obtain qualification for the offering from the Division of Corporation Finance pursuant to delegated authority from the Commission. After obtaining qualification, issuers must continue to comply with Regulation A's requirements. So certain changes to an offering, such as an increase in the number of securities to be offered, or a fundamental change in the offering price, can be made only by a post-qualification amendment or a new offering statement, each of which requires additional review and qualification by the Commission. Filing an offering circular supplement, which is not qualified before taking effect, is not sufficient to increase the number of shares offered or to fundamentally change the offering price. In addition, issuers who are engaged in ongoing offerings must file financial statements updated at least annually, and all issuers have to comply with Regulation A's prohibitions against aftermarket offerings. For the issuers charged in the sweep, each obtained qualification from the Commission to offer securities pursuant to specific terms under Regulation A. However, as found in the settled orders, several of the issuers failed to comply with Regulation A by using one or more supplements to try to make a fundamental change to the offering price or to try to increase the volume of securities offered, instead of filing a new offering statement or a post-qualification amendment. As a result, the issuers lost the exemption for subsequent offers and sales. In addition, the orders found that certain of the issuers engaged in ongoing offerings failed to update their financial statements at least annually as required. Accordingly, these issuers' offerings no longer qualified for the exemption for transactions that followed the failure to update. And then finally, Regulation A requires issuers to offer securities at a fixed price, and at-the-market offerings are prohibited. The settled orders found that certain issuers use one or more supplements to try to conduct an at-the-market offering by offering shares at several different prices in violation of this prohibition. Once these offerings deviated from the fixed price, the exemption no longer applied. So that's the Regulation A initiative.
Thank you, Kay. Another area of focus for our colleagues across the division, including in Chicago, has been the conduct of individuals who buy and sell microcap securities without registering as a dealer. Can you talk about some of the recent decisions in these unregistered dealer cases?
Sure. So I'll focus on two unregistered dealer cases in which the SEC obtained summary judgment in 2023. But just to kind of recap what was discussed in an earlier panel, Section 3 of the Exchange Act defines a dealer as any person engaged in the business of buying and selling securities for their own account. But the term dealer does not include a person who buys and sells securities for their own account, but not as part of a regular business. So whether or not someone is a dealer required to register under Section 15A of the Exchange Act turns on whether that person is in the regular business of buying and selling securities. So the first case I'll talk about is SEC versus Careborn Capital, which was filed in the District of Minnesota by staff from the SEC's Chicago Regional Office. In September of 2023, the district court in that case granted the SEC summary judgment. The court found that defendants Careborn Capital and its managing partner, Chip Rice, acted as unregistered dealers when buying convertible promissory notes, converting them into shares of the issuing company's stock, and then selling billions of newly issued shares of microcap securities. The court found in that case that the undisputed facts showed that Careborn purchased 93 convertible promissory notes from 27 different issuers, as well as 18 convertible notes from 7 different issuers from third parties, that they converted the billions of stock shares from these notes and sold billions of shares of the issuer's stock into the market. In determining whether the defendants were engaged in the regular business of buying and selling securities, the court looked to prior case law, which focused on the volume of the trading activity, the amount of profit generated, and the extent to which the conduct resembled a commercial enterprise, and whether or not the defendants advertised their interest in buying convertible notes. The court found that defendants engaged in a high volume of buying and selling securities, that Careborn sold 17.9 billion shares of stock, from which it received net profits of 13.9 million, and that defendants advertised the convertible debt opportunities through a website and at conferences, microcap conferences, and in cold calls, and that all of these factors supported the finding that defendants were engaged in the regular business of buying and selling securities. The court also rejected defendants' arguments that they were exempt from the dealer registration requirements because they typically held onto the convertible notes for a period of 6 months to comply with the safe harbor provisions of SEC Rule 144. The second case I'll talk about is SEC versus Fiero, which was filed in the District of New Jersey by the DC office staff. In that case, in June of 2023, the district court granted the SEC summary judgment, finding that defendants John D. Fiero and his company JDF Capital acted as unregistered dealers. According to the court in that case, under the plain language of the Exchange Act, the undisputed facts show that defendants were required to register as dealers with the SEC. The court said, looking only at their 10 highest grossing stocks during the relevant period, they sold approximately 5.7 billion shares of stock from converted notes, and those sales resulted in approximately 5.4 million in proceeds and approximately 2.3 million in profits. Citing the precedent, the court found that these undisputed share volumes, proceeds, and profits were strong indicators that defendants engaged in the business of buying and selling securities. The court also found that to generate such proceeds and profits, defendants acquired newly issued stock directly from microcap issuers at significant discounts based on the terms of the convertible notes, and then resold that stock to the public, further evidencing defendants' status as dealers and not traders. The court in that case also rejected defendants' arguments that the SEC's claims were barred as a matter of due process because the SEC's interpretation of dealer under the Exchange Act was unclear and failed to provide fair notice of activities that require registration.
Thank you, Kay. So for the remainder of our time, I'd like to ask each of our panelists to share some thoughts or pointers for practitioners to consider when representing clients in enforcement investigations. Glenn, let's start with you.
Thanks, Antonio. I'm going to start with two before you go to the next one of my colleagues. One of those relates to the representation of multiple people at a company, and we see that a lot at the SEC. It raises concerns when one attorney is representing everybody, and in particular, I want to make sure that lawyers out there in the audience are thinking about their ethical obligations when it comes to the Commission's cooperation program. And Sam Walden talked about that earlier in the enforcement, larger enforcement panel. But so as I'm sure you know, the Commission has a cooperation program that applies not only to companies and entities, but to individuals. And I do think it is questionable in some of these cases whether there really is no conflict of interest between various people who work at a company when they're facing an enforcement investigation. I mean, it's very possible that there could be someone in that group who actually has pertinent information. They may have been involved in the activity, or they may even, have the opportunity to enjoy some sort of whistleblower status, even if we've already started investigating certain conduct. So I think it's very important that practitioners out there make sure that they have fully discussed with every person they are representing who works together at a client, the cooperation program, the whistleblower program, and any other ethical considerations that may make that joint representation or that representation of all those people not only impracticable, but not really in the individual's best interest. The other one I'm going to throw out there, and I'm just going off of what Stacey Bogart discussed earlier today at the enforcement panel. She made some good comments. She gave some good comments about the Wells process. One thing that, look, you're totally free to say it, but I have found over the years that when counsel comes in, when they write a Wells or they come in for a meeting, and their primary argument is, there's nothing wrong here, nothing to be concerned with, the staff is just crazy. That is not likely to be the case, and therefore it's not likely to be a very effective argument. I mean, it is important when counsel finds flaws in what the staff is proposing, legal or factual, definitely you should point those out. We want to hear those before we make any recommendation to our client, or we certainly will decide to close an investigation without action based on a Wells. But by the point a Wells has been issued, a lot of smart people have been thinking about this. You've got the staff attorney who's been investigating it, often a staff accountant who's been co-investigating this. You've got a first-line supervisor. You've got an associate director. In the regions, you've got the regional director. You've got the regional trial counsel. You've got another trial counsel. I mean, typically, it is not going to be crazy for us to at least propose to you the idea that we think there ought to be an enforcement recommendation. So I would encourage folks to tone down any such heated language in a Wells submission and focus on arguments that are likely to be more compelling.
Thanks, Glenn. Jason, over to you.
Yeah, so I know that, so I'm going to talk about cooperation. And I know that this was something that was covered earlier today as well, but I think it's worth talking about more now. And I suspect some other folks in this panel will talk on issues related to this too, because it really is an important issue in the relationship, if you will, between counsel and staff at the SEC, and can really impact the kind of credibility of the relationship, the tenor of the relationship, and quite frankly, in my mind, impact the efficiencies in the investigation and quite frankly, the costs and time commitment for clients as well. So I'm going to cover it again, including benefits that could come from strong cooperation for your client. And to be clear, by cooperation, I mean more than just doing what a party is legally obligated to do, such as responding in a complete and timely manner to a subpoena, for example, requesting the production of documents. That type of compliance is, of course, super important, but it's also required by law. What I am talking about is active voluntary cooperation beyond things already required by legal process that help efficiently advance the SEC staff's investigation and get to the heart of the important factual and legal questions, which I think we can agree is something that all sides really want to get to, right? Let's get to the heart of one of the key facts and issues and talk about it in an objective, honest way. Such cooperation, I'm just going to give you a few examples of things that I've seen acknowledged in SEC orders in the past where folks have gotten cooperation credit, and also just from my own personal experience. It can take a lot of different forms, but let me give you a few examples. Making substantive presentations to staff on key issues and facts, including potentially making multiple presentations, and being responsive to questions and follow-up from the staff. During such presentations, not just presenting a one-sided picture of the facts, but also dealing objectively with potentially troublesome facts or conduct. I mean, you can rest assured that we're aware of sort of all sides of the picture, right? And so what we really want is an objective presentation and discussion. Potentially sharing findings and or key facts learned during internal or special committee investigations is another example. Facilitating interviews with entity witnesses who might be located abroad. And just one last one I'll flag is like not engaging in a data dump when producing documents, but instead flagging key evidence, both potentially supportive of a violation of the law, but also importantly, potentially supportive of defense as well, right? Our job is to get to the truth and figure out what happened, and that's facilitated by some of this cooperation I'm describing now, including sharing information supporting a defense. There are a lot of benefits that can come out of such affirmative cooperation. One important one is potentially saving money and time for your client. Engaging in the type of cooperation that I just described can potentially lead to quicker completion of investigation. It just depends really, right? It can also potentially lead to more targeted or limited document requests by helping the SEC staff to focus in on the most important issues. If there's an open dialogue and sort of a nice rapport that's been built, including with strong cooperation, that can help the staff work with counsel to figure out key issues or facts to focus on, including with respect to staff requests, which again will save time and money for clients and certainly for the staff too, right? It certainly helps the staff to conserve important resources. And additionally, and I know this was discussed earlier today, but I think that it's important to reiterate, meaningful cooperation can help reduce or even lead to no penalty assessed against your client in certain circumstances. I know that some of my colleagues will touch upon other factors that can contribute to situations where a recommendation might be made to the commission to not assess a penalty or to assess a lower penalty against someone who's otherwise found to have violated the law. But I'm going to briefly talk about cooperation and just go through a couple of examples. If you heard it earlier, I apologize, but again, these are recent examples. I think they're helpful, both to discuss now, but also as a reference point in the future as well. So first, on February 6th of this year, the commission issued a settled order where it found that issuer Kloopen Group Holding Limited, and that's C-L-O-O-P-E-N, Kloopen, committed accounting fraud in violation of Section 10B of the Exchange Act and other securities law provisions. So that's standard-based fraud. The commission order also declined to impose a civil penalty against the company, in part because of its significant cooperation. For your reference in the future, if you're interested, it's paragraph 19 of the order that identifies the specific cooperation steps that the respondent Kloopen took, and that's available on the SEC website. One of them I'll flag now just because, as you can imagine, it was very helpful for the investigation and to just cut to the chase in terms of what the key issues and facts were. Among other things, this is what Kloopen did. They voluntarily identified, translated, and produced key documents related to the misconduct at issue that were originally written in Chinese and that were located abroad in China. And then just one more example I'll flag for you, which again was mentioned earlier today, is a matter called View Inc., V-I-E-W, Inc. It was from July of 2023. And it's just another of a recent example of a public OIP, public SEC order, where a company was not assessed a penalty in part because of its strong cooperation. The bottom line of what I'm trying to say here before I turn it over to the next panelist is that strong cooperation can be a real benefit to your clients, and that's both in terms of saving time and money during an investigation, and also in terms of building good rapport with us, the staff of the SEC, and potentially getting a reduced or no penalty for a violation of securities laws. At the end of the day, we're going to take the steps we need to take to get to the truth and discover the facts that we've discovered. If it takes more time, we're still going to do it. And really exercising that or demonstrating the cooperation I mentioned, I think inures to the benefit of everyone and just cutting to the chase of the key issues.
Thank you, Jason.
Antonia?
Yeah.
This is Glenn. May I interrupt just for a second to sort of second and add to something that, that
please
Jason
do.
has said? So I thoroughly agree with what, all the points about cooperation Jason raised, but I wanted to talk about giving presentations to the staff. I mean, they can be great, and I think they can be very helpful to your client too, in reducing the length of investigations and maybe how many testimonies we have to take, similar to sharing the results of internal investigations. But I would say I want to highlight what Jason said is those presentations do need to be objective. They can't just address those areas of the misconduct or the possible misconduct we're looking at that the client has a good or at least a better explanation for than others. It is important that all of the areas of the misconduct that we're looking at be addressed, and frankly, if there's an area where the client and through counsel needs to acknowledge there were some problems here, that doesn't necessarily mean you're throwing your client to the wolves and we're going to bring a case, because that's also an opportunity to tell us how the client has addressed those problems and what's changed going forward. But a presentation that does explain some things but leaves others unaddressed is certainly going to be, at best, less helpful than a fulsome presentation. Thank you.
Thank you, Glenn. Kay, if I could turn it over to you with some advice or on tips or practice pointers.
Thank you. So I'd just like to discuss the importance of cooperating with exam staff for those regulated entities who are subject to the SEC's examination authority. As I'm sure everyone knows, a number of our cases result from exam referrals. And so it's really important that you cooperate with the exam staff. I would suggest that if you are contacted by exams, you should be cooperative, be responsive, and do whatever you need to do to figure out whether you have any problems, deficiencies, or violations with regard to the conduct that exams is seeking information about. Providing the exam staff with timely, complete, and accurate information about your conduct can be very helpful. And you should also self-report anything that you have identified. If you identify a problem, you should promptly communicate with the exam staff about it, and you should talk with them about taking early remedial action, including retaining a consultant or a compliance consultant if it's appropriate. These types of actions can make it less likely, depending on the circumstances, including the nature and the length of the conduct, that there will be an enforcement referral in the first place, or that there'll be a subsequent action. And it's a big red flag if you're being the subject of an exam and you're refusing to produce information and you're not complying. If you take that tack, that may result in a referral to enforcement sooner rather than later. So I think it's important to think about, again, many of our cases arise out of exam referrals, and it's very important that you comply with the exam staff, not only because you're subject to their regulatory authority, but it may be beneficial to you in terms of whether or not there's a future enforcement action.
Thank you, Kay. Tejal, turning it over to you for tips and pointers.
Thank you. So first, to round out the discussion about cooperation, I'd like to touch on the importance of self-reporting. As Sanjay Wadhwa said this morning, self-reporting can be the most significant factor in moving the needle on penalties. So since I talked about sweeps earlier, I'll come back to that. As I said, sweeps are a way we hope to influence industry-wide behavior. Firms that see we filed a sweep concerning a particular type of violation should take a hard look at their own practices. If they do determine that they're violating the same provision at issue in the sweep, they could choose to sit tight and hope that we in the Enforcement Division never learn of their violation. However, that is a risky approach. A firm could position themselves better by self-reporting. For example, Perella Weinberg self-reported their off-channel communications in connection with the off-channel sweep. In turn, they paid a penalty significantly lower than other comparably sized firms for the same violations. So while self-reporting and other forms of cooperation are most often recognized by lower penalty amounts, I do also want to stress that there are times where they get recognized by the Commission deciding not to bring an action at all. However, since our investigations are non-public, there is just no way for us to highlight those instances. But they do exist, and firms can best position themselves to make the argument that an action is not warranted if they come to us by self-reporting before we come to them. So I just wanted to turn briefly to another topic before I turn it back over to you, Antonia, which is the difference between asserting reliance on counsel versus presence of counsel. And this is just a general practice pointer. So oftentimes what happens in investigations is counsel will make representations to the staff regarding their client's good faith or lack of scienter by referring to the fact that their client consulted with counsel in connection with the conduct at issue. However, they try to straddle the line between referring to that but not waiving privilege and giving us the benefit of those communications. As we all know, an attorney's legal advice is only as good as the information they're given by their client upon which they're basing their advice. So in order for us to credit a reliance on counsel defense or assertion, the client must waive privilege so that we have the benefit of reviewing the entire communications.
Thank you, Tejal. So it turns out we have a few more minutes left in this panel, and we've covered what we set out to cover. So I thought I would mention some somewhat recent cases that New York has brought along with, in the startup area. Jason already talked about some of those initiatives that have been pursued in the out of the San Francisco regional office. In the New York regional office, we too have brought a number of cases in that area. And one such example was a case against Charlize Javis that was initiated last year in April of 2023. The SEC filed a case against Charlize Javis, the founder and a former CEO of a company called Frank, which was a student loan assistance company headquartered in New York. The allegations of fraud included selling Frank, the company, by the founder to JP Morgan Chase in 2021 for $175 million. Javis and her company Frank allegedly claimed to have access to valuable data related to 4.25 million student users of Frank's services. In reality, the number was less than 300,000. Javis allegedly paid a data science professor to manufacture user data required to close the deal with JP Morgan Chase. This was after she allegedly asked an internal Frank engineering director to help her create, quote, synthetic data, end quote, of users' existence and identifying information. And that internal engineering director declined. The SEC's complaint alleges that Javis tried to assuage the engineering director's concerns about the legality of creating this synthetic data by stating, quote, no one would end up in orange jumpsuits. So whenever you're mentioning orange jumpsuits, you know things have gone terribly wrong. The SEC filed charges under Section 10B and 17A, and there was a parallel civil case filed in the, parallel criminal case filed in the Southern District of New York. So I don't think we have any questions in the chat. So I'm going to hand it over to PLI to see if they have any other questions for us.
Hey, Antonia, this is Jason. I'm inspired by your last example there, and just one more example to highlight, because I did want to make the point that it's obviously not just the San Francisco office that works on these private startup actions. These actions are brought or investigated by offices across the country at the SEC. wherever these issuers are located, wherever the investor is located. So in addition to highlighting the Charlie Javice case you just mentioned, which I think is a really significant one from last year, I did want to mention one more example just because it gives you a sense of the sort of color that you get in these types of cases. So in February of 2023, another example I want to give was a case that the SEC brought, which is SEC versus Aussie Media, as well as against two of its executives, Carlos Watson and Samir Rao. Aussie was a media and entertainment company that had produced daily news digest emails, TV programming, podcasts, live events, and its headquarters were in Mountain View, California. So they were a Silicon Valley tech company. The allegation was that there was a $50 million offering fraud, and the parties were also criminally charged by the U.S. Attorney's Office for the Eastern District of New York. The SEC's complaint alleges that from at least January 2019 through September 2021, the defendants presented prospective investors with false financial statements that grossly inflated Aussie's annual revenue by at least 100%. And again, this goes back to the point I mentioned earlier, where this seems to be a common theme amongst private startup fraud, where you have this manipulation, often very egregious, of financial figures and financial numbers, facilitated in part by the lack of internal controls or adequate internal controls, as well as the very dominant control, like either complete control, as I said, or near complete control of the issuer by a particular founder or executive. And you can only imagine in a public company sort of the lack of parallels there, or potentially absent very extreme circumstances, a lack of parallels, right? Certainly nothing I would say 100% on point. So the SEC's complaint also alleges that Watson and Samir Rao, who was its chief operating officer of the company, solicited investments by falsely telling investors that other well-known and sophisticated investors would be investing in Aussie. As one example of their fraudulent conduct, the complaint alleges that former CEO Watson and Rao orchestrated a scheme to mislead a prospective investor by impersonating an executive from YouTube during a call. This involved lies regarding Aussie supposedly receiving licensing revenues from YouTube when it was not. After the investor found out that, in fact, there was not a real representative from YouTube on the call, Watson allegedly attributed Rao's impersonation of the YouTube representative to Rao suffering from a, quote, mental health crisis. So I kind of flag these more as sort of like colorful examples of the type of extreme fraud that we often see in the private startup space. It's not every case that happens, but it does happen. And again, it goes back to some of these underlying factors that I mentioned earlier, where there's just these conditions that seem to be conducive or create environments where pretty egregious financial fraud can happen in the startup space. That maybe those factors might not exist with the governance of public companies, potentially still can. But given the significance of the private startup space, I think that's why we're focused on it, right? Because there are these factors that contribute to potential fraud there. So just throwing that extra example out there.
Thank you, Jason. Yes, and often in the startup space, there is a lot of eagerness and willingness to invest in new ideas, and that can sometimes enable promoters to deceive in ways that are new and creative, from very deceiving both retail investors, sophisticated institutional investors, and others across the spectrum. So I think we have 1 minute left in the panel. Does anybody have any last words before I hand it back to our PLI sponsors? And I want to thank PLI for hosting us this afternoon and for hosting the SEC Speaks over the last 2 days. But any final words, anyone? No? I think that's a wrap for the SEC today.
Thank you, Antonia, and thank you to the Enforcement Workshop. We really appreciate you joining us this year. Thank you all who joined us either in person or on the web or via the live stream. Thank you as well to the two co-chairs from the SEC, Gurbir Grewal and Eric Girding, as well as all of the staff and speakers who joined us over the last 2 days. It really meant a lot. Have a good year, and we hope to see you next year.